Okay, and the clock has struck 9. So, calling to order this morning's evidentiary hearing for docket number 2019-0117. Good morning, I'm Jay Griffin, the chair of the Hawaii Public Utilities Commission, and also in attendance here for our virtual hearing are Commissioner Jennifer Potter, Commissioner Leo Asuncion. This is an evidentiary hearing for Public Utilities Commission docket number 2019-0117 related to Young Brothers' request for temporary emergency rate relief filed on July 7th, 2020. This is not a public hearing. The Commission is here to receive evidence from the parties to this docket and will issue written decisions shortly following this hearing. I do want to briefly introduce our staff, joined here with Chief Counsel Carolina Shida, Chief of Policy and Research Dave Parsons, Dave Takashima, and Elsie Lee are from our IT department, Supervising Attorney Mark Kayatu, and our Chief Clerk Eleanor Tuyasa Sopo. This is our first virtual evidentiary hearing that the Commission has conducted since moving to all electronic procedures in March 2020. In preparation, the Commission has provided an overview of WebEx at the pre-hearing conference on August 13th, 2020, and also provide additional trial opportunities with Young Brothers on August 11th, and again, second time again in August 13th. We appreciate everyone's cooperation and understanding as we develop procedures to accommodate the virtual nature of this forum. We're recording the hearing for later transcription by a court reporter. It is critical that the court reporter doing the transcription can clearly hear what each party is saying to ensure that the hearing is transcribed accurately. Disruptions which interfere with the party's ability to take testimony or interfere with the court reporter later will not be tolerated. A party shall make the necessary arrangements directly with the court reporter to obtain their own copy of the evidentiary hearing transcript if they would like a copy. In addition, the Commission will have a copy of the original transcript when filed, available for public review upon request. The Commission will upload a copy of the original transcript onto our document management system following the issuance of its order addressing YB's motion for leave and for emergency and temporary rate relief. In addition, we are live streaming this hearing via YouTube, similar to the live streaming that the Commission has used for our July 10, 2020 status conferences regarding Young Brothers' financial condition. The link for the live stream was provided in a notice letter that was posted in this docket and on our website. As noted in the Commission's pre-hearing conference order filed on August 13th, the provisions set forth in this pre-hearing conference order shall govern the evidentiary hearing. Now, can we please have appearances for the party's representatives, beginning with Young Brothers?
Thank you, Chair. Jeff Ono and David Nakashima appearing on behalf of Young Brothers. Also with us are Mr. Jay Anna, president of the company, Chris Edwards, Chris Martin, consultants Mike Starkey and Cheryl Kikuta. Did I miss anybody? I think I got everybody. Thank you, Chair.
Thank you, Mr. Ono. And now the Consumer Advocate's Office.
Good morning, Mr. Chair. Lane Tsuchiyama and Edward Knox appearing on behalf of the Division of Consumer Advocacy. Along with us are the Executive Director of the Division, Dean Nishina, and our consultant, Mr. Michael Brosh.
Thank you, Mr. Tsuchiyama. As noted in our pre-hearing conference order, there'll be no opening statements by the parties. In addition, as we noted, the parties will have an opportunity to conduct a brief up to 15-minute direct examination of each of the witnesses. As we just discussed previously, we will be timing that, and Dave Parsons will be sending you the warnings at 5 minutes and 1 minute. Commission does not intend to close any portion of this hearing unless pursuant to Oahu Publications Incorporated versus ON. The closure serves a compelling interest. There's a substantial probability that in the absence of closure, this compelling interest would be harmed, and there are no alternatives that would adequately protect the compelling interest. Just a few housekeeping matters here. We did 2 WebEx trials yesterday, the pre-hearing conference, to ensure that counsel witnesses are familiar with the WebEx platform and as we discuss what to do if any technical issues arise during the hearing. All of you should have copies of the procedures for addressing technical difficulties at the hearing document that was sent to you, which provide instructions if we run into any problems. From time to time, I may call brief recesses or conferences with counsel up at the bench, which in these circumstances, we'll step away from the WebEx, and those discussions will be held via phone through Microsoft Teams. Your counsel should have received the contact information for this. Again, we would prefer to keep everything out in public in the open here. We'll be taking breaks during the proceeding at the discretion of the presiding officer, as we need periodic breaks, as well as a 1 hour break for lunch between approximately noon and 1 o'clock. We'll see where we stand in the procession of witnesses at that point, or exactly when we call it. And finally, the commission expresses strong preference that the hearings concluded today. The hearing's scheduled to adjourn at 4:30, but if we need to stay longer, we're prepared to do so. Reminder to witnesses, please speak slowly and clearly, and please respond to questions verbally so that the recording can capture your response. For both witnesses and counsel, please avoid talking over or interrupting each other so that each person's questions or statements can be clearly heard by the commissioners, commission staff, and the recording. Reminder to counsel, given the virtual nature of the evidentiary hearing, the parties do not need to provide hard copies of the hearing exhibits to the commission or to each other at the evidentiary hearing. An examining party will identify an exhibit they're using to question a witness by the title of the exhibit and the date it was filed on the commission's document management system, so that the commission, the non-examining party, can refer to the exhibit using their own materials. While examining a witness about an exhibit, the examining party should allow for a short amount of time before beginning questioning for the other party to locate the respective copy. And to accommodate the virtual nature, the examining party may use the screen share function to show an exhibit, which we tested out yesterday. However, as noted above, this does not apply to the exhibits reflecting new information which has not been previously produced by the other party, or to the other party. In the event a party attempts to offer into evidence a document that has not been previously disclosed to the commission or the other party, the admittance of said document shall be subject to the prevent manifest injustice standard set forth in HAR 16-601-37B. As noted in the pre-hearing conference order, the opportunity for redirect examination recross shall be requested orally during the hearing and is subject to presiding officer's discretion. Presiding officer will rule on such requests at the time. I'll briefly restate the issue before we begin with direct examination of Young Brothers' first witness. The issue before us today is whether Young Brothers has demonstrated probable entitlement and financial need to authorize a temporary increase in its rates, fares, and charges as requested in its rate increase application. We'll now start with the first witness from Young Brothers. Will Jeremiah Anna please stand and identify himself before I proceed with administering the oath? Mr. Anna, I think you got to turn the video on. Apparently sounds like they may be having technical difficulties at their office, is what we were. Is that the case, Dave?
That's correct.
Okay, our backup on this. How about we take a brief recess? We'll see if we can clear this up and within 5 minutes, and if not, we'll proceed to the next available witness. Hi, just given that Mr. Anna is the lead witness, we're trying to give an opportunity for him to start out. Apparently, we understand they're trying to call in by phone. Is that correct, Mr. Ono?
Yeah, yes, that's my understanding. They're trying to call into the bridge.
Okay, we'll give it a little more time. Otherwise, we're going to have to move Mr. Martin's the next witness in the order, but we would prefer to start with Mr. Anna, but we got to keep the timeline moving.
I understand.
Is that Mr. Anna on the phone?
This is Cheryl.
Hey, Jeff, this is Chris Edwards. I'm on the phone. I think Cheryl's on the phone. We're trying to grab the others real quick. I apologize to everybody for the delay.
Okay, that's as much time as we can take here. Is Mr. Anna on? Okay. Ms. Kikuta is the next one up in the order. We heard you on the phone. Are you still online?
Yes, I am.
Okay. We're going to proceed forward with Ms. Kikuta as the second witness. Everyone, I'm looking at everyone following along. Okay. We're going to call the hearing back to order and proceed. Calling our hearing back to order, and we will proceed with witness number 2 from Young Brothers, Cheryl Kikuta. Can you please stand and identify yourself before I proceed with administering the oath?
My name is Cheryl Kikuta.
Okay. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. We will begin with the direct examination of the witness.
Thank you, Chair. Good morning, Ms. Kikuta. Could you again state your name for the record as well as your occupation?
My name is Cheryl Kikuta, and I'm currently a regulatory rate making consultant.
Could you briefly describe your professional and educational background?
I received my degree in business administration with a major in accounting from the University of Hawaii. Upon graduation, I was employed by the public accounting firm, which is now known as Grant Thornton, as an auditor. After Grant Thornton, I worked for approximately 30 years at the Division of Consumer Advocacy until I retired at the end of 2008 as the Utilities Administrator. During my career at the division, I worked on a number of rate cases and other regulatory matters. In that capacity, I've prepared statements of position and written testimony and testified in evidentiary hearing on regulatory matters which pertain to certification, financing applications, asset sales, and general rate increases. Since retiring in 2008, I've on occasion worked as a local consultant to assist companies in various regulatory and rate-making matters.
And what has YB retained you to do here?
In May, I was asked to assist YB in supporting the company's request for rate relief, particularly the motion for temporary rate relief and the reply to the consumer advocate's response to YB's motion for temporary rate relief. My role was to provide the regulatory perspective of the underlying reasons for YB's need for rate relief and to rebut the consumer advocate's position that the temporary request should be based on a revenue requirement that removes depreciation on the premise that depreciation is not an operating expense that requires an immediate outlay of cash, and to consider temporary cost savings measures.
In order to perform these services, did you have to review any materials?
Yes, I reviewed the record in the pending general rate case docket number 2019-0117, as well as the Commission's investigative docket number 2020-0084, and the non-docketed filings associated with the adjusted saline schedule to obtain a general broad understanding of the underlying reason for YB's need for rate relief and the underlying support for YB's request.
What will you be testifying on today?
My testimony will focus on the proper analysis for determining the amount that YB is probably entitled to for purposes of a temporary rate increase. Specifically, I will testify why the Commission needs to use a revenue requirement analysis and not a cash flow analysis in reviewing this motion for temporary rate increase.
Why is the consumer advocate's cash flow analysis and proposal to exclude depreciation as an operating expense inappropriate for determining the amount of the temporary rate increase?
In essence, the temporary rate increase is that portion of the permanent rate increase to which the utility, in this case YB, is probably entitled to receive. As a result, the determination of the amount to which YB is probably entitled should be based on the revenue requirement formula, consistent with how one determines the permanent rate increase. Excluding depreciation expense is not consistent with the revenue requirement formula. The other thing to remember is that pursuant to HRS 271G17(e), the amount to be awarded in the temporary rate increase is based on probable entitlement and financial need. It's, in essence, an emergency relief based on, once you determine probable entitlement, it's based on financial need. Thus, it's not based on a cash flow analysis. In determining financial needs, the Commission has previously cited to the decision of a Michigan Public Service Commission, which ruled that to warrant a temporary rate increase, one must have a showing of reasonable certainty that the utility is currently experiencing a revenue deficiency and of the existence of at least one of the following conditions. One, the inability to arrange debt financing at reasonable rates without improved revenues. Two, distinctive and sudden decline in revenues. Three, evidence of unreasonable and harmful loss of revenues if partial rate relief is deferred. And four, reasonable grounds to believe that denial of such interim relief would cause irreparable harm to the utility. The factors to be considered all focus on the present rates and associated revenues. Thus, it is clear that the determination of financial need considers the losses that have been incurred and or are projected to be incurred for the test year at present rates, the purpose of reviewing a result of operations. A cash flow analysis, while not appropriate for rate-making purposes, may be used when determining the need for financing and the amount of such financing, similar to the financial assistance YB sought from the government.
Ms. Kikuta, why is it inappropriate to consider temporary cost-saving measures when determining the revenue requirement, or in this case, request for a temporary rate relief?
In essence, rate making is prospective in nature, and the test year revenue requirement must be normalized to reflect conditions that are expected to exist during the period that the rates remain in effect. The temporary cost-saving measures are short-term, and while the measures are being incurred in the 2020 test year, the measures are not expected to reflect the ongoing normal operating expenses. This situation is similar to where there's an expense that is only expected to be incurred in the test year. The expense is often removed from consideration when determining the test year operating expense because it is not representative of the normal ongoing operations for rate setting purposes.
Ms. Kikuta, would you like to add anything else for the record?
Not at this time.
Thank you. Chair, this concludes the direct examination.
Thank you. Now we'll start with the cross-examination by the consumer advocate.
The cross-examination for Ms. Kikuta will be handled by myself. For the consumer advocate, it's Lane Tsuchiyama. So, hi, Ms. Kikuta. How has life been since you retired from state service in 2008?
Very good. Thank you.
So I believe that you mentioned you were employed with the Division of Consumer Advocacy, right?
Yes, I was.
And in the course of your employment there, you're familiar with what the consumer advocate does, and you've participated in a number of proceedings before the commission yourself on behalf of the consumer advocate, right?
Yes, that's correct.
And you've been a part of the consumer advocate's application of regulatory principles in representing the interests of consumers as that responsibility is I guess is laid out in HRS chapters 269 and 271G, for example.
Yes.
And you're familiar with many of the determinations and decisions and orders reached by the commission in the past?
Yes.
And in fact, you've been part of developing the record that these determinations have been based on as part of the consumer advocate's role in the regulatory process, and many times in a senior or supervisory role, right?
Yes.
And you're familiar with the work of Mr. Michael Brosh and Dean Machina, who are testifying later today for the consumer advocate?
Yes, I am.
And Mr. Brosh and his firm Utilitech did work for the consumer advocate while you were previously working there.
Yes, sir. Yes, that's correct.
And so you're familiar with the work of Mr. Michael Brosh then?
Yes, I am.
So the consumer advocate has read YB's motion, the rate design supplement, and the reply to the consumer advocate's responses that YB filed in the docket for the purpose of handling and addressing these matters in the reopened proceeding by the commission. So you're familiar, I believe you said you reviewed the materials in docket number 2019-0117, which is this current rate case docket, 2020-0084, which is, I believe, the emergency proceeding that the commission opened to investigate YB's financial situation, and also the tariff transmittal, I believe that's 20-00003. Is there
Yes,
anything?
to get a general.
Is there anything else that you reviewed as well, or is that pretty much it?
I looked at the orders that were cited by the consumer advocate in its response to YB's motion. I also took a look at the prior testimonies that were submitted in the last two rate cases that YB had.
Okay. And did you have any part in drafting any of those documents with respect to Y Brothers' current either motion, what I'm going to be calling the rate design supplement, which is the supplemental filing that I believe Young Brothers filed on July 13th or so, or it might have been the 17th, 2020, and the reply to the consumer advocate's response. Did you have any part in drafting any of those documents?
Wait, can you repeat the question? It was a long question and I'm losing track of exactly which documents you're referring to.
Okay, so YB's motion in this particular proceeding, the motion for emergency or temporary rate relief, YB's rate design supplement, and the reply to the consumer advocate's response. Did you have a part in drafting any of those documents?
I had a part in drafting the motion and YB's response. I did not have a part in drafting the rate design aspect.
So in the reply, there are a lot of references to the term generally accepted regulatory and rate-making principles. Are you familiar with those statements as they appear in Young Brothers' motion? But I think that phrasing altogether, meaning generally accepted regulatory and rate-making principles, primarily appears in the reply. Are you familiar with those statements?
Yes.
If you know, who was the person primarily responsible for presenting that concept in YB's filings? Because unless I missed it, the motion did not have those topics expressed explicitly or too heavily, but it does appear more frequently in the reply. Do you happen to know who was responsible for including that in the reply or explaining that in the motion?
I had a significant part in that, and it was because it was intended to explain why the CA's proposal to exclude depreciation on the basis that depreciation expense does not require an immediate outlay of cash is not appropriate when determining the temporary rate increase, and the consumer advocate's proposal to consider all temporary cost savings in reducing YB's temporary request for temporary rate relief.
Okay, so I believe that you mentioned that you were retained or engaged by Young Brothers in the month of May 2020. Was that before or after Young Brothers filed or issued a letter to the commission right around the end of May? I believe it's May 26, 2020, indicating that Young Brothers had a cash flow problem?
I was officially on contract after, but I was aware of the filing and I was aware of the situation, yes.
So you were aware, or you are aware, that Young Brothers had communicated at least to the commission and the consumer advocate that they were facing a liquidity problem in the sense of not, as far as I understand and interpret it, not having enough money to pay its bills on a timely basis going forward?
I was aware of that, yes.
So just that I understand the proceeding here properly, and I guess to position it properly for the commission's consideration, YB through its motion is asking the commission to set temporary rates and grant a temporary rate increase, as that option is available to Young Brothers under HRS section 271G-1 17 subsection E, and that's through the motion, correct?
Can you cite that section again?
271G-17 subsection E.
Yes, that's correct.
And having been at the Consumer Advocate for a long part of your career, is there a difference between setting temporary rates as opposed to any other kind of rate, maybe such as a interim rate in a rate case, as far as those concepts are understood by the commission?
I believe that there should be no difference. It is, as I stated in my oral presentation, the temporary or interim rate increase is based on probable entitlement. And as it's stated here in 271G17 subsection E, it is that amount to which YB is probably entitled on an emergency basis during the deliberation of the request for permanent rate increase. As a result, it should be based on the rate making formula, because this is all intended to provide YB with rates that will be compensatory.
So what you're saying, I guess, and I don't want to, so let me see if I got what you're saying correctly, is that the granting of a temporary rate increase and the issuance of an interim rate decision or granting an interim rate increase, those are not different things as far as the commission's application of those two terms are concerned. They should be considered one and the same thing.
It is one and the same thing. However, the amounts awarded under the temporary rate increase may not necessarily be equivalent to the amount that the company is asking for in the permanent rate request. And the reason is because under the temporary rate increase, one is determining the amount to which they are probably entitled. So when there is a dispute on a particular revenue requirement item, the commission may choose the more conservative, if it's operating expense item, the more conservative recommendation, because that would be the amount, the minimum amount to which the utility is probably entitled. And if you read the section, it says when a rate increase application is filed, and then it goes on to say, upon a showing by a water carrier of probable entitlement and financial need, authorize temporary rate increases in rates, fares, and charges.
What if the consumer advocate had not provided any countervailing or, investigative testimony pointing out or highlighting or discussing any of the recommendations proposed by the company in the record? What would the commission do then in that state of the record in terms of determining probable entitlement?
If the consumer advocate did not submit its own proposal, then the commission could, on its own accord, make a determination, or which may be different from what the utility requests, but based on the record before the commission, the company's request would be the one that the commission would need to look at. And that's why I think if the consumer advocate had significant concerns with the company's request, then the consumer advocate would have submitted specific concerns and proposed adjustments to reduce the request that was offered or suggested by the utility. The only document that we saw proposing the consumer advocate's recommendation in terms of the dollar amounts was the one which said remove depreciation expense and consider all temporary cost reductions. And YB is saying that is not appropriate for purposes of determining rates, fares, and charges.
And so let me ask you, in your role or position as YB's consultant on this matter, did the letter that YB filed with the commission in and around the end of May, and for this purpose, I think I believe that letter is, let's see here. That letter is, I believe, either May 26, 2020 or May 29, 2020. If Young Brothers issued or submitted those letters to the commission indicating that there are substantial financial problems or challenges that Young Brothers faces, such that Young Brothers believes that there's, issues or matters that need to be addressed by the consumer advocate and the commission immediately, would that change the situation in terms of how the docket would be understood and at least approached by the consumer advocate, if not the commission?
I believe the answer is no. And the reason is that YB's situation has been brought about because the present rates that are being charged and the current projected cargo tonnage that YB transports results in insufficient revenues to recover YB's normal operating costs. As a result, the rates are non-compensatory and do not provide the funds that are necessary to allow YB to pay for its normal operating costs. So the situation in the letters is a result of the rates being non-compensatory. And that is the key, the compensatory rate or non-compensatory rate. Thus, YB's application for general rate increase, and right now its request for emergency temporary rate increase, brought about by the sudden reduction in operating revenues caused by the sudden decrease in tonnage that is now being transported as a result of the downturn in the state's economy due to this COVID pandemic.
So those letters that were submitted to the commission towards the end of May, those are, I guess I would characterize it, and then you're free to disagree with the characterization, as confirmatory letters indicating that YB has financial trouble, but that the commission and or the consumer advocate was not to take any other significant note of that. I guess any of the paragraphs within it was not there to raise any kind of concerns or issues or things that required immediate attention, meaning immediate in the sense of the next couple weeks to a month, rather than something of a little bit longer term, meaning on the order of a couple months to at least the end of August or beginning of September of this year, at least at that time in May. So they were not supposed to take any notice of anything else other than the fact that it's just confirming that Young Brothers has the matters that were brought to the consumer advocates and commission's attention in the application.
Objection, Chair. It's not clear what the question is, and I submit that if the question is intended to determine what the intent of that May 26 letter is better served to be asked or posed to a YB official.
Yeah, Mr. Suchiyama, can you restate the question?
Okay. Yes. Just one more. Because I'm a little confused as to Ms. Kikuta saying that the letter is just a letter rather than a letter raising a significant or serious issue that the commission needs to deal with. Because I guess that's my question. Are you saying that it's just a normal letter informing them of informational matters, or is it a letter designed or intended, I guess I won't say intended, but designed to raise some kind of concern for immediate commission action? Because the way that I'm interpreting or understanding what you're saying is that it's just a letter. So are you saying it's just a letter telling the commission X, Y, and Z happened, or is it intended to get the commission to do something on an emergency or immediate basis?
Mr. Chair, same objection. I think Ms. Kikuta testified that she was formally retained after that letter was issued, so I don't think she has personal knowledge of again what that letter was intended for. If Mr. Suchiyama is asking for Ms. Kikuta's expert opinion on what that letter means, that's one thing, but I believe Mr. Suchiyama is asking why that letter was sent.
I believe Mr. Nakashima is correct. I think that I think the question, I mean, if there's specific questions about the letter and the drafting, it should be directed at the sponsoring witness. But if you have some question about the content.
Okay, no, fair enough. But I just want to highlight then one. Well, you know what? I guess that's a question better left for Young Brothers employees, the witnesses that are Young Brothers employees in this matter. So I'll move on. Now, with respect to Young Brothers' reply on page 19 of the document. So if you can turn to page 19, I'm going to read from what is under point number
Excuse me, is it a hearing exhibit? Is it
The
a hearing
reply?
exhibit?
No, it's Young Brothers' reply. The exhibit A, the reply, the actual reply to Young Brothers. Young Brothers' reply to the consumer advocate's response.
Mr. Suchiyama, can you state the date for the record? The filing date?
Filing date, I believe, was July 31, 2020.
Okay. Thank you.
So I'm going to just read from the section that is on my copy that is under point number 3, which says regulatory principles governing the determination of the revenue requirement, and under sub point E, which says the revenue requirement must be reflective of the normal ongoing operating conditions of the period that rates are to remain in effect, period. I'm going to start at that paragraph. It says, it
Can
is
you give me
also
a page number?
page 19.
Okay, hold on, I'm trying to get there. Okay.
So at the start of that paragraph, it says, it is also well-established regulatory and rate-making principle that test year data is restated to the extent necessary, and in parentheses, or permitted, close parentheses, to produce data that is considered to be reflective of conditions during the period that rates are to be in effect. In other words, the revenue requirement is based on data that reflects the normal ongoing operations of the utility because rates are set based on what will be reflective of the utility's financial operations in the future. I've omitted the footnotes there, but is that statement recited correctly?
I believe it is.
Is this part of the generally accepted regulatory and rate-making principles you're referencing earlier?
Yes, it is.
You agree with that statement?
Yes.
So concerning the conditions during the period that rates are to be in effect, what is that period supposed to be here for purposes of determining the temporary rates to be approved by the commission in this instance? In other words, what is the period that these temporary rates are supposed to be in effect?
As we responded to in response to CAIR 373, I believe that it's speculative to anticipate what is the specific period during which the proposed emergency or temporary rate will be in effect, because the period is subject to the commission's discretion and the timing of the final decision. But as I explained earlier, and as stated in HRS 271G 17 subsection E, the temporary rates are that portion of the permanent rate increase to which the utility is probably entitled to receive on an emergency basis because of financial need. So in essence, when you set the temporary rate, you apply the same principles that you would when you set the permanent rate increase. The difference is in amounts would be consideration of differing recommendations on specific revenue requirement elements. For example, if the temporary rate increase included a return on rate base and there were differing recommendations on the return on rate base, what the return on rate base should be, for temporary rate increase purposes, one may go with the lower amount because that would be the most conservative, and that's the minimum to which the utility is probably entitled based on the information in the record at that point in time. So you don't apply the principles in determining the temporary rate increase on the basis of the period in which the temporary rate increase remains in effect. It's based on the period of the permanent rate increase. And again, that's speculative.
And I believe you mentioned, differing recommendations, but at this point in the record, as it stands right now, there are no differing recommendations, right? Because there's only YB's proposal or recommendations in the record to be reviewed to or referenced to, right?
That is not correct, because the consumer advocate has proposed an alternate recommendation for purposes of temporary rate relief, and that alternate recommendation removes consideration of depreciation expense and removes all of the temporary cost measures that have been implemented in 2020 to address YB's financial situation, pending the outcome of YB's general rate increase application. So that is a recommendation before the commission that the consumer advocate is offering.
Okay, I think I understand. But another question that I have then, because it also says that with respect to YB's normal and ongoing operations, which are supposed to be reflective of the financial operations going into the future, is that concept supposed to encompass YB's reduced sailing schedule as presently approved by the commission on a temporary basis, as applied to determining these temporary rates to be approved by the commission in this docket, or is it supposed to be based on a full sailing schedule?
As we explained in the motion in that schedule. I think it was Exhibit B, Attachment 2, where YB provided the list of adjustments that they were making for purposes of temporary relief. The state cost reductions associated with the modified saline schedule that was approved on a temporary basis for transmittal number 20 I'm sorry, I can't remember exactly the transmittal, but those are temporary measures because the commission has not approved the modified saline schedule on a more permanent basis. They've approved it on short-term intervals. YB has a request before the commission asking to extend that saline schedule. We've also explained in the reply to the CA's response that because there is no certainty that the modified saline schedule will be approved on a more permanent basis, YB must include operating costs on the assumption that YB will be asked to return to the pre-transmittal saline schedule. If YB doesn't do that, then and YB is ordered to return to the pre-transmittal saline schedule, then YB will not have sufficient operating expenses embedded in the permanent rates that are set in this proceeding. YB has stated that, and even in, I think, the recent alternate proposals that were submitted in response to the commission's request, that if the commission approves the continuation of this modified saline schedule on a more long-term basis, or at least until the cargo volumes resume to a level that justifies the return to the quote full saline schedule, YB will then remove the approximately $9 million of cost savings from its temporary increase. Again, it's all tied to how long they are allowed to continue the modified saline schedule. And if it's only going to be for periods of 30 days or 60 days, YB has to make sure that they have enough operating costs embedded in the development of the rates from this proceeding to pay for the full cost of going back to the full saline schedule.
Okay, so I guess
I'm sorry, Mr. Sutia, we're trying to be mindful of the time here. How many more questions do you have for this witness?
not too many, maybe just a few more sections.
Okay, understood. Thank you.
So I just to wrap this, I guess this section up in a bow. Then why does YB have to elect one of the two options, meaning temporary saline schedule going forward into the indefinite future, or resume full sailing schedule for the commission to determine what the temporary rate is? Do they have to elect one or the other?
When you say do they have to elect, they are basing their request on the understanding that until they get approval from the commission to continue the modified saline schedule on a more permanent long-term basis, they have to assume that they will be required to resume to the full sailing schedule. And as a result, must make sure that they have embedded in the revenue requirement the cost of resuming to the full sailing schedule. It's not a matter of them electing. It's a matter of what they are allowed to do on a more permanent basis, and then ensuring that the revenue requirement includes the cost of that recommendation or mandate from the commission.
Okay, so and this is a related question that goes to the same type of issue, which is with respect to cargo volume, for example. is it the testimony of Young Brothers that the normal ongoing operations for Young Brothers in terms of cargo volumes is the number that they record today, meaning in the COVID environment, as reflective of what is to be their financial operations going into the future? Is that what the commission is supposed to use for determining the temporary rates in this docket?
If the economists that are supporting the forecast are saying that the current COVID situation and impact on the cargo volumes is going to be reflective of the future, at least for an extended period of time, then yes. If on the other hand, they say, oh, this is only a 2-month or 3-month or 6-month, for example, impact, then my answer may change. But I believe that the economists are predicting that this situation is going to be with us for quite some time. On that basis, it is appropriate for YB to reflect the cargo tonnage based on conditions that are expected to remain in effect, i.e. the reduced cargo tonnage because of the impacts of the pandemic on the state's economy. We can't ignore that.
So if the cargo volumes were to go up any point in time in the near or foreseeable future, that would make a difference in terms of determining what the temporary rate increase should be?
Can you repeat that question again?
So if the cargo volumes were to go up at some point in time in the near or foreseeable future, would that make a difference in terms of what that temporary rate increase that should be granted, if any, from the commission?
If it went up in the near future, and when I say near, I'm talking about less than a year, then I believe that we would, or YB would look at the situation a little differently. However, I don't believe that that's what is being anticipated. And I also have been informed that when they did the forecast that's being reflected in the temporary rate increase, there was assumptions that are no longer valid because of the further delays that the state is facing. And so even now, the cargo tonnage in the temporary rate increase is overstated from what YB expects to transport going forward.
So if, from what I've gathered from your testimony, and I don't think anybody would dispute this, that it is a dynamic and fluid situation, but if the information that's submitted to the commission and the consumer advocate through the record keeps changing, or there's differences that keep appearing in the record, does that make it difficult for the consumer advocate to determine what the recommendation is for the commission to consider in investigating or reviewing Young Brothers' application in the docket?
No, I disagree, because when we set rates, we're not trying to be precise. As I've stated in testimony on behalf of the consumer, in my testimony on behalf of the consumer advocate, rate making isn't an exact science. It is a means of looking at data to determine the relationship of revenues to expenses to investment in plant that's used and useful to provide the service. It's looking at reasonableness. So there are assumptions that are made. At some point, I think nobody will know with absolute certainty what's going to happen going forward. But you make assumptions and you do the best you can with the information you have before you to determine reasonable rates. And that's why it says reasonable rates. I believe that the impact on revenues and the cargo tonnage is a reality. And to say, well, we can't do anything because we don't know for sure is not the right answer. You have to make some assumptions and do the best you can to anticipate what that tonnage will be on a normal ongoing basis. That's the bottom of what you do, the foundation of how you project for rate making purposes.
I guess then this would be the last question. If new information is indeed filed in the record, would you expect the consumer advocate and or the commission to take note of that and to incorporate and fold it into their analysis and review of whatever is proposed so far?
Can you clarify what you mean by new information?
Or if there's let me put it this way then. If there's a further filing of material, would you expect for the consumer advocate and or the commission to utilize or at least review that information and try to incorporate it into their assessment of the case?
Yes, yes, that would be correct.
And that sorry, you can finish.
No. In essence, when you look at the temporary rate increase request, the most significant or the new information is the cargo tonnage forecast. The adjustments to the operating expense are a result of responses that YB provided to the consumer advocate's information request. So it's not really new in the sense that it's part of the record that has been ongoing since the filing of the initial application. But nobody could have anticipated this pandemic, and nobody could have anticipated the impact of this pandemic. As a result, given the significant impact that the pandemic has had on the cargo tonnage that was initially forecasted, it is appropriate to now consider the reduced cargo tonnage that is being forecasted. And I believe that YB has been providing the commission with periodic updates on the lower cargo tonnage that they are now transporting as a result of this pandemic. So it shouldn't come as a complete surprise that the temporary rate increase is looking at the lower cargo tonnage. It's a reality. They're facing this.
So I guess the last question then, if new information keeps getting added, the new information should be reviewed and incorporated as appropriate then?
As long as it's not after the record is closed. Let me back up and explain. The Hawaii.
I think you answered my question, so I have no further questions.
Okay.
Thank you, Mr. Tsuchiyama. We'll turn to Chief Counsel, Commission Counsel Carolina Shida.
Thank you, Chair. I have no questions for this witness.
Now we'll turn to the commissioners. Commissioner Suntian.
Yes, thank you, Chair. I do have a couple of questions, more I think for clarification or confirmation on what I heard. Good morning, Ms. Kikuta.
Good morning.
I think, and I'm going to paraphrase, and I'm not as versed in the terminology on rate cases and the like, so forgive me for that. But I'm going to try to paraphrase what I heard. First off, right, the way you describe this emergency rate relief, it is within the context of a regular rate case. I think that's the gist. So
yes, that is
right. If we didn't have this emergency rate relief, it would probably be like an interim decision and then a final decision.
Yes, that is correct.
So if that's the case, and maybe you can confirm for me. So say we do have a decision on the emergency rate relief, right, and an amount. So if I play that through, so if we do take up, right, the rate case, which is still pending before, right, the initial rate case application, this emergency rate relief has to be factored in, right, to the a final or interim decision on the rate case.
May I ask a clarification?
Sure.
Are we saying, for example, if the emergency rate relief amounted to $20 million, for example, and the permanent decision request was $27 million, that the $20 million granted in the temporary rate increase is a part of the $27 million that's granted in the permanent rate increase? Is that what you're asking me?
Yeah, it does it. Is it factored in, right?
Yeah, if that's the case, yes. It
Okay.
is not on top of the $27 million. It is a part of the $27 million.
Okay. And so thank you for that. I think the only other question I have, and it stems from Mr. Tsuchiyama's cross-examination of you. So clarify for me, so the current request for the emergency rate relief, it does assume, or YB had to assume, a full sailing schedule, right?
Yes, that is correct.
Because they did not have any decision on their request for a modified sailing schedule for X period of time.
And I'd like to clarify, that's correct. Yeah. However, the key is, what is that X period of time? If the X period of time is only like 30 or 60 days, then when YB sets rates, they have to assume that the normal operations will be the full sailing schedule. If the approval is for a more long-term basis that is tied to, for example, the cargo tonnage that will be transported, then assuming that that cargo tonnage volume is not going to be realized for an extended period of time beyond a 12-month period, then yes, if that approval is granted, then YB can take out the amounts that they have embedded in their temporary rate increase, which amount to approximately $9 million, because they'll know that they don't have to resume to the full sailing schedule for a period beyond 30, 60, or 90 days. It's more long-term in nature.
Okay. Thank you. Thank you, Ms. Kuta, for that. Chair, I yield back to you.
Thank you, Commissioner. Commissioner Potter's next.
Thank you, Chair. I have no questions for this witness.
Thank you, Ms. Kikuta. I have no more questions either. You may be excused. Have a good day.
Thank you.
Okay. Given the time, we're going to keep rolling. We're going to go to Mr. Anna next, or I guess go back. Mr. Anna, can we test your connection?
Yes, I'm good. Apologize, Commissioner. We were informed that Telcom had some issues in the area, and that's why all of us dropped off. So,
understood.
Thank you for accommodating.
Yep, it sounds good now. Oh.
Excuse me, Chair.
Go ahead.
Yes, we've been going about an hour, and I've entered into the kupuna stage of my life, and so I'd like to request a short break, please.
How long?
Just enough to run to the restroom and come back.
No, okay. 5 minutes. Or we'll start back up again at 10:20.
Thank you. Sorry.
Thank you, Chair.
Okay, we're in recess.
Oh, how come I didn't get off?
Okay, we're going to get going in a second here. Mr. Otto, you ready?
Yes, can you hear me, Chair?
Yes, I can hear okay. Opposing counsel, can you hear who is it? Mickey's up?
Yes, Chair. I'll be
Okay.
on this witness.
Okay, we can hear you okay. All right. Calling the hearing back to order. We'll proceed with the examination of Jeremiah Anna. Please stand and identify yourself before I proceed with the oath.
Yes, I'm Jeremiah Anna.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Chair.
Okay, please proceed with the direct examination.
Thank you, Chair Griffin. Please state your name for the record.
My name's Jeremiah Anna.
And what is your position at Young Brothers?
I am the president of Young Brothers.
How long have you held that position?
I am on my 8th month. I started in January of this year.
You had done a previous stint at Young Brothers. When was that and what was your position?
Correct. I was with Young Brothers originally as a business unit controller, starting in 2014, and I left as the director of finance and accounting in 2018.
Let's get right to the point. Please describe for us Young Brothers' current financial condition.
Currently, we are in a position where our financial constraints have been exacerbated by the impacts of COVID. It has been well documented that we have been in a loss position for the last couple of years, with losses of about $11 million and $10 million in 2018 and 19 respectively. Pre-COVID, we anticipated a loss of about $13 million. With the advent of the governor's a stay-at-home, stay-at-work proclamation that took place or took effect late March, our cargo volumes dropped significantly, and at its worst and its peak was about 40% down year over year. That, again, has exacerbated our financial situation to a point where now we anticipate an intrastate loss of about $30 million.
Okay. Mr. Anna, you mentioned that you were in a loss position. Young Brothers was in a loss position for the last couple of years. That would have been pre-COVID, is that correct?
Correct.
Tell us about those pre-COVID losses. What caused those losses?
Okay. So over the last several years, we have been operating in a position where we've basically had flat or decreases in intrastate cargo volume. That degradation in cargo volumes, combined with virtually no significant rate increases over a period of 6 to 8 years, combined with continuing escalating costs, have led to our financial situation.
And can you describe when the COVID pandemic first affected Young Brothers' cargo volumes?
Yes. So again, the pandemic had been affecting the world really, I think, into the latter part of 2019. But for Young Brothers, we did not see any impacts or noticeable impacts to our cargo volumes until the governor's proclamation ordering businesses to close down took effect. And I believe the date was March 23rd, I believe. We look at it as week 13 of our operating cycle.
And then what happened after week 13 or after Governor Ige submitted that emergency proclamation on March 23rd?
So we saw immediate declines in volume. That first week, week 13, we saw approximately 12% year-over-year decline in volume, and that escalated significantly. The subsequent weeks, and I think it was about, within 2 weeks, we were down 30% year-over-year, and that held for effectively the duration of the governor's stay-at-home order, which I believe was in effect for 30 to 60 days. At its peak, we were down close to 40% on a given week. On average, for the bulk of the pandemic's impact to our state, we've seen year-over-year declines of about 30%.
And what have you done to obtain funding to assist young brothers financially?
So we've pursued all avenues and opportunities of that we have been able to identify as external or third-party relief. We've continued to monitor federal opportunities, whether that's specific CARES provisions, PPP, the Main Street home lending opportunities, none of which have been applicable or pertinent to YB. So unfortunately, there haven't been or hasn't been to this point a specific maritime carve out. We've also continued to work with state and local government agencies to pursue opportunities for relief, whether it's through CARES appropriations to the states and counties or other normal subsidies. In addition to that, we've been working with government agencies to provide and seek opportunities for relief, not necessarily in the form of cash funding, but by relief of our expenditures to the state.
Have you attempted to obtain any loans?
We have also sought third-party financing, and unfortunately, we were declined in each of those instances.
And why were you declined?
Because as we all undertake in our normal course of life, when we apply for a loan for a home mortgage loan, for example, there's a financial review and an assessment of an ability to repay. And each of the banks have provided us feedback suggesting that we do not demonstrate the ability to repay because of our negative cash flow. And effectively, their comment is that we don't have the debt service coverage.
The consumer advocate brought up in his opposition memorandum that Young Brothers helped bring on its own financial problems by investing in the 4 new Capena tugs that cost $80 million. Do you remember seeing that from the consumer advocate?
Yes.
And do you agree with that?
I disagree.
And why do you disagree?
Well, for a couple of reasons. First off, the investment in the tugs is for the benefit of the consumers to ensure safe, reliable, and consistent service. So, I guess first and foremost, it demonstrates our commitment to our community. It demonstrates a commitment to our customers, and it demonstrates a commitment to our employees that safety is at the forefront. It also demonstrates a commitment to our environment. But specifically, why it doesn't necessarily contribute to our financial circumstances, that at current we don't carry any debt relative to that investment. At the time, right, we were able to secure funds from our ultimate parent, and those funds were utilized to acquire those vessels. We do have outstanding intercompany payables. I believe it's to the tune of about $8 or $9 million. Chris Edwards, who will testify later, can provide more specifics on that. And that's based on a mix of things, but includes the investment.
When you say funds from your ultimate parent, are you referring to capital invested by Saltchuk, the parent of Young Brothers?
Correct. Well, ultimately by Saltchuk Resources, yes. But the funds come from our immediate parent, Foss Maritime Company.
And why can't you sell those tugs to generate cash than lease back cheaper tugs? Why isn't that an option?
So there's a number of different obstacles that that would be presented, or I shouldn't say obstacles, challenges that would be presented if we did that. It goes back to really when the due diligence that we did when we made the prudent investment in the tugs. In doing so, we investigated the market, right? We scanned the market to assess whether or not there were vessels in the marketplace that we could acquire without having to go through the process of building our own tugs. One of the issues with that is that, again, not all tugs are created equally, meaning, each tug is very specialized. A harbor tug is different than a towing tug, and different towing tugs have different I guess, specs to be able to endure the environment that they operate in and the conditions that they work under. Our towing tugs, for one, are very specialized. So if we were to sell it, assuming we are able to sell it, we wouldn't be able to find in the marketplace tugs that would be able to service our community in the fashion that we are able to with the Capenas. and that also assumes that we would be able to sell it. In a down market like this, we'd likely take a fairly significant loss on those vessels because there is a downturn in the world economy. There are a lot of vessels that are available in the marketplace. So the market is flooded, and we wouldn't be able to yield a cash return or a market return for our initial investment. But most importantly, the tugs are an integral part of performing our service. With the Capena class tugs, again, I mentioned a number of different benefits. They're environmentally friendly, they're safe, but from a customer's perspective, they ensure timely and reliable service to promote and support the just-in-time needs of consumers in the Hawaii market. Before acquiring these tugs, it was not uncommon for us to have late arrivals, for us to, in fact, miss sailings because our tugs were 35, 40 years old. We also incurred a significant amount of maintenance expense because of the unreliability of old vessels. And last but definitely not least, the on-time arrival, it facilitates our ability to manage and minimize overtime on shoreside labor. If we are late, and when we were late even more so in the past, it made it extremely difficult to manage the shoreside labor.
Mr. Ana, I want to change subjects for a moment here. I want to refer you to a letter you wrote to the Commission on July 24th, 2020. And for the record, this is a letter described as docket number 2019-0117, Young Brothers LLC's notice regarding potential discontinuation of regulated intrastate water carrier service of property in absence of necessary emergency rate relief by August 17, 2020, and/or other government funding. You're familiar with that letter, Mr. Ana?
Yes.
And what was the purpose of that letter?
The purpose of this letter was really to underscore and emphasize and remind the Commission and all parties of the urgency of our situation. We had filed for emergency relief, and that in and of itself, I think, also relayed that message. But it was really in an effort to be transparent, to communicate, and to make sure that we and that all parties involved and all stakeholders involved had an opportunity to understand our situation. As we've mentioned a number of times, we're in a position where we've continued to manage our cash flows and we've managed terms with vendors, but we've gotten to a point where we expect that we will no longer be able to continue that practice and that vendors will start to discontinue or turn off service if they don't have certainty that we will have the ability to repay. Again, we've been able to manage that, but I will say, and Chris Edwards will reiterate in his testimony later, that at this juncture, we have more obligations, financial obligations, than cash on hand. And so at some point, juggling and managing our cash will require that we make adjustments to our business in order to constrict and make sure that we are able to make the obligations as they come due.
Was this letter intended to be a threat to the Commission?
No, by no means was this letter to be intended to be a threat. Although we recognized when we were drafting the letter that it would be received that way, and there was really no way around it. But our intent was to communicate just as it was with our letter that was issued, I think, on May 24th or 26th. Our letters are to notify and to be transparent and be communicative.
How did you select the August 17th date for this letter?
So the August 17th date, was really based on our expectation that we would be able to continue our practices of managing cash and terms through the latter or end part of September. August 17th gives us effectively about 45 days to make plans if we need to constrict, to manage our cash flow. But again, our focus today is on finding a solution. And we, at this point, are entirely focused on a solution, whether it's through emergency relief and or through continuing dialogue with state and local agencies.
Mr. Ana, one last question. Can you just describe for us, summarize for us just how dire Young Brothers' financial condition really is?
Yes. So again, as I mentioned, we have obligations that are greater than the cash that we have on hand. And as the year ensues, we have even greater obligations. Right now, we have a $5 million pension or greater than $5 million pension commitment, a cash payment that's due in December. But we continue to operate monthly cash flows at a deficit. Like any of us in our households or any of the businesses that are challenged in this trying time, you can only continue to manage, vendor terms and whatnot for so long. And at a point, we will not be able to make payroll. And that is forthcoming in a very short time frame. As I mentioned, we're looking at in the next 45, 60 days.
Thank you, Mr. Ana. I have no further questions for you at this time.
Thank you.
Thank you. Now we'll proceed with the cross-examination from the consumer advocate, to Mr. Knox.
Okay. Can you hear me okay?
Yes.
Okay. Good morning, Mr. Ana.
Good morning.
I hope you and your family are staying safe right now.
Thank you. Likewise.
Thank you. To start today, about that May 26th letter, if you need it for reference, it was CA 16 hearing exhibit. Do you recall writing near the beginning of the letter, quote, "I expect that unless immediate relief is obtained from the state of Hawaii, Young Brothers will face a cash shortfall very shortly," end quote.
Correct.
Now, you talked a little bit about this indirect, but can you just explain that particular term? What did you mean when you wrote the letter by cash shortfall?
Yeah, so, again, cash shortfall basically means we will have less cash than the obligations that we have that are coming due. As mentioned previously, and that's been on the record, prior to May 31st, we were able to operate at a cash flow deficit only because we continue to receive external funding. But no different than anyone else who have maybe a line of credit for your personal reasons, or whether it's for your home equity line or whatnot. That line of credit needs to be repaid and be paid on, and that line of credit cannot just be a constant cash inflow, and so it was discontinued. And in that moment, or May 26th, I guess, the intent was to communicate that the cash shortfall was that we would not have enough cash and we would not generate enough cash to meet the obligations as they come due.
Mm-hmm. You mentioned some of those obligations, such as paying your employees or suppliers. Which upcoming expense in particular and when would Young Brothers soonest not be able to pay, given its rates are the lowest?
Okay, there's a number. We have been, I guess I'll use the term floating our AP. Like any business, there are terms to AP when there's an expectation to repay. In many of our outstanding liabilities, we've actually extended beyond the term. So for example, a normal payment term is 30 days. We are past due on many of those payment terms. And so this is in large part, Jeff Ono had asked about how did you come up with the August 17th date? We were looking at how long we can continue to extend the terms on some of these payments until these vendors would ask for them to come due. One example of you asked for a specific example of a vendor who we have not paid and what we expect. We have not remitted our payment of wharfage, for example. The wharfage obligation is about $2 million each month. And so with each passing month, we'll incur a continuing liability of $2 million. I think at current, our amount due is about $6 million.
Okay. Mr. Ana, do you recall participating in a status conference before the commission back on June 10th?
Yes.
And at that status conference, do you remember making a presentation describing the company's financial challenges and the steps being taken to contain costs and pursue other sources of revenue?
Yes.
Do you recall telling the commission that Young Brothers needs funding to sustain operations through 2020 and emergency rate relief, including potential 25% increase, $18 to $20 million in revenue requirement? Subject to check?
Yeah, I don't remember the exact specifics, but that sounds, yes, in the ballpark, yes.
Okay. Do you recall projecting a cash shortfall in August under that forecast?
We reflected one, yes, but we also reflected and indicated that assumed, I believe that cash projection assumed that we didn't do anything, or we continued normal course of operations, but we were planning on taking some steps to continue to mitigate that risk.
Okay. For that presentation, were all of the revenues and cash values that you used prepared on a total company basis rather than only on interstate?
I don't recall every slide, but for the most part, I believe the slide deck was prepared on a total company basis.
Okay. Do you remember if the values from monthly EBITDA and free cash flow amounts for each month of 2020 were presented on a total company basis or on an interstate basis?
I do not recall. I think Chris Edwards, who will provide testimony later today, and I think he spoke to that slide in the status conference, will be able to confirm that.
Okay. In your direct testimony, you mentioned that the company had been paying $8 to $9 million in intercompany payments for the new tugs. Is Young Brothers still paying those $8 to $9 million?
That's a correction. We are not paying it. That's an obligation. That's a accounts payable or intercompany payable. We have not been making payments on our intercompany payables.
Okay.
So it's another one of our outstanding obligations.
Okay. Looking at the company's expense reduction efforts, the company indicated it was going to evaluate headcount. Can you tell us about the company's reductions in workforce so far?
Yes. So we've had reductions in workforce in two primary categories of our business, or areas of our business. We've had reductions in workforce in our what we refer to as our administrative and salaried staff. That's our non-union personnel. We had layoffs in that area. And we also had layoffs in our Inland Boatmen's Union workforce. That's our IBU. Those are that's the crew that works on the vessels.
Okay. Does Young Brothers intend to bring back all of those employees, or will some of those reductions likely be permanent?
So on the, I guess on the IBU side, the vessel side, we were able to terminate those employees because we were able to work that temporary adjusted sailing schedule. So we're currently operating an active 4-tug fleet versus an active 5-tug fleet. To the extent that we are able to continue a sailing schedule that is permanent, then we would not need to bring that crew in until we had to continue the full sailing schedule. On the admin side, it is not sustainable to continue to have all of those positions unreplaced. For example, one of the positions that was terminated, or a couple of the positions that were terminated, help to manage and oversee our operation, particularly here in Honolulu. Our director of terminal operations has taken a more hands-on role in overseeing that, but it would be extremely challenging on an ongoing basis and on a permanent basis for him to manage the day-to-day business as well as continue his other responsibilities.
Okay. On the union side, what discussions has Young Brothers had with ILWU and IBU about its collective bargaining agreements, especially in terms of furloughs and RIFs?
Yes. Well, so I mentioned the IBU. We've had obviously executed some of those. As it relates to the ILWU, I will defer to Chris Martin. He's our terminal operations director, and he is our primary contact and collective bargaining contact with the ILWU.
Okay, thank you. at least for the IBU, besides just furloughs and RIFs, have you talked about overtime provisions in the CBAs?
Well, with the IBU, their contract is managed a little bit differently. They're basically, how do I describe this? They work on the crew and they're on the boat, so they don't really get paid overtime. It's what's called a day rate. And so because, so for example, they're working on a vessel. It's not like it's not an 8-hour a day job. They sail to Hilo, they're on the boat for 24 hours, and then they have to continue on to remain on the vessel as the barge is discharged, and then they remain on the vessel 24 hours on the voyage back. So they're paid through a day rate. We've had some discussions as it relates to day rate, but nothing has materialized or been finalized at this point.
Okay. For the ILWU, we can bring this up more with Mr. Martin, but just to the extent that you can answer, have you had discussions with the ILWU about overtime provisions?
We have not specifically talked about overtime provisions or as it relates to the contract, but we've continued to manage overtime to the extent possible through the CBA. As mentioned, we have the sailing schedule adjustment that we estimated at for this year, I think approximately $7 million in savings. It should be noted that a significant portion of that savings is through wage. It's through wage because we don't have barge days. It's through wage because those barge days are not driving overtime. And it's through wage because we've also managed the gate hours on non-barge days.
Mm-hmm. What is the status of negotiating vendor rate reductions, including affiliate transactions?
Yeah, so we continue on an ongoing basis to negotiate vendor contracts. In many instances, we've gotten reductions in our vendor contracts. But again, not all of those are sustainable, right? So many of the vendors, we've managed terms with them and we've gotten temporary reductions, but they are not permanent reductions.
Mm-hmm.
Likewise, with affiliate transactions, we've gotten instances with services that are being provided. We've been able to get discounts on those services as well.
Is there any reason why Young Brothers couldn't continue to pressure its vendors and talk to them about price concessions?
There's no reason why we couldn't continue. No, and as I said, it's an ongoing and continuing process.
Sure. Same with affiliates?
Correct.
Okay. I wanted to come back to that June 10th presentation. Did you mention the Young Brothers secured a temporary common carrier agreement with Matson to increase revenues over the next 90 days?
Correct.
From that point?
Correct.
In Young Brothers' response to CAIR 374, you provide some more information about the revenue gains arising from that agreement. Do you know why Matson was interested in increasing its cargo volumes with Young Brothers at that time?
Well, objection calls for speculation.
Okay, I'll rephrase. Did Matson tell you why they wanted to increase the cargo volumes with Young Brothers?
They did not.
Okay. In that same response to CAIR 374, Young Brothers indicated that it did not include any of the impacts of the Matson Agreement in calculating its freight revenues or jurisdictional allocations supporting the requested amount of emergency rate relief, because the Matson Agreement is a short-term agreement effective for a 90-day period, and Matson is not obligated to provide additional cargo under the agreement. Has Matson, in fact, provided additional cargo under the agreement so far?
They have.
How much?
I couldn't tell. I mean, they've given us much more cargo than they had in the past or most recent history, particularly in the auto area. I couldn't tell you off the top of my head how much. I mean, that's a pretty vague.
In rough terms, double?
Oh, well, Well, auto is more than double. You know, before we started the agreement, I think we got a piece count of 2 automobiles from Matson in for the year leading up to, I believe, was the end of June. Since then, again, please don't hold me exactly to this number, but we've seen anywhere on a weekly basis of anywhere between 150 to even 300 at some points vehicles from them on a weekly basis. Containers, it fluctuates, but I would say it was probably in the anywhere between 50 and 75 containers a week, more than what we were receiving in the past.
Okay. Given the way that the arrangement has gone so far, do you expect that the agreement might continue?
Again, as Jeff indicated, that would require my speculation. It is our hope. It is our hope that that would be the case, but I cannot speak to whether or not that would be. We've had. I think if you look at the last couple of years, our experience with Matson, they will make decisions and move cargo in the manner that's in their best interest, and depending on market conditions, I presume. I'm not speculating as to what drives their decisions, but I assume that the market conditions will determine how they manage their cargo loads, whether it's on their own or to utilize YB as an overflow.
Okay. Is there an option in the agreement to extend that temporary agreement for a longer term?
I do not believe, but I don't recall specific language, but I don't believe there's an immediate option clause.
But could the
I'd
two
have to look
parties
at the
decide?
contract again.
Could the two parties decide to extend it if they want?
I believe there's language in there that the two parties can decide to continue the agreement. Yes.
Okay.
But there's not I don't believe there was an explicit, option statement or anything to that effect.
Okay. Would you please confirm that Young Brothers has filed an application in docket number 2020-0104 seeking deferral accounting authority for both pandemic-related costs and lost gross margins?
Confirmed, yes.
Are the lost gross margins that Young Brothers is seeking to recover there different from the lower revenues directly attributable to the cargo volume decreases in your motion for temporary rates here?
When you say different, I don't believe they're different. You mean, are they overlapping or are they the same? I mean, I guess, is that your question? Yeah, it's the same loss.
Okay. Do you think it's appropriate to ask the commission for recovery of those amounts in both the motion as well as the other docket?
We do, and the reason being is we don't expect a favorable decision on both items in both dockets, but what is uncertain to us is whether we would I guess be successful or whether the commission would approve one versus the other. And so we acknowledge that if to the extent that we get recovery through emergency relief, that we would not seek that recovery of that through the deferral docket.
So you would prefer that recovery through the emergency relief over the deferred accounting?
Absolutely. And the reason being is because, as I mentioned, and by way of our letter, we have an immediate cash need. The deferral docket, while it provides a potential avenue for recovery, I guess there's two things. One, all it asks for is for deferral. It doesn't necessarily suggest that we have recovery of it. And so from a financial standpoint, it just pushes the financial impacts down the line, but it does not provide the immediate cash infusion that the emergency relief would.
Would you still have that preference if you didn't have the immediate cash need because, say, you had access to capital through Salt Chuck or through bank loans?
I guess it's hard to say. Again, that would be speculating. Okay. But I think that we would be more open to a cost deferral, especially in light of the current pandemic and what impact rate increases would have on our customers.
Okay. Would you please look at Young Brothers' application in docket number 1999-0213? It is listed as the Consumer Advocate Hearing Exhibit CA 13.
I'm sorry, I don't have that. How do I? 1999?
It's Consumer Advocate Hearing Exhibit CA 13. It is docket number 99-0213.
Okay, okay, I'm sorry, I need to ask someone from my team to
Sure.
help me locate that.
We're testing the.
Yeah, Mr. Knox, can you share your screen with the exhibit?
Exactly. Thank you.
Help facilitate us. Do you have it up?
I can, if you would give me a minute.
Okay.
Mr. Chair, this is Lane. I have it available. Let me try to see if I can share that for Mr. Knox.
I have 99-0231.
Can you see I think I shared it with mine.
I can see it.
Okay, I see it.
Okay. Well, thank you, Lane. Would you turn to page 14 in the application? It's 17 of 28 in our exhibit.
Is that page 14 of the application? Sorry. Okay, I think I'm there.
Yep. And go up to the image. Okay. In that second paragraph, the second sentence, Mr. Anna, would you please read that second sentence starting with Salchuk will dedicate the resources?
Salchuk will dedicate the resources which are necessary to support growth, development, and safe operations at YB.
Thank you. So as Young Brothers responded to CAIR 391, that commitment was made about 20 years ago. So about when did Salchuk decide to possibly abandon or renege a commitment it made to the Commission and to Young Brothers customers to support Young Brothers growth, development, and safe operations?
Well, I guess first off,
excuse me, Mr. Anna, let me object. That question is argumentative.
I think maybe Mr. Knox, can you rephrase?
Sure. In your response to 391, did you object to answering the question about this phrase?
I believe I did.
And did you point out that that obligation was made 20 years ago?
I don't recall specifically. What was the IR number?
IR 391.
Hold on. Sorry. Okay. Okay.
This is Lane. Do you see that? I think I have it on my computer now.
Okay.
Thank you, Lane.
Yeah, I remember indicating that it was
at the very bottom.
Not waiving such as states that reference. Okay. Yes, I confirm that.
Okay. So that commitment was made about 20 years ago, and your response indicates that that length of time has made it moot. Is that accurate?
No, I don't think we were suggesting that the length of time has made it moot.
So does Salchuk still commit to support Young Brothers with the resources for its growth, development, and safe operations?
Objection calls for speculation.
Why would that be speculating? Isn't he an employee of Salchuk through its subsidiary?
No, he is not. You can ask the question.
Can you rephrase, Mr. Knox?
Sure. Mr. Anna, you indicated in your response to, I believe it's 392, that you have been in touch with Saltchuk about different synergies. When you were in contact with them, did you ask them about their commitment to support YB that they made back in number 990213?
I believe the IR was Saltchuk or other affiliated companies in synergies. So my direct parent is Foss Maritime Company and Saltchuk Marine. So my discussions are directed through that entity, just for clarification.
Okay. Do resources come also through Foss Marine?
Foss Maritime provides was the entity providing us our funding, correct?
Did you talk to Foss Maritime about a commitment to provide resources necessary for YB's growth, development, and safe operations?
Yes.
And what did they say?
Well, again, no different. As I mentioned earlier, they've made a decision to discontinue funding our daily operations. Their commitment came by way of continuing to fund the capital needs of equipment in our operation, as demonstrated most recently by the $80 million investment in our Capena tugs.
But not ongoing OPEX.
No, YB needs to be able to operate and fund its own business and generate operating revenues sufficient to cover its own operating expenses.
Okay. Can you see Consumer Advocate Hearing Exhibit 21? It's an SEC disclosure form showing a purchase by Saltchuk of about $6.5 million stock in Overseas Shipholding Group, which is an operator of a fleet of oil tankers and barges based in Tampa, Florida.
I see it.
I'm going to object to this line of questioning as being irrelevant.
It goes to Saltchuk's ability to provide resources.
We'll allow the question.
Thank you. When you're talking to Foss Marine, did you point out that Saltchuk apparently has capital to invest?
No, I do not.
Okay. Saltchuk did represent that it would support Young Brothers in the 990213 docket. It does have money now, but it just won't support Young Brothers, not even through this regular rate case proceeding?
Yeah, I'm sorry, Mickey, I didn't hear the question clearly.
Sure. I'll try again. Sorry. So Saltchuk represented that it would support Young Brothers back in the 990213 docket. It has money to invest, but it's indicated to Young Brothers that it just won't support OPEX, at least through the end of the regular rate proceeding. Is that correct?
Objection argumentative.
We'll allow the question.
Again, I can't speculate as to what Saltchuk's decisions are, and you know, I don't represent Saltchuk. I'm an employee of Young Brothers.
Just from your business experience, would you call it a reasonable business practice, especially in the context of the utility compact, to have a situation where a parent company, without at least setting up a subsidiary with independent access to capital, pulls financial assistance on short notice?
Would I phrase that? Would I think do I think it's reasonable?
A reasonable business practice.
Yeah. That they would establish. I'm sorry. Say that again.
Do you think it's a reasonable business practice, especially in the context of the utility compact that is applicable here, for a parent company, without at least setting its subsidiary up with independent access to capital to pull financial assistance on short notice?
Well, I guess I think what practice was taken, again, there's some speculation here, but based on my professional financial experience, I do not think it was impractical or unreasonable. All businesses need to be able to sustain themselves and generate operating revenues to cover operating losses.
Is there any difference in the context of the utility compact with regulated utilities?
I do not, that requires a subject matter expert that I don't know the answer to that question.
Okay. If Young Brothers had its own line of credit with banks, could it draw on those lines to support operations while the rate case is completed?
That is correct, but it is contingent on a significant assumption that we would have been able to secure a line of credit and financing. As we explained, because of our historical operating losses, absent of even the existing pandemic, financial institutions would not provide us the funding necessary to secure a line of credit. I believe we had gone through an exercise that was initiated before even this pandemic, and we were encountering the same issues because we did not cover our operating losses.
When you talked to banks recently, did any of them say that they would be more likely to extend you a line of credit if Saltchuk had not pulled its financial assistance?
We know that there was no representation to that effect.
Okay. Just a few more questions. Thank you. Would you agree that there is significant uncertainty at the present time in terms of the timing and pace of Hawaii's economic recovery from COVID-19 and its economic impacts?
In general, yes. There's uncertainty is, I guess, the core of the question. Yes, there's absolutely.
Yeah. Given the uncertainty, has Young Brothers prepared periodic updates of its 2020 operating budget to look at different scenarios of economic recovery?
We've continued to rehash our forecasts, and we have we use, I believe, and Chris Edwards can speak to this more specifically. We use a Monte Carlo financial model to assess and evaluate different scenarios of financial recovery due to the pandemic. Yes.
So scenario planning through budgets.
Correct.
Okay. Has Young Brothers done these same scenario plans through its operating budgets to look at different options regarding sailing schedules and other changes to its operations under consideration?
We haven't necessarily flown them through the entire financials, but we've looked at different, I guess, impacts of different alternatives. Yes.
Okay. In your view, does the recent decline in Young Brothers freight volumes and resulting loss of revenues justify Young Brothers revising its originally filed rate case revenue forecast to incorporate lower freight volumes caused by COVID-19?
Objection, legal conclusion.
Hold on a second.
Sorry, I was slow to mute.
Jeff, can you say why that's a legal conclusion?
Yeah, can you please rephrase, Mr. Knox?
Sure. Does the uncertainty justify Young Brothers taking current conditions into account and revising its originally filed rate case revenue forecast?
Yeah. Well, objection, vague and ambiguous.
Okay, let me try.
Yeah, please rephrase.
Okay. Does the company intend, in the pending full rate case and the remainder of the proceeding, to rely on its originally filed forecasts of revenues and expenses?
Yes.
Okay. Thank you for your time today, Mr. Anna. Chair, the Consumer Advocate has no further questions for this witness at this time.
Okay, thank you, Mr. Knox. Moving to Commission Counsel Carolina Shida.
Yes, thank you, Chair. I have just a couple questions. Good morning, Mr. Anna.
Good morning, Caroline.
Just to follow up or to clarify on a couple of the consumer advocates' questions, what is your current understanding of Salt Chuck Resources' obligation and commitment to support YB as a subsidiary?
Salt Chuck, my understanding is Salt Chuck remains committed to YB and the state of Hawaii. But again, a path forward needs to be developed to ensure that YB can stand on its own and continue to generate operating cash flows to sustain its business. Salt Chuck's commitment and obligation, my understanding, is to continue to provide the capital necessary to acquire the equipment and develop facilities and infrastructure to continue to provide our vital service.
You said continue to provide the capital necessary. What does that look like?
What do you mean?
You just said that Salt Chuck's obligation is to continue to provide the capital necessary to YB's operation. What does that look like?
What investment in capital? Our business, while it requires obviously labor to utilize the equipment, it requires a significant investment in equipment. Whether it's tugs, barges, containers, and lifts. Salt Chuck continues or has provided us that funding, and their commitment is to continue to provide that funding. But does that make sense?
In your motion for the emergency rate relief, you said that Salt Chuck Resources is currently unwilling to continue to invest in Young Brothers at this time. And what you just said here seems to contradict that. Can you clear that up for me?
So the discontinuation is to fund the daily operating costs of Young Brothers. But to the extent that we need to continue to acquire new equipment, that is a funding capacity that as obviously we've deferred capital and maintenance at this time to help manage our business, but as obligations to that effect come due, then that is the means, or Salt Chuck Resources by way of False Maritime Company would be the means of that funding or the source of that funding for those purposes.
Has Salt Chuck provided any capital to YB since that May 26th letter that was raised earlier?
It has not.
Okay, thank you. And can you also quickly walk us through what YB's operations look like if it were to, as you raised in your July 24th letter to the Commission, discontinue regulated intrastate service?
At this juncture, we don't have, sorry, was there somebody else? At this juncture, we don't have a set or defined plan as to what we will look like. Again, we would have to explore any and all opportunities or avenues to manage our business.
Would the provision of that interstate service involve the use of any regulated intrastate rate-based assets?
Would the provision of the interstate service include use of regulated intrastate assets? Yes, our resources are all shared resources.
Okay.
Did I understand your question? I'm sorry. Can you repeat the question?
I think you did understand the question. I have no further questions at this time. Thank you.
Thank you, Ms. Ishida. Questions from the commissioners now. Commissioner Sunstein?
Yes, thank you, Jay. Thank you, Chair. Good morning, Ms. Nana.
Hi, Commissioner.
I think I have a number of questions, but I think it's from what I've been hearing from you, it might be more pertinent to others, so I'll hold off on those. But I think, right, as I understand it, right, the major kind of components, if you will, of the business, right, it comes down to the volume, right, that is shipped, and then also operating expenses, right? in a nutshell, right? And I'm sure there's other things, but those
I
are,
would say rate and volume.
okay.
Yes,
Okay.
right. Mhm.
And so we've been talking about, right, like how YB would look like if they were to be reduced, or right, some viewpoint of the future. And you've been talking about some of the things, right, with Mr. Knox, about, you know, what have you guys taken a look at, right? What are options? And I just want to maybe ask you, are there anything else at this point off the top of your head, or that you have some awareness of, that, right, things that have not been mentioned, right, that YB is taking a look at now, or maybe taking a look at in the next whatever, week or so?
So I mean, other things as opposed to what we've filed as far as I guess is what that's on the record. You know, like the.
Well, what's on the record and what was discussed today, right? You.
Oh yeah, no, those I. Yeah.
Yeah, he went through like.
I should note, I believe you're aware, Commissioner, we had initiated our first meeting with a working group through SR 125. That working group was intended to address exactly this situation, but more on a mid as well as long-term, from a mid and long-term perspective. At this point with our first meeting, we hadn't, I guess, developed any alternatives, but we are very excited to continue to work with all stakeholders and identify potential options in restructuring our business, if that's an appropriate term to say, so that we can ensure that we are able to provide a balanced, come up with a balanced solution and continue to provide our service.
Okay. And one more item for clarification for me is, we talked about the intercompany payables, right, which is an obligation. And you mentioned that YB has not been making those payments at this time. How long has, right, because you were making them at some point and then you stopped. Was it when COVID hit? Was it, right, it was before that? Or can you give me an indication? And maybe it's not you, maybe Mr. Edwards can speak more to it.
I think Mr. Edwards can confirm, but I believe that we stopped making payments in or around that May 31st date. It was probably, a week or two prior. Well, actually, I should let Mr. because it technically, I guess what I should say is it's probably well before that, because all of our cash was managed on a net basis, and we were drawing more cash to support our operating needs than we were, to pay. So we might pay. Example would be, I might pay $5 on the debt, but I'm going to ask them for $15 because I need to pay payroll and vendors.
Okay.
Does that make sense?
Yes, thank you. And likewise, Brett, we talked about the wharfage fees, and roughly about 6 million. So if it's 2 million a month, about 3 months. But the wharfage fees goes to DOT harbors. Is that
correct?
Payment to the state.
Correct.
So it's really been about 3 months or so.
We stopped paying the May. Our last wharfage that we paid was for April, I believe.
Okay. And I assume that was worked out with DOT harbors.
That's incorrect. Obviously they are aware, but part of our position is that I don't remember the exact chapter, but the governor's proclamation that suspended, tenants.
Yes.
We believe that wharfage falls under that suspension.
Okay. Thank you. That's all the questions I have, Chair. You back.
Thank you, Commissioner Asuncion. Commissioner Potter's next.
Thank you, Chair. Good morning, Mr. Ana. How are you today?
Good morning. I'm good as can be.
Good.
Commissioner,
yeah,
thank you.
As good as can be, right? Excellent. So I'm going to shift gears a little bit here and talk more about attitudinal issues for the company. I'm going to refer back to page 4 of the supplemental memorandum that YB filed days ago. To quote that document, you stated, as such, existing rates not only negatively impact the company's overall financial performance, they also send incorrect messages or price signals to certain customers. I want to ask, does YB recognize that the services that they provide to Hawaii residents are scarce and that customers have very little options? I'm going to compound this question, I apologize. And as much, does YB understand that the services that they provide are essential and that customers do not have the luxury of shopping around or responding to price signals from service providers?
Do we recognize, I'm sorry, I want to try to tackle both questions. So I guess we contend that there are, depending on the service, but there are alternatives. So consumers do have options, whether it be by freight forwarders, air freight. And I think that is in large part is what's contributed to even our pre-COVID financial circumstance. I referenced that what has driven a significant contributor to driving our financial situation was a degradation or loss of volume. And that's in large part because consumers have exercise their ability to use the alternatives, whether it's direct shipment through the interstate carriers, violation of the SIT pack, and or use of freight forwarders.
We received several comments, many comments actually, from your customers that state that they do not have options, and that's concerning. So these, indicating that that people are responding to price signals. I'm concerned that YB doesn't necessarily understand the magnitude of how essential their service is to the residents of Hawaii.
I completely understand the magnitude and the impact that we have. I guess to rephrase my comment, there are certain markets that don't have options. So particularly Molokai, Lanai, absolutely. We understand that, which is why even in the face of our financial challenges, when we initially discontinued the 2 sailing schedule to Molokai, we quickly reinstated and reconsidered that primarily because of our understanding of the limited options that those consumers have. They don't have an alternate port. They don't have the freight forwarder options that maybe the larger ports do, nor do they have warehousing in there or infrastructure in their communities to be able to handle and accommodate larger loads on a single sailing. So I want to reiterate that we do completely understand and are willing to, even in light of our current financial situation, and we will continue to bear losses to provide that vital service to these particularly remote communities. But ultimately, our concern is that we cannot continue to do that. It's not sustainable for us to continue to perform this service at a loss. And while our business is, largely the utility business is constructed on the ability to cross-subsidize and subsidize less profitable or non-compensatory services, ports, or whatnot. But what this pandemic has illustrated is that with the loss of cargo volume, which has been everywhere, but particularly on the large container volumes, that was a source of a subsidy for these remote locations that will never, quite frankly, have the volume to support and justify, alternates or alternatives. And so that is, I guess, a challenge that we're faced with.
Thank you. Chair, I have no more questions.
Thanks, Commissioner. Thanks. Good morning, Mr. Ana.
Morning, Chair.
Hopefully this won't take too long. So
okay.
I do want to touch on 3 areas, and just so you know where we're going, I want to just clarify a couple of points about the emergency rate relief request. Okay. Discuss the customer impact from the proposal, and just get some more insight and your perspective on your efforts going forward on managing your operating expenses. So first, just so we're clear, because there's been a few different numbers in different filings, based on the reply filing, when Young Brothers asked for us to grant the motion in full, you're asking for a rate increase of $26,997,928. It's that number. It was different in the prior filing, and it was, I think, a little different in what we received earlier this week. So that's, when you say the motion in full, that's what we're talking about?
Correct.
Okay, and you just, that's 46% increase in revenue?
I think the 26 million is a 34%. I think that percentage increase was the full 30 that was cited in our emergency application, but if the footnote identified that we are capped by the original general rate case docket.
So, okay, we'll verify this, but I believe in the IRs you submitted earlier this week, where we asked for the across the board percentage was 46%, but 34%, 46%, would you agree is still a big number, a big increase?
Correct.
Okay, just so also clear, what sailing schedule are we talking about? For motion in full.
Our motion in full is for a return to the full sailing schedule.
Okay, all right, so we're clear. Again, so despite the differing percentages, again, whether it's 34% or 46%, you agree that that's a big ask for customers at this point in time during a recession?
We understand that, yes.
In your perspective, what are they getting in return?
Our customers are getting the continued vital and important service that we've provided for many years. You know, again, Commissioner, we do not contend that it's not a significant rate increase, but we have not seen a significant rate increase for the better part of 8 years. And our service, at this point, the rates do not match the cost of providing that service. It hasn't for the better part of 3 or 4 years.
Okay, no, we understand that there have been losses. We'll get to it in a little bit about your growth and operating costs. I do want to touch on, and we can either put the exhibit up or I can read you the quote, but this is a quote from your reply to the consumer advocate on July 31st, page 4. It says, unless the commission grants YB's motion in full, YB will be unable to continue to provide the regulated services on which its customers rely. This will be negative not only for customers, but also for many of YB's valued and highly skilled workers who may need to be furloughed or laid off. So you're saying unless we grant it in full, you can't continue to provide service?
Correct.
Okay.
Yes, correct.
Just let me take this from a different angle. If we do grant this in full, how long is YB's commitment to serve?
Again, as we mentioned in the status conference, when we were pleading for that or talking about the roughly $27 million ask, we anticipate that cash would be able to allow us to operate through the early part of April of next year, May of next year. We've acknowledged and identified that we need both immediate, midterm, and long-term solutions to this problem. But the immediate need is for cash infusion. For us to meet the cash obligations, we need to continue our service.
So do I interpret that if we grant this in full immediately, we will repeat this discussion in April?
Well, we will, no, not necessarily as it relates to rates, but it'll buy us time to continue with, for example, the working group that is working through Senate Resolution 125 to identify alternatives and options for how to restructure the business. And it gives us time to work through that working group.
Okay, but what if we're in a situation where revenues are insufficient again? Would you expect to come back to this commission, ask for another increase?
I can't anticipate, Chair, that or promise that is not a possibility. As we all know, the rate making exercise is contingent upon forecasts. And so our forecast assumes a recovery. And so the revenue requirement that we've projected to recover will be contingent upon those forecasts coming to fruition. To the extent that they do not, there is a possibility that we will have to come back to the commission, hopefully through our general rate case proceeding, finalize I guess first to finalize our temporary to a rate increase to a permanent increase, but there's a possibility, but that is not our desired outcome.
So there's a possibility we grant this motion in full, the significant rate increase, and that you could come back sooner.
Sooner than.
Well, you said April before, but you're saying there's a possibility it could be sooner. There's no commitment for how long that.
There's a possibility for anything, but our current expectation is that would not be the case, that we would be able to operate with that. Again, our existing request does not account for any allowed rate of return. It basically gets us to a break-even position. In doing so, there's some inherent risk, meaning there's not a lot of cushion for us to operate and continue to generate and build cash flows in the event that something unanticipated were to occur. For example, with the pandemic, we did not anticipate that we would continue to have rising cases of COVID in the state. If the governor chooses to shut the economy down for an extended period, that would definitely have an impact on our forecast, and then it would definitely have an impact on our ability to manage our cash flows.
So that's understood, but I guess what I'm trying to understand is what is Young Brothers' commitment to avoid this continued exercise? We just agreed that this is a big ask of customers. Mm-hmm. What I agree with is that the continued service throughout the state is essential. But what I hope we can both agree on is that this is something we want to avoid for everyone. Significant rate increases during a recession, neighbor island customers living in fear of losing service. Can we agree on that?
I agree with that.
I think what we would hope is some greater commitment that this may happen again and it may happen soon.
A commitment that it may, I'm sorry, can you repeat that, Chair?
Or I guess what I'm hoping for is a commitment that we can avoid this exercise, both the rate increases. Mr. Ono talked about it. You guys said that your letter to us was not a threat, but you understood that when we received it would be a threat. I don't think it's just a threat to us, it's a threat to all the other people that you serve. So what we need to do is get out of this cycle. And if we grant the motion in full, I think what we need to have comfort with is that there will be a commitment that we move to a different path, that we're not just expected to grant whatever rate increase Young Brothers says is necessary. So
yes, Chair.
My question is there a commitment to that change?
Absolutely, Chair. I mean, our intent and our commitment is to prevent this from happening. I guess my comment previously was that, we don't have a crystal ball. And if we continue to operate, for example, with a full sailing schedule, but if the economy shuts down and we're providing all services of all lines with no commerce, we're not effectively generating the revenues and the cash necessary to operate our business. While we are a utility, we are not immune to the impacts of the pandemic, and we are not able to operate if we don't have cash to manage or to pay for our obligations.
And I think the commission understands that the state needs your services to continue. I think what we need to have a better understanding on is that we can't continue this cycle of people living in fear and expectation of continued rate increases. So I guess, again, I come back to the commission is to grant this in full. What is Young Brothers' expectation? What are your commitments to action that we can move on to a different path?
Yes, as I said, we are committed to identify and work through mid and long-term solutions. That is being led by Commissioner Asuncion. And through those conversations, we're working with all stakeholders for different alternatives and avenues in how to perform our service. We are committed to, if it's necessary, to look like a very, very different company, to adjust to the market conditions and the needs of our customers, to provide that service and ensure that that is not contingent solely upon rate increases. But the solution may require a complete restructuring and reevaluation of our business. But that we want to do with all stakeholders in mind, including customers.
Okay, no, we understand. I mean, the commitment on all sides of the working group is there. I guess I am still concerned about the shorter term. I mean, you talked about possibly this rate increase being sufficient through April. You know, if conditions change, what I think I heard is that it may be insufficient earlier than that. Is that so? I don't want to lose sight of the short term.
No, and again, Commissioner, I only said that because I want, my interest is to be transparent. So again, if the governor were to shut down the economy for say 3 to 6 months, those are not factors that we've anticipated. You know, we would see, even if granted a rate increase, if there's no consumers bringing product to us, we would have not yielded a rate increase effectively. So I was trying to emphasize that short of these types of you know, completely unforeseen and significant impacts, we believe we'd be able to continue to operate with the full rate requests even beyond the April-May timeframe. Does that clarify? I'm sorry. Hopefully I'm.
That's helpful. I guess it would be more helpful if you had the list of items that you're working on that would give us more confidence that that would be the case.
As I mentioned, we're not. You know, we are working with the working group. We had not finalized any specifics through that working group. We provided the commission, the consumer advocate, with some alternatives that we've explored, but no decision has been made as to whether those alternatives would be the ones or a solution or a combination of solutions that we would exercise in the short term or in the long term.
Okay, I just think one more question, just so I'm clear. If the commission were to grant the motion in full, we're talking about the full sailing schedule, but Young Brothers has no commitment for a timeline for staying out of any additional rate increase after this. So if you were to find yourself in financial trouble again, 4 months, 6 months, your view is you would need to come back to us for an additional rate increase over the one granted in the motion in full.
I believe we would need to finalize the general rate case application. I believe that is what the next step would be following granting of an emergency relief.
But can't you agree that it's preferable to avoid any further rate increases, especially after if the commission were to grant this?
Would be preferable to avoid? Yes, but I guess, Chair, I'm not sure if I'm understanding. The emergency relief is intended to be temporary. Wouldn't we need to finalize the general rate case application, which it's not on top of, but it's inclusive of this emergency motion?
I guess you're asking me questions now.
I just wanted to clarify. Sorry.
No, we would need to finalize whatever the final rates are, correct? But
correct.
The question is, the expectation if they're going to go up further, I think, is what we need to be clear about.
Yes, and I want to clarify and be transparent. You know, our request includes no rate of return. It includes, in fact, it includes no working capital component to it either. So at some point, yes, you know, in order to attain just and reasonable rates pursuant to the pact, we would need to, you know, come in for a rate increase to attain a just and reasonable rate. Part of this exercise is to ensure that the utility is viable and we can attract the capital necessary independently so that we can promote a more sustainable capital infrastructure, I think is what Mickey Knox had referred to earlier. But in order to do so, we need just and reasonable rates to attract continued investment and the ability to fund from third-party financial institutions.
But I just want to be, your primary perspective of achieving that is additional rate increase, not better management of your own cost structure.
It's the
There's
solution
two
is a
sides of the
combination.
equation right here. Okay. But
The solution is
we've only been hearing the one side.
well, I referenced the working group, and I believe on the record we've presented a number of alternatives that would manage costs and reduce our cost structure. And in many of those examples, it would reduce the cost structure significantly, which would benefit ratepayers from a price perspective. But there's different ways in managing benefits of the consumer, whether it's convenience of service as a single source that provides freight of all kinds, or a cheap alternative that is in combination with other service providers, ensures that commerce moves throughout the state. Again, there's a combination of alternatives. Rate is only one component of it, but there are different avenues that we can continue to explore.
Okay, just one more time. If the commission were to grant this in full, it's Young Brothers' position. If you need to, you would come back for an additional rate increase. There's no commitment to a period where you would take all steps to avoid that.
Again, Commissioner, I cannot, without knowing with certainty what the future looks like and knowing with certainty what alternatives we will pursue and work with the working group on, at some point, I guess we will need to ensure that we get just and reasonable rates to provide for an allowed rate of return. If that's managed solely through mitigation and cost restructuring, that would be great. But I believe that there is going to be some balance, and there's got to be a balanced solution that may require some rate modification one way or another.
Okay. That concludes my questions. Thank you, Mr. Anna.
Thank you.
You're excused now. Looking at the time, I think what we would like to do is call the next witness. We'll do our direct examination and then break for lunch. We'll probably have a little shortened lunch period, but we want to keep things moving. So Mr. Edwards is next. Sorry, let me flip forward. Can we have Christopher Edwards? Please stand and identify yourself. Looking on the screen. Oh, I see you up here. I don't see your video.
It's muted.
Mr. Ono, do you know where your witness is?
I mean, I see his name on the screen. I don't know where he is.
Okay. If we assume for now he is not available, can we move to, the next witness is Chris Martin. Yeah. Can we move to him and do the direct? I see.
I'm going to have Edwards come in my office. He was having his disconnection.
Okay.
Is that okay, Chair?
Yeah, that's fine.
I ran over. He got bumped off.
All right. I apologize.
That's okay. We're happy to have you.
Thank you.
Good morning. Please stand and identify yourself. And hopefully you heard the game plan here. We're going to do the direct, and then we'll take an abbreviated lunch. I know I promised an hour, but we're trying to keep the process moving.
Yes.
And then we'll start again. We'll start over after lunch with the examination from the CA. So,
Right.
yeah, Mr. Martin, I'm going to read the oath here. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. Mr. Ono, please,
Proceed.
you're conducting the examination?
Yes, thank you,
Please.
Chair.
Please proceed.
Please state your name.
Christopher Edwards, Director of Finance and Treasurer for Young Brothers,
How long have you held that position?
for 2 years.
Was the 2020 test year rate case prepared under your supervision, the revenue requirement?
Yes, it was, me and the team.
Okay. And did you also prepare the rate increase for the motion for temporary and emergency rate relief?
Yes, I did.
Could you
Under my
briefly describe the process to determine the rate increase for the purposes of the motion for temporary and emergency rate relief?
Sure. Generally, we took the original filing from 2019. We took the budget of 12.3. We took the test year of 13.4, and we added 8 RMAs, or rate making adjustments, to the emergency motion. Those RMAs are shown in Schedule A-06. We didn't take an off. Go ahead.
So is there a rate of return built into the temporary rate increase?
No, there's no profit component or ROI component in this revenue requirement. We're just simply looking to break even.
And why didn't you include a profit or rate of return in the temporary and emergency rate relief request?
We know this is a big increase, and so we're looking for a balance between our utilities, sustainability, and the consumer.
And can you tell us, Mr. Edwards, why cash flow is an inappropriate means of solving Young Brothers' financial problems? Why a cash flow analysis is inappropriate?
Yeah, I think what I'd go one step further, and why can't you derive a cash flow analysis from a test year P&L? And I think that's the important concept here. And I think the first point here that I'd like to make is that normalization rules in the test year aren't conducive to a cash flow analysis. You're spreading out across 12 months, basically a law of average. And there's also a lot of temporary proposals in there that we haven't seen savings for as well. And so, but most importantly, I think this is what I want to highlight here, is that there's no working capital component in there. And so when I say that, we've incurred, and Jay said that the obligation is about $6 million. It's actually about $7 million to the Department of Transportation Harbors. So we have an obligation that we have to pay there. We also deferred our pension cash contribution via the CARES Act at $5.6 million in December of 2020. That's not included in this P&L analysis. And then there's also some capital that we ordered before the pandemic that's going to happen in Q1 of 2021 that we have to save up money for. So no, you can't derive a cash flow analysis from a test year P&L.
The consumer advocate suggested to the commission that $8.6 million in a revenue requirement would cover your cash flow needs. Do you agree with that?
No, it's just not enough. Right now, we're burning on average about $1.5 million in cash a month. And if we implemented $8.6 million rate increase, that's roughly $700,000 of cash on a monthly basis. There's also a lot of risks in our forecast right now, and that's one of the things I want to highlight too, is we've projected a recovery in Q3 and Q4 for our Hawaii communities. And so to the extent that we do not recover, to the extent that the quote swoosh becomes a whoosh and goes back down, we also carry a lot of risks there.
Okay, nobody is going to know what you're talking about when you say swoosh and whoosh. You're going to have to describe those graphic descriptions a little better for us. Can you do that?
I can. So what I mean by a swoosh is that's what we currently have in our volume forecast. We have the bottom at April, May, and June, and then coming back up like a Nike swoosh, coming back up in Q3 and Q4. So embedded in our forecast is a recovery for the Hawaiian state economy. And in that recovery is the recovery of our volumes. To the extent that we extend out a shutdown, or the extent that we continue this quarantine, or that we have bankruptcies that go on through the community, that could become a W recovery, and we could go right back down. The recent COVID cases, yesterday was 355. It doesn't look favorable for us to continue that swoosh or that recovery in Q3 and Q4. And that's the risk that I'd like to also point out to us as we get into these last 2 quarters.
Now, in coming to this $8.6 million amount, the consumer advocate removed over $14 million in cost savings items from Young Brothers' own financial statements to mitigate these financial losses. In your opinion, Mr. Edwards, is it appropriate to remove these cost savings items?
No, these are temporary savings that we have, that we had shown in our considered adjustments. A big one of those is the 9.4 for the sailing schedule modification. To the extent that that 9.4 can be somehow made permanent, we would consider that as part of a solution for reducing this revenue requirement. But as of today, it has not been, it's still temporary. Also included in there are some savings that we have via our contracts, and some savings that we've had for temporary reductions in headcount that we can't sustain. There's also some deferred maintenance in there that would affect the safety and service reliability of our tugs.
The consumer advocate says that the forecasted revenues for the temporary and emergency rate increase does not include the Matson cargo volumes from a recently negotiated connecting carrier agreement.
Yes.
Matson is an interstate shipper, is that correct?
That's correct.
Why is it inappropriate to forecast the Matson cargo volumes based upon this new contract and include it in the revenue requirement?
We viewed it in the same way. Without a strong long-term agreement, we just don't know how to project that into a normalized year. It's just a 90-day contract.
Yeah, I just have one last question, Mr. Edwards, and the same question that I asked Mr. Ana. Can you tell us from your financial point of view, how dire is Young Brothers' financial condition?
We don't have the cash to pay our current liabilities. We incur, like I said, about $1.5 million in cash operating drain, and we don't have compensatory rates at this point in time to sustain the business. So when you look at it from the very near term to the short term to the midterm, the outlook isn't very good.
Okay. I have nothing further at this time. Thank you, Mr. Edwards.
Okay, thank you. We're gonna do a couple of, as I said, I think we will take a break for lunch. I do want to ask counsel here, obviously we have 8 witnesses today. Simple math would say we're behind for lunchtime. How do you foresee the pace of the afternoon going? Can we expect something similar? Can we expect maybe faster? Can you give us any insight? Just one, I want to make a decision over how long to allow us to eat, and then 2, give us some insight into how the afternoon's going to go.
I don't control the cross-examination, Chair, so I think this is directed at
you do for 2 of the total witnesses, or you're.
I'm going to start.
Okay. Yeah. Understood. I guess Mickey and Lane, can you give us just what your plan is? I'm not asking to change. I'm trying to get an idea and plan. Let me be clear about that.
I expect my cross of Mr. Edwards to be a little shorter than my cross of Mr. Ana, and my cross of Mr. Martin to be a bunch shorter.
Yeah, and I'm going to be responsible for the other two witnesses, and I think at this point in time, at least for Dr. Brubaker, I know for certain that it's not substantial, and for the cost of service element, I think it shouldn't be that long either.
Okay, well, you guys just have talked yourselves into extra 15 minutes for lunch. So we'll go 45 minutes for lunch. We'll come back and what time does that put us at? 11:40. Sorry, 12:40, right? We'll resume here at 12:40. Thanks, everyone. Thank you for the morning. And Dave, are we exiting or are we just all going on mute and turn our cameras off?
Yeah, I think just go on mute and turn off your camera, and the stream will continue. And then when we resume, the video will turn your video back on.
Okay. Thank you, everyone. We will resume again at 12:40.
Yeah.
See you then. Thank you.
Thank you.
Hi, this is Jay. We're getting everything ramped up again. So here we go. Yeah, those of you ready, please tune in. Looking for my colleagues. Hi, Commissioner Potter. There's Leo. Commissioner Sancian. Dave, how are we doing with the YouTube?
Good, we're still streaming, so.
Okay.
How do I look, Dave?
As good as ours, yeah.
You're gonna have to go to YouTube and find out for yourself. We're not gonna answer that question. I object.
You
Like
look
an
at
elder statesman.
Can I answer?
you look at dapper as usual, Mr. Ono.
Thank you, Leo.
You're representing the Kapuna generation here. I did want to say, for those of you that may have caught my math, I want to say before we had cut out, I was preparing to cut lunch down to 30 minutes. And so that's why we got the extra 15. That's how we got to 45.
Appreciated.
Okay, so we have all sides here. Mr. Edwards, are you ready to go?
Ready to go, Chair.
Okay. We'll call the hearing back to order. And we'll begin with the cross-examination of Mr. Edwards by the Consumer Advocate's Office. Thank you.
Okay. Good afternoon, Mr. Edwards.
Afternoon.
I hope you and your family are staying safe as well.
We are, thank you.
I wanted to quickly cover some points that were already brought up. You mentioned a 1.5 million per month cash burn rate.
Yes,
Is that total company?
that's total company.
Thank you. And you talked about the correct and incorrect way to go from a revenue requirement to a cash flow analysis.
Yeah.
If you point out working capital and normalization of certain expenses, are those the main differences?
Yeah, and I think if you would look at it, sorry, were you done, Mickey?
Oh no, please go.
Okay. Yeah, I think if you'd look at it from a working capital, and working capital meaning that, you know, working capital is the same as what we talk about when we talk about harbors, the obligation that we've incurred.
Yeah.
And that's now at $7 million. The normalization is another one. The cash contributions to our pension plan, and then it doesn't include capital. You know, and I think we've been pretty explicit that we're taking that off the table, but it doesn't allow us to save and spend on capital.
Yeah. So if things like cash working capital and normalization are accounted for and adjusted, can a cash flow analysis be accomplished?
I think I think you could I think if you used the cash that we were projecting for the pension plan, if you use the cash that we're projecting to having to pay back and step into it, if you considered, then you have a cash flow analysis. And I think that was my point. And when we got into this, is that it's very difficult to derive a very simple cash flow analysis from the P&L that's on the test year.
Mm-hmm.
And I think one of the things I'd like to highlight too is, in a normalization, we normalize those volumes, right? That expected swoosh recovery that we keep talking about. Well, right now, as of June, our volumes would have to increase roughly 5.7% just to get back to that average. You know, so we'd be short because of that normalization. Just as a more specific example.
Okay, thank you.
Yep.
About the 8 to 9 million intercompany payments for the new tugs. Yeah. What period are those 8 to 9 million for? Is that quarterly or monthly?
So I'd like to clarify what that is. And so it's not necessarily for the tugs. It's not necessarily for anything specific, but previous to June 1, cash was swept out of Young Brothers accounts up through Saltchuk Marine and up to SRI. That cash stream is what we're talking about. That's a deficit to Saltchuk Marine of $9 million. It's for the tugs. It's for our operating losses that we've incurred over the last 18 and 19. 18 we had negative cash flows from operations. 19 we had negative cash flows from operations. So it's just representative of the continued deterioration of Young Brothers, not necessarily for the tugs.
Okay. Mr. Anna talked about the cash obligations needed to continue service. To the extent that you can comment on that, do the cash obligations necessary to continue service include that 8 to 9 million?
Do the cash obligations to...
When you represent to the commission how much cash you would need to continue obligations.
That 8 to 9 million doesn't get paid back in anything we've provided to the commission or for any presentation here.
Okay, thank you.
Yes, absolutely.
Yeah. Would you refer to Young Brothers' reply filed on July 31st?
Sure. What page?
It starts on 51, but really it's a list of adjustments going from 52 to 58.
Sure.
These were cost reductions that that the company said that they were not including.
Correct. Okay.
Quote, the adjustments excluded by Young Brothers are not expected to be representative of the company's operating expenses under normal ongoing operations.
Yes.
You mentioned a few of those, such as the vendor price reductions, hiring freeze, sailing schedule reductions, and the maintenance and cost deferrals.
Yes.
There are a few other large ones. I just wanted to mention them and ask a question or two.
Sure.
There was a little over $1 million for the suspension of payments to DOT. There was $660,000 for the reduced allocated charges from FOSS. And there was about $175,000 for the merit raises for employees.
Yeah.
I wanted to ask you, so were these savings, were these cost reductions helpful to Young Brothers in conserving cash and continuing its operations?
So let me speak. I'll speak to all three. I'll pick each one and we'll go through that with that question. The reduction in storage is really just a timing thing. So from a cash standpoint, that hasn't been beneficial to the company just as of yet. The $660,000 of shared services reductions is something that we continue to work with FOSS on as we look to try and reduce that for the business and for the ratepayers. And then the 175 is a reduction of it was the foregoing the 3% merit increase, and I would say that has benefited the company fiscally, but it would be short-term fiscally as we try and attract talent and maintain our position as an employer in the state.
Okay. Which of those have produced actual cash that the company has been able to use to continue operations? Is there anything that you can point to?
I would say only, Mickey, that the 175 would be the only one that has really affected a cash stream and then has now been turned off.
When you say that, are you including the four that you mentioned earlier, the sailing schedule reductions, the maintenance cost deferrals, hiring freeze and
Oh.
vendor price reductions?
Sorry, I was just talking about the same three that we were talking about earlier. I would say that the sailing schedule adjustments, the modifications that we've been allowed to do, have seen tremendous impact to our bottom line. And so when I talk about the way that we've been able to survive, at least up to this date, has been that ability to pull that lever. That's allowed us to get up and underneath some of this heavy COVID economic impact. That would be the biggest one that I would say to date has affected us.
Okay. Thank you. So up at page 30 of the reply, it states, quote, acknowledges that YB has presented a cash flow analysis that reflects the declining cash balances as support of the company's dire need for temporary rate relief, end quote. Can you confirm that the company did, in the June 10th status conference and in discovery responses since, characterize this emergency as being a cash flow problem?
Yes, we would have called that a cash flow problem, derived from a P&L problem, right? Your cash flow problems are derived from losses on the operations, continued losses, and in many ways exacerbated losses because of this COVID impact.
But then why in the reply does Young Brothers say, quote, thus performing a cash flow analysis to support the determination of the increase to which Young Brothers is probably entitled is not consistent with generally accepted rate-making principles, end quote.
Yeah, I think the way I'd classify that is when we talk about what's happening with the business, we've had a sudden financial need, right? And that's a cash need. But under where we are today and talking about temporary rate relief, we need to go through the prism of looking at, again, the test your P&L and saying whether or not it's the probable entitlement, or whether we've displayed significant financial need. And I think that's why we would categorize it that way for this presentation, rather than an update of financial stability and what we see going on with our bank accounts. Does that help?
Yeah. Yes. And just to get one little iteration on that. So just to confirm, is the company still in a cash flow emergency in your view?
The company is in a cash emergency. Yes.
Okay.
Financial emergency.
What is Young Brothers' actual total company cash position as of July 31st, or the most recent date that you have?
Yeah. As of this morning, it's around $6 million.
Okay. And given the 1.5 million per month cash burn rate that you mentioned earlier,
Yes.
do you have an estimated cash deficit date?
So we have, if we paid all of our debts today, all of our obligations, our cash balance would be negative $1 million. That, so like I said before, we have an obligation to Harbors of $7 million. We have $6 million of cash in the account.
Yeah.
So I think the trick that we have and the timing that we have is that we cannot float like this in a period of time that's longer than, a couple, 45 days or whatever that is. That it's unsustainable. It's patently unsustainable.
Okay. Do you have contingency plans? Without financing from Saltchuk, do you have plans to borrow cash past your cash deficit date, if and when you can no longer float like this?
I think, like Jay said, when we went to seek a third-party financing, the feedback that we received and why the no's was that we could not prove a path forward to pay that back. And I think that's a like we were saying, it's a reasonable business decision as a bank. Mm-hmm. And so for us to go out and get a loan at this point in time is they say always get a loan when you don't need one, because when you really need one, the banks will say no. And I think that's likely true in this situation.
Yeah. Sorry, that was informative, but just I wanted to go back to the specific call on my question. So do you have contingency plans in place?
We don't have a plan, a financial plan much past this.
Okay, thank you. Let's see. Just wanted to go into some specific expenses. Page 22 of the reply, Young Brothers mentions, quote, the CA proposal fails to include all costs that are being incurred to process the general rate application, which are not expected to significantly exceed the projected amount set forth in the general rate application, end quote. First, isn't it true that the consumer advocate did not actually propose excluding any rate case expenses?
That's true. Yeah, and in the 14 million that we presented in our emergency motion and the exhibit A, or exhibit B, I'm sorry, when we talked about the temporary cost savings and the considerations of the temporary cost savings, rate case expense was not in that one.
Okay. And in Young Brothers' response to CAIR 377, there is mention of the $694,000 of rate case expenses that the consumer advocate would allow for recovery. Yes?
Yes.
And in Young Brothers' last rate case, Young Brothers was allowed to collect $642,702 in annual rate case expense, annualized.
Mm-hmm.
Is that correct? To your knowledge?
Yes. Yes, to my knowledge.
So using either of those two amounts, being fairly close to each other, would you agree that Young Brothers is recovering more than $50,000 per month in approved rates for rate case expense?
Generally, that's the way the math works out. Yes.
So far, what is the?
I'd say that if we maintain the volumes from the 2018 rate case, and we are not, so.
There. Yeah. Do you know what is the total accumulated rate case expense so far for this rate case?
I believe that we filed this an update in one of these responses. I don't offhand, but if
okay,
if you have knowledge.
Does the rate case expense that Young Brothers has incurred with QSI Consulting relate primarily to the development and documentation of Young Brothers' proposed new cost of service allocation model?
So quite a bit of the cost of service model development has been capitalized. So as we think about that's internally developed software that you can put on your balance sheet and go that way. So we separate the invoice from QSI into different tasks. Some are not rate case related. Some are specifically rate case related as it relates to Mike's time today. But the development from the programmers, for instance, the work that's been done to build the working model, that piece of software is not included.
Okay, thank you. Wanted to just quickly go back to cargo volumes. Does the company have any forecasts of 2021 cargo volumes and revenues at this time?
At this point in time, what we've forecasted is an outline of a continuation of where we see that swoosh ending up from Q4 and just a continuation. I think Paul Brubaker may testify later on the outlook and the economic outlook of 2021. I think generally Young Brothers' economic outlook of what 2021 looks like is very similar to what 2020 is. Without a vaccine event, we're going to be in this for a little while.
Oh, okay. Do you know, just like a top line number, what Young Brothers' current best estimate of 2021 interstate revenues will be?
I don't have that offhand, but happy to provide it to everybody.
Oh, sure. Thank you. Looking at Young Brothers' response to CAIR 374, Young Brothers provides some information about the revenue gains arising from Young Brothers' agreement with Matson. And you heard Mr. Anna respond just previously about that.
Yep.
Just one question. At least for the rest of the 90-day period in which the agreement is still in effect, what are the positive revenue impacts of the increased cargo volumes provided in response to CAIR 6 in docket number 2020-0084? I believe that's been touched on already. Do you know what the positive revenue impacts from the Matson agreement are?
So when we signed that, again, there was no volume guarantee, but based on conversations, we expected to receive about $300,000 a month in additional revenues.
And have you been?
We've received, like Jay said, we've received more automobiles than we have. I think we've received less boxes than we expected.
And the actual revenue impacts have been more or less than the 300,000 you expected?
They've been right at or below.
Okay. My last line of questions, in response to CAIR 375, Part F in particular, the company was asked to say with specificity what is now proposed by Young Brothers with respect to rate case completion and the proposal steps and dates that Young Brothers is currently recommending. In the response, which you are a sponsor of, it states, as a first step, and if leave is granted by the Commission, Young Brothers recommends that the CA file its testimonies as contemplated as part of the original procedural steps on Young Brothers' request for general rate increase as soon as possible. After that step is completed, Young Brothers would be in a better position to confer with both the Consumer Advocate and the Commission on further lifting the suspension period, recommend further steps and dates with respect to the rate case completion, end quote. I wanted to focus just a little bit on your suggestion that the Consumer Advocate file its testimonies, quote, as soon as possible. Should the Consumer Advocate rely only on the company's initial filing that has been working with for months and ignore all of the much lower revised cargo volumes and revenues estimated that were recently submitted?
So I would like to, when we get back into this general rate case proceeding, I would like to update our volume considerations. That's going to be critical for this, the GRC.
So would you characterize the 2020 test year, how you'd like to update it, as a blend of the pre-COVID and post-COVID months and the revenue impacts and cargo volume associated with those?
Yeah, I think we would like to take an evaluation of what does a normal volume year look like, and I think what we're starting to see is a better picture of that, and that's what I think that we can have. That's why I would like to go and update those volumes. Yes.
And along with those updates, should revenue updates from, for instance, the Matson contract be assumed to be in place for 3 months, 6 months, or some other period?
I think we might have a better view of it as we get in through the year. Right now we don't. Right now they are temporary.
Should the cost savings that are listed in the company's reply be assumed to be in place for part of the test year, all the test year, or should they be completely ignored?
I think it like I said before, I think if we were to able to make more permanent the sailing modifications, I would agree to providing those savings into that test year.
Mm-hmm.
But as these go from 30-day approvals, I don't think that that's appropriate to push into a normal test year. Those savings.
Okay. So if any of these revised cargo volumes, revenues, or expenses are included, if there are any updates included, should the Consumer Advocate have an opportunity to conduct discovery on those updates? and to test and verify amounts forecasted to develop alternative forecasts?
Yes, I believe that's fair.
On page 49 of the reply, Young Brothers provides a table comparing interest rate operating revenue levels at present rates in the general rate case application versus in the motion. There is about a 13.7 million revenue reduction shown. And I might be able to share my screen because that is probably one that's more useful. All right. Let me try. Oh, no, I'm sorry, I can't. Do you remember the table? Page 49?
This is Lane. I'll share it. I have it available.
Yeah,
Thank you.
that'd be
Thank you.
helpful.
Yes. Thank you, Lane.
Okay.
Are all of these amounts 2020 test year forecasted revenue amounts?
Are all of these amounts forecasted test year amounts? In what way? Sorry.
Are they all forecasted for the 2020 test year?
You've got so let me just break it. Let me separate them a little bit.
Sure.
The Exhibit G was what was filed in, I think it was September 23rd, 2019.
Mhm.
That was our view walking into the 2020 year, and what was filed in 2019-0117.
Yeah.
The Exhibit A is an updated view of the emergency motion and the revenue requirement derived from an updated view of revenue in a COVID environment. Yes.
Okay. So that was the updated forecast for the test year.
Updated forecast for, yes, for the emergency motions test year. Yep.
Okay. And that column A, is that based on several months of actual 2020 data and then a revised and much lower COVID-19 impacted cargo and revenue budget for the later months? Is that how that was derived?
Yes. So the Exhibit A is derived, and I think off the top of my head, I don't know if I think we just had May actuals, and that was derived, I think is Jay hinted at, using a simulation study, that a Monte Carlo simulation study that says, how bad can these commodity codes get? What is the likely scenario, and what's the best case scenario, knowing what we know today? And then we pushed in some linear regressions and some data points that said, effectively, in working closely with Dr. Brubaker, we worked into a swoosh recovery. So what's maybe miscategorized there, Mickey, is that this does include April and May's trough of actuals. Coming up from April and May's actuals is a strong recovery in Q3 and Q4 in our forecast. Does that make sense? So
yep.
We think that, you know, and when we put this together, we think that we thought that Q3 and Q4 would come back. And to kind of give you that feel, COVID volumes right now that Jay was talking about, at the trough, they were 30 or 40% down year over year. Our entire 2020 year that we're seeing right now is 14% on the interstate side, 18% on the intrastate side down. And so there is a recovery built into from the COVID depths built into our forecast.
Okay.
I think that's an important thing to know.
Okay.
And a risk, and a pretty strong risk.
Yeah. The Exhibit G column, there is a row heading total operating revenue, and the amount is about 78.8 million. total operating revenue estimate. See that?
Yes.
Is that number and the associated cargo volumes what was used to determine the revenue requirement and determine the jurisdictional allocations in the company's initial rate case filing?
So there's a 74 of freight revenue, and then there's the other operating revenue.
Yep.
The 78, 783 is what was used. I'm sorry, it's not what was used. It was the output of the JCOS, the jurisdictional cost of service study, the model. So the 74 is what came out of the model.
74 is what came out. So was the 78.8 the input that produced the 74?
I think as we look through the jurisdictional allocation of some of those other operating revenues, some of those are going to be strongly one way or the other, and interstate or intrastate. Yeah.
Okay. Which of the forecasted revenue amounts in the table on page 49 are now believed by Young Brothers to be reflective of normal ongoing conditions for rate making purposes?
So the best view that we have today is Exhibit A, is column Exhibit A.
Is that the same for forecasted expense amounts?
That is the same for forecasted expense amounts, the 95, 478. It's the best view that we have of today.
Okay, my last few questions. Back down on page 51, and I'm not sure this needs the screen. So YB states in regard to consumer advocate adjustments, quote, the adjustments excluded by Young Brothers are not expected to be representative of the company's operating expenses under normal ongoing operations, end quote. Is it your view that Young Brothers is seeking emergency rate relief because it is experiencing right now at the present time, quote, normal and ongoing operations, end quote?
Let me reframe it so I understand what you're asking. Do we believe that emergency conditions of this situation are reflective of ongoing operations of the business?
Yeah, are you seeking emergency relief because you're in normal ongoing operations right now, in normal ongoing conditions?
I think normal ongoing for the foreseeable future is a better way of saying that. We are experiencing immediate financial need because of a pandemic that hit our country, our world, the state, our economy, our business, our customers. That has put us into the new reality, and I think that new reality is going to last more than a couple of years. And I think that's what you're asking, is if this COVID pandemic will be lasting a little while, and I suspect it will.
So the normal and ongoing operations are the decreased cargo volumes and
Yes.
all of the operational changes and associated savings.
It is ongoing operations, and to the extent that some of these savings are unsustainable or are not permanent, then that's reflected in our Exhibit A. I think what we've been consistent about is, to the extent that we can make some of these things a little bit more permanent, we would be willing to include a lot of those, like that 9.4 of the sailing schedule modification. I think if that could become more permanent, we could include that into our test year, because it would be reflective of a normalized of the ongoing futures. But at this point in time, we can't do that at this point in time.
But if they became more permanent, you could?
We would be agreeable to that. Yes.
And if like the Matson agreement and its revenues became more permanent, you could include that?
I think that's a fair approach, Mickey.
Yeah. This is my last question. If new permanent rates are not likely to be effective until late 2020, would most reasonable approach to the rate case be dismissing the pending rate case and preparing a new 2021 revenue requirement calculation? Would that yield a more accurate test year projection?
I don't think so. I think I'm able to just leave it at that. I don't believe it would. I think you'd have the same uncertainties that you have, that you guys are considering today. And it would delay. To the extent maybe we get, to the extent that maybe we get some emergency relief, and it gives us some time to think, to retool. But I just don't think that that's. I think the most reasonable path is to move forward with this 2020 test year and let's close it out. We've done 400 IRs so far. We've gone through all of this discovery. We've worked together for so long. I think that we owe it to ourselves and everybody in this room to knock that out and get that complete.
Okay. Well, thank you for your time today, Mr. Edwards. Chair, the Consumer Advocate has no further questions of this witness at this time.
Thank you, Mr. Knox. We'll go to Commission Counsel Carolina Shida.
Thanks, Chair. I have no questions for this witness.
Okay. Commissioner Asuncion.
Yes, thank you. Thank you, Chair. Good afternoon, Mr. Edwards.
Good afternoon, Commissioner.
I just have, and I think these are more clarification, confirmation of what has been said already. We talked around what the current financial condition. This is with Mr. Anna, and he rifled off what was the losses in 2018, 2019, right? 10 million, 11 million, and then a projected pre-COVID 13 million in loss. And then we got to, I guess post-COVID, projected getting as high as 30 million. Clarify for me again, was that total company or just intrastate or?
Yeah. That's a good question. When we were talking about those audited losses, and I think what was important in that is we get an external audit from a Big Four, from Ernst & Young every year. And the audited financial statements coming out of 2018 was $11.4 million loss. 2019 was a $10.3 million loss. And as we stepped in, our budget was $12.3 million loss. And that did get, I think it got upwards. We were projecting $26 million. And it's, because of some tools we've been able to, some of the savings that we talked about in the temporary savings. And to some extent, to the Matson arrangement, we've been able to get that down to about 22.5. That's total company.
Total company. Okay, yep. Thanks. And then I think Mr. Anna kind of punted to you to confirm on when the intercompany payables, when did that stop? And I think he offered May 2020, and then just for you to confirm that, or otherwise.
That was what we talked about, where it's more of a sweep, and I'd call it a scoreboard of how much cash has come down or how much cash has gone up. It's more of I'd call it maybe more of it's a trade payable and receivable account, but it's more of an equity account that cash goes up, cash comes down, and right now that's at a $9 million payable from Young Brothers up to it. So what that represents is that's a deficit for the Salt Chuck Marine fellows.
Okay, and thank you again for bringing the obligation on the wharfage fees.
Yeah.
The actual number of 7 million. Mr. Chair, that's all the questions that I have. I'll yield back.
Thank you, Commissioner. Commissioner Potter.
Thank you, Chair. I have no questions for this witness.
Okay, I just have a few. Mr. Edwards, there was a statement, I want to make sure I don't get this out of context, and it did draw a red flag for me though. I heard you in response to Mr. Knox say that you do not have a financial plan past this.
Yeah.
What, can you give us context for that? Or I just want to make sure I don't take that out of context.
I don't think you can take it out of, we don't, we're working through this path with you guys. And we're hoping to be as successful as possible with you and the community here. There aren't a lot of options for us, and I want to highlight that outside of this. And so, so when I say that there's nothing from this desk, from my understanding, that's what I meant by that.
Can you remind us of what your title is again?
Director of Finance and Treasury.
So you're the Director of Finance and you're saying your company has no financial plan past this?
We're hoping for a successful outcome here, Chair.
Okay. I got two other topics. So you're, if I'm understanding right, in your projections, you've baked in your revenue projections, your cargo projections, recovery in quarters 3 and 4.
Yes, true statement.
And so I guess, kind of following up on my earlier conversation with Mr. Anna, what if that doesn't occur?
Mm-hmm.
I mean, you're making statements to that effect.
There's risk in the COVID environment, or in this pandemic environment. I think is better categorized.
So
there's downside risk. Yeah.
Could that mean as soon as Q3 and Q4 you're back sustaining? If we were to approve the motion in full,
yes,
but recovery doesn't play out as you have the basis of your information, we could be back in the same conversation as soon as Q3.
Let me highlight this, and maybe this can make you commissioners feel a little bit better. We at Young Brothers, and particularly as the Director of Finance and Treasurer, I don't ever want to be in this position ever again. Finding ourselves in this financial position and coming to you guys asking for the percentage increase that we're asking for at this point in time, we can't do that again. And so what I fully expect is that we would be able to float enough if we get this increase to where we're not asking for something as large as what we are today.
I'd like to believe that, but you just told me you don't have a financial plan past this.
That might be a misrepresentation of what we have ongoing.
That's why I wanted to ask for the context.
Okay.
But do you understand the alarm?
Let me tell you what we continue to do. So I hear you. We continue to work with vendors. We continue to work with our people. We continue to work to become more efficient. We continue to provide better service. We've cut our capital. We're trying to get underneath all of this pandemic and the associated economic consequences of the pandemic. So on our side, we're going to continue to work through. I think what you've seen is the savings that we've been able to work through. We're going to continue to work with our workforce. We're going to continue to work on everything that we can to get underneath this. That's the financial plan. There are things that are out of our control, and then I think that are in the economic environment today that make a promise that, if we were to get in a situation where we were in a shutdown again for a quarter, we don't have a financial plan to address these we don't have a financial plan like that. That puts us in a very similar situation. But if we were to say that our projections, that the optimistic projections that we have on our swoosh are off by a couple percentage points, I think we have a plan to work underneath that. Is that a better way of framing it, Chair?
What I take from that is, yeah, if the recovery trajectory is a little bit faster, a little bit slower, it's one thing. But right, let's be honest with that. We're seeing the highest number of cases we've seen here yet. We know what we're anticipating in the coming weeks. So we're probably
Yeah.
Okay. So does that take us back into the no plan territory?
I don't think that it's a no plan, but I think it's where it's are we prepared for what the pandemic can cause us for additional if there's a second wave. I think it's our job to be as forthcoming as possible, and that's all I think I think that there is risk in the economic forecast, like you said, with the 355 yesterday, the 200 today. I think we are looking at a spike. Will we be able to withstand that with emergency rate relief? I think we could, but I also want to be as forthcoming as possible that.
Okay, I'll just close this line of questioning. One more on this. When I asked Mr. Anna earlier, he was talking about if we were to prove the motion in full, the projection was that should sustain things through April. I mean, what I take away from this is it could be substantially shorter. So that very serious concern. Part of that is so the question of the Matson contract has come up a few times.
Yeah.
And I get it. You can't plan until it's more permanent. It's hard to plan into your forecast, but I want to know, what are you guys doing? I mean, it sounds like it's been a successful piece of new business, and in this environment, you should be seemingly aggressively pursuing that. So can you share with us what you're doing to make that more sustaining? Because I'll be honest, what I kind of heard was a fairly dismissive attitude towards it so far.
And I apologize if I portrayed that tone. I think the tone of dismissal was just, should we have considered it for a test year? The answer to that is not at the moment. We continue to work closely with our Matson counterparts and value that relationship as they look at they're under the same pressures that we are as they look at their cost structure and their offerings. We're hoping to work closely with them to be that provider to really, what I would say is return to that fruitful relationship that we once had. And so we continue to seek that, and we'll continue to aggressively seek that.
Okay, thanks. Those are all the questions I have. Appreciate it. Thank you, Mr. Edwards. You're dismissed. The next witness we have is Chris Martin. Chris, I was told you're ready and on deck. There you are. Okay. Okay. Rolling forward. Or actually, should I check with our Kapuna contingent here? Do we need to take a break?
Thank you, Chair, but no, I don't need a break.
Okay. Okay. Sorry, couldn't help you. Okay. Next witness is Mr. Martin. Chris Martin, please stand and identify himself before I proceed with the oath.
Chris Martin, sir.
Okay. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Thank you. Please proceed with the direct examination.
Thank you, Chair. Please state your name for the record.
Christopher Kai Martin.
What is your position at Young Brothers?
Director, Terminal Operations.
And what does that mean, Director of Terminal Operations? First, what are terminal operations?
So I'm responsible for statewide shoreside operations specific to or related to barge load and discharge. So my responsibility is everything on the shore. I'm not involved in anything on the marine, so not involved on the tugs or barges. My team manages our highly skilled workforce. Our workforce is who processes cargo into our facility, throughout our facility, and onto the neighbor island ports.
Okay. You talked about shoreside operations being barge, load, and discharge. Are there operations, shoreside operations that go beyond barge, load, and discharge?
There's maintenance. So there's a shoreside operation that is our M&R department, so our maintenance and repair.
Well, how about things like billing, customer service, documentation? Are those considered to be part of shoreside operations?
Yes, they are.
And are those part of what you call barge, load, and discharge?
Correct.
I'm sorry, what you said that?
Yes, they are.
Okay. And on the receiving side, when cargo gets to its destination, after the discharge, are there activities that Young Brothers is engaged in that goes beyond just taking the cargo off the barge and putting it back putting it on the dock?
Yeah, when we discharge a vessel, we obviously have to notify our customer, but we also have to stage it in our terminal. So we have staging areas, and as you know, we move freight of all kinds, so we have to sort through cargo like livestock, make sure they're safe and secured, separate the has and non-has, refrigerated container and dry container. And once those containers or cargo is situated in our terminals, we contact the customer, and then we continue our process of allocating that equipment. At the same time, on our barge days on the neighbor islands, we're also receiving cargo at times, primarily our straight loads, and so we can actually load back full container loads back to Honolulu. On top of the full container loads, we also move empty equipment. We rely on the barges returning from the neighbor islands to replenish our inventory in Honolulu so we can continue our weekly sailing schedule to all ports.
Okay, I want to bring up and discuss with you an issue that the consumer advocate has raised. The consumer advocate is saying that in our cost of service model, in order to divide up the expenses for shoreside activities of consolidation, documentation, billing, and customer service, that Young Brothers should be using piece counts as a proxy for allocating costs between interstate and intrastate. You're aware of this issue?
Yes.
And can you tell us first of all, what a freight bill is?
A freight bill would be documenting the type of cargo and the piece count of what we're moving. So if I can answer the question, Jeff, the more accurate way to allocate those costs would be a freight bill. And the reason I say that is for our interstate customers, there's multiple containers on a single freight bill. Whereas on our intrastate or our regulated customers, for the most part, their piece count and their freight bills kind of are one for one. So it's not accurately represented if you go off of piece count.
Can you help us? Can you draw a picture for me? Without drawing a picture. So on the interstate side, can you describe the kind of customers you tend to service on interstate compared to intrastate?
Yeah, so for interstate, so for our non-regulated customer, I'll pick Costco. Costco going in the Big Island, we'll move, let's just say 30 containers. Some reefers, so refrigerated cargo, and then some dry, non-perishable cargo. And they'll come in on a single booking with multiple containers for that customer. Our regulated customer, our intrastate customer, could be, let's just pick the same island, KTA, and they might have just one 40-foot container of groceries for that port. So that single container will move on a single freight bill, whereas for Pasha, our interstate, our non-regulated customer will have multiple containers on that freight bill. But
I'm sorry.
Okay, sorry, I was done.
So if you have Pasha with one freight bill and 30 containers, how does that compare on the intrastate side to having 30 freight bills associated with moving 30 containers? How does the work change for consolidation, documentation, billing, and customer service?
Administratively, it requires a little bit more work. Obviously, there's more paper moving, more process.
On which side? You got to tell us on which side.
On the intrastate side, it requires more paperwork and more administrative costs. I'll bring up a point. For customers' convenience, we allow our intrastate customers to allocate containers on a booking, and we don't require them to bring the same container number or the same chassis when they return it. And so we can sometimes modify that at the gate, and that's more for their convenience. But what happens is it delays our processing, and we have to do adjustments on the back end. It sometimes delays our processing time. So for the most part, at the gates, when everything is seamless, we can process a container within a minute. When we have these adjustments at our container station, it sometimes can take 5 to 10 to 15 minutes to process. So it becomes a little bit more cumbersome for us to deal with that type of cargo.
What about on the receiving end? Is there a difference between the way, after the barge gets unloaded, is there a difference in the way the shoreside activities occur for interstate compared to the intrastate customers?
Yeah, one thing to point out is some of our on the interstate, we actually pass that cargo to our customer, which is Pacia or Matson. And I'll use Matson for this example. So in Kauai, we'll actually discharge that container of interstate cargo, and we'll actually pass it to Matson to outgate it. If you look at the first and last place of rest, the first place of rest would be the West Coast. Last place of rest would be the Big Island, Kauai. So technically, that's not our jurisdiction of work when it comes to YB, Inter-Island stevedoring. So we pass that cargo to Matson to complete that because we are their common carrier. So the work actually on the back end is processed non-YB, whereas the intrastate side, it's processed by us, start to finish. So when the container comes off the barge, it gets segregated in the yard, and customer gets notified, customer comes in, it has to get verified, machine operator has to load it to the vehicle, it has to allocate and process in our system. So it takes a little bit more to process that container versus the pass with the interstate customer.
And so why is there, why would it make a difference between freight bill and piece count for this activity once the cargo is unloaded off the barge?
Because there'll be multiple containers on the freight bill versus for an interstate customer versus intra.
Yeah, and on the interstate side, Matson and Pacia, once the cargo is unloaded by Young Brothers, Matson and Pacia take 30 containers.
Correct. They process it, they take it and process it on their own. So they're calling their customer, and then they're dealing with their customer on that end. And if they need our service to bring it back, they'll notify us and bring it back. Other than that, that's their responsibility or their kuleana.
So on the interstate side, does the number of containers make a difference, once the cargo is unloaded? The fact that you have 30 containers, does it take more time to process those interstate shippers than, say, intrastate? Why isn't it the same? Why you got 30 containers interstate, 30 containers intrastate? Why isn't the work the same?
One, with the pass, so we're trying to make sure we meet the jurisdiction between the workforces, so longshore work and the YB work. And the other thing is it's a little bit more simpler to stack all Matson containers in one area and just separate them by refrigerated or dry container. Whereas when you have 100 different intrastate shippers, you sometimes have to mix them in one stack. So you have multiple shippers of multiple commodities. They might be the same refrigerated type of refrigerated container, but they're mixed in the same area. We lack the space in our terminals to efficiently sometimes run our operation. In Honolulu, we're dealing with some peer work, and we're trying to deal with the KCT project next door. So we're limited on space. So my point is, when a customer for the intrastate comes into our yard, a lot of those cargo and containers are mixed match. So customer might have to circle our yard a few times to get to their container because we can't separate every individual shipper in our terminal. Whereas it's more simpler to deal with the Matsons and the Pacia because they come in and they pick up their containers for Costco, for example. All 30 of those containers is in Pacia's dry stock. So it's a little bit easier for us to move that cargo.
Okay, we're running out of time here, Mr. Martin, so I'm going to run through this real quick. I want you to go through the same analysis for auto Roro. Compare the work that's done for documentation, billing, customer service. If you would compare that shoreside activity, auto Roro on the interstate against auto Roro on the intrastate side.
So auto Roro for the interstate is primarily new or fairly new used vehicles. So they've already been inspected multiple times prior to getting to YB. So if you take a brand new Ford car that's been processed in California and they're making their way to Honolulu Ford, which is right up the street, they've already been checked out and processed. A lot of them already come in with the shrink wrap that's protecting the vehicle in transit. So for these new vehicles, when we process them, not only do we do a cursory check, so we're only looking at major damages, but it's a quick look over, maybe 1 to 5 minutes max on a vehicle, because like I said, they've been checked in at Honolulu Ford or Ford on the West Coast. They've been checked in at Matson in Long Beach. So when they get to us to make that connection, they've already been inspected. So we're looking for baseball-sized dings. We're not spending too much time on these new vehicles, and they can bring them in with bulk, meaning they can bring in 20 cars at one particular delivery. And that's
one freight bill.
On a freight bill. When you look at our intrastate customers, they're primarily our POV or personally owned vehicles. So they come in on an appointment. And each appointment is spread out between 15 and 20 minutes because that's how long it takes to process that vehicle. So the customer comes in on an appointment at 8. They get to meet a clerk. That clerk would go through a full walkthrough, checking the vehicle exception sheet to process that vehicle, make payment, sign it off, stage it in our yard before it goes in the barge. So it's just a longer process to do individual shipments of cars versus the interstate process of multiple vehicles on a single freight bill.
So if you use piece counts, well, if you're trying to use as a proxy to allocate these shoreside activities that don't include we got 1 minute, Mr. Martin, for documentation, billing, customer service. If you use piece counts to do that allocation for auto Roro between interstate and intrastate, what's the outcome? I mean, why do you feel it's not right?
Because if you move one car on one freight bill, but you're moving multiple cars on another freight bill, it's not represented correctly.
Okay, I have nothing further. Thank you.
Okay, thank you. We'll turn to the cross-examination by the consumer advocate, Mr. Knox.
Okay. Good afternoon, Mr. Martin.
Good afternoon.
And I'll repeat as I've repeated for others. I hope you and your family are safe right now.
Yeah, likewise.
Thank you. Just a few questions. I wanted to talk to you about barge capacity utilization. In attachment 1 to Young Brothers' response to CAIR 383 is actually a response to the Consumer Advocate IR back in the prior rate case that requested documents filed in a YB rate case back in 2006, correct? I believe it was in response to CAIR 191 in docket number 2017-0363. which itself was referring back to the 2006 rate case. Is that correct?
I believe so. I don't have that information in front of me, but
Subject to check.
yeah.
Okay. Would you agree that YB was finalizing its commitments to fleet modernization back in 2006, starting with barges?
I was aware. I wasn't directly involved, but I was aware.
Okay. Did YB present to the commission back in 2006 its expected growth in CPE cargo demands, as shown in YB Exhibit 102 that appears at attachment 1, page 4 to the response to CAIR 383?
I believe so.
And does page 5 of that attachment show that in 2007, growth in cargo volumes declined and flattened considerably compared to the projected levels?
Yeah, I'm sorry. I don't believe Mr. Martin has the document in front of him.
Yeah, I don't. So I'm sorry.
Okay, let me see if we can pull it up.
Can we do the screen share?
We'll try, Chair. Oh. Thank you, Layden. Okay, so we were looking at page 5 of that attachment. Yep. So right after 2007, I think you can see.
Can you rotate it for everyone?
Yeah.
I think it's under view.
Yeah. Right at the top. Thank you, Lane.
Thank you.
So you see that peak in 2007. Does that show that after that peak, cargo volumes declined and flattened considerably compared to the projected levels?
Yep.
See, and in response to Part E, Brother states it does not currently track or measure barge capacity utilization for its barges because Young Brothers is currently required to meet its commission-approved sailing schedule, whether its barges are at capacity or below, despite the fact that intrastate cargo volumes have decreased year over year since 2017, end quote. What options has Young Brothers explored to right-size its fleet of barges in response to the declining cargo volumes?
Well, let me just object. Lack of foundation.
Okay.
Can you rephrase, Mr. Knox?
Sure. I think I could actually build foundation real quick. Mr. Martin, does Young Brothers fully utilize its barges, or does it have an excess barge capacity?
Cargo ebbs and flows at times. So sometimes we have we've never been over capacity, but just to kind of so you guys understand tug and barge operations, it's actually nicer to have a barge that has additional capacity that's not fully loaded because we can gain some efficiency. So loading 200 containers on our 340 barge, which is our flat deck, our newer barges, is a lot more efficient for cargo handling. So we can actually lower the container stacks so they don't have to go so high. It's pretty difficult. That's why we have skilled workforce to load these vessels 5 high. So when you can load a barge at 3 high capacity for 200 containers, it's a lot more efficient. So the cargo can get loaded and discharged quicker versus it being fully loaded to a 5 high capacity. So in my opinion, I think we have the right fleet size at the moment to deal with growth. And even without the growth, it actually allows us to build some efficiencies because we have the room to operate instead of being so chocker block. You don't want to be loading a barge on a smaller barge and take your vessels and reduce your fleet, because then you're going to look like our smallest barge, which is our 250 barge. And that's, even though we go to Lanai and Molokai with that barge, to fit the rolling stock on that barge on top of containers is very, very, very difficult for us. So if we could go into Lanai Molokai with a bigger barge, like our Kukahi, which is 310 feet, that's a lot more efficient. We could service the community a lot better. Unfortunately, it's too big. So we don't measure the utilization, or at least I haven't in the last few years with everything going on, but I believe we have the right capacity for growth. And even without the growth, we have the right type of barges to actually gain some efficiency.
Do you have the right sized fleet for declining cargo volumes?
I think we do. Yeah, that's my personal opinion.
Would you actually get more of those loading efficiencies if you bought bigger, more expensive barges?
Well, at this point, I wouldn't look at buying bigger barges. I think if we did look at buying barges, we would be looking at the sea level rise. You know, we would have to get fully ballastable barges. So I don't think we'd be looking at size. We'd be looking more for future down the road, because with sea level rise, we're going to have fully ballastable barges that we currently don't have in our fleet.
So the 2006 projections of rising cargo volumes, the cargo volumes didn't actually rise that much. They actually declined and flattened out for a while. But you think that even though the barge and tug fleet was based on that projection, they fit well with the amount that's much less than the projection?
I think our barges fit our service and our business just fine.
Okay, thank you. Looking at operating expenses, Mr. Anna mentioned that you primarily deal with the ILWU through the CBA. Is that true?
That's true.
Can you talk to me a little bit about any furloughs or RIFs that Young Brothers has put into effect right now?
There has been no furloughs or RIFs to LW workforce.
Are you considering any?
Not at this time. We're basing everything on how things play out here. We've had some ongoing conversations with the LW. They know our situation. They've been very supportive of us. Obviously, they're not happy, but given our situation, they understand. So have we had conversations? We've had brief conversations, but not direct conversations as far as specific information on what we need to do. Like I said, we're hoping that we can get the right outcome for us so we can continue service and the service levels that we have been giving the state. We can't reduce the workforce and continue servicing all lines of service and the businesses that we do. Any reduction in the workforce will put our customers at risk, not only our customers, but more importantly, our workforce. We don't have a bench of employees. So we're kind of like your smaller high school in Hawaii that some football teams play both ways. That's kind of a good analogy for YB. So when we don't have somebody show up to work, we play short. So we don't have an excess bench of employees that we can actually lay off. We actually have just the right amount. And sometimes we don't have the right amount of employees in some ports.
But didn't Mr. Anna say that on the boats, because of the reduced sailing schedule, they had reduced headcount, at least temporarily?
Yeah, but I don't deal with the marine side.
Sure.
I'm speaking specifically to shore side.
Sure. But why would they reduce the headcount on the sailings, but keep the same number of people for the loading and unloading? Why would they need as many people for unloading and unloading if they have fewer sailings?
So going back to my point about operating safety, whether you have 2 sailings to Hilo or just 1, you have the same amount of volume and same amount of cargo. So when the barge actually arrives in Hilo, you're still dealing with your straight load customers, which is your Matsons and your Pecias, on top of your local customers like KTA, and Foodland. On top of that, you're dealing with your autos, your Ro-Ro, you're dealing with your mixed cargo, your LCL, dry and reefer. So in Hilo, we have 25 employees. just because you're going there once doesn't mean you can reduce any of the headcount. It would make it extremely unsafe, or we'd have to look at cutting that service. And as you guys know, Hilo is asking for to go back to the normal service levels because the one sailing is not favorable for that community, and we understand that. But you cannot reduce the headcount and service the community if we're going to keep all lines of service open, meaning freight of all kinds.
Have you talked to ILWU about overtime provisions in the CBA?
We have, and with our sailing schedule, the work opportunity is less, so their wages have been less. We're not labor loaning to the neighbor islands, so we're not paying for flights, per diems, and that sort of thing. So we've like I said, we've been communicating pretty regularly, and they've been very supportive of the business given our situation.
Can you estimate those savings, even in rough terms?
I think Jay and Chris Edwards kind of referenced that, but a lot of that $7 million that for our cost savings, the majority of that is reductions to the ILW.
Okay. And are you involved with negotiating vendor rate reductions, including affiliate transactions?
No, I'm not.
Okay. Well, thank you for your time today, Mr. Martin. Chair, the consumer advocate has no further questions for this witness at this time.
Okay, thank you, Mr. Knox. Commission counsel.
Yes, just a couple of quick questions. Hi, Mr. Martin.
Hello.
Are there any software or other fixes that you've explored to assist with alleviating some of these paperwork and administrative costs you've said are associated with intrastate cargo handling?
Yeah, we're in our current system in FACE, there's some mechanisms that we can turn on. We're actually in the process of looking at the impact currently. It'll move some of that process to go away from the manual process. But it might be a little difficult for our customers, which is why we've been slow to turning it on. But we believe some of those mechanisms in our current system can help reduce some of the wait times and processing times. But we're still in the process of testing to make sure. As you guys are aware, we finished the auto RoRo enhancement in FACE, so we have the iPad capability, so that went paperless. Prior to that, we did the barge load discharge and moved that to the iPad and went paperless. So this is kind of part of that same phase of seeing within our system where we can actually move some of that process to a paperless process. So it's not so cumbersome handling multiple papers or having to print out documents or use Excel spreadsheets.
And what's the projected time frame for that transition from a less manual process?
For this particular thing, we're trying to target January of 2021.
Okay, thank you. One other question. In your opinion, how could YB improve its communications with its customers?
Oh, that's a tough one. I think we've done a great job in improving over the last 8 months, our communication. I think we have the right people, right skill set, but to get to all of our customers, that's difficult. I don't know what the answer is. I mean, I think we got to put ourselves more out there in the public. I think we got to have more, get into the community a little bit and have maybe some roundtable discussions in each community to offer up our experience, so maybe we can offer them solutions, and maybe through this working group Senate resolution, we can come up with better ideas. But I think we just got to get more involved in the community, and like I said, have some type of town hall forum type of meeting, so we can get more customers knowing who the players are and offering up some solutions.
Do you have any current plans to schedule these types of town hall meetings or roundtables?
No, I mean, we've been, with COVID, we haven't really finalized, but we've been dealing with the livestock, as you guys know. So I want to kind of knock that off on my plate first. And I think with the working group and kind of tapping on what we did with the livestock, which, for the most part, I think it's been pretty successful. we want to work together with our customer, and hopefully, in the next few months, we can get a better system worked out. I know we're working with DOT Harbors on some space allocations in our pier and some other opportunities elsewhere to open up some space for the livestock. So anyway, short story is I hope that we can take something that we did with the livestock and work with our other customers to help them with solutions.
Thank you. Those are the only questions I have.
Thank you.
Thank you, Caroline. Next up are the commissioners. Commissioner Asuncion.
Yes, Chair. Afternoon, Chris.
Hey, Commissioner.
Just kind of going, we've been, as you shared with Mr. Knox and also with our Chief Counsel, I'm interested in, and this is similar to what I asked Mr. Anna this morning, anything else around the operational side, efficiencies that you see that could be implemented short term, mid-term, long term, right? Other than, right, you shared with Chief Counsel, right? Technology might play a part in taking care of some efficiencies, and you shared some with Mr. Knox as well. Anything else there that, and I take it from the context that you as the director of operations, right? You're the guy seeing day to day, right? The operations at shoreside. So, right, just on your observation and off the top of your head, any other areas to look at as far as efficiencies of operations?
I think YB, we've been around for so long, and I think because we service freight of all kinds, we've tried to do everything. We've been around for 120 years, and kind of, part of the Hawaiian culture is we just continue doing the same thing over and over. And I think one thing that I noticed is that I think we've reached a point where we cannot deliver all cargo at the same time like we always have all this, all these years. And I think some of the efficiencies which are going to have to come at some concessions with some customers because they're going to have to kind of wait. But I think if you start to look at the way we operate our terminals, I think we got to focus more on getting the stuff off of our barges faster and processing what we can on that day, but not really deliver everything on the day of and wait till the next day to do it, because we're trying to do too much on one day, which is creating a long day on our barge days. And then customers are coming to the port trying to wait for freight and it's not available because we still got to process it. So we kind of got to take what works for like our vessel operations, like Matthew and Pacia, and focus on delivering that cargo and getting it off and reloading that vessel and sailing. And somehow finding that happy medium where our customers can get their cargo and not have to wait so long. But I think we're trying to do everything all at once, which is causing heartache for both our side and our customer. So I think that's where my mind is right now, is looking at that at the top of my head, if you ask.
Okay, thank you. I have no further questions, Chair. You with that?
Thank you, Commissioner Asuncion. Commissioner Potter.
Hi. Thank you. Mr. Martin, thank you so much for your time today. I have several questions for you. I'm going to piggyback off of Chief Counsel and then also Commissioner Asuncion in regards to the cargo and efficiencies around your operations. I'm really interested in cargo handling, and there's as you mentioned, it's a very cumbersome process. It can take a long amount of time if you're trying to do it all in one day. And so what I'm interested to know is, have you looked into any type of best practices or considered hiring a consultant or bringing in someone that could help you improve the efficiencies of that process?
Recently, no. In the past, we've had consultants. I wasn't directly involved. I think what's difficult is if you look at us on a moves per hour basis, which is what kind of the industry standard is, for a tug and barge operations, we're pretty high. I think when you look at our efficiencies, on some of our highs, we're moving 38 moves per hour. And I think if you look at the standards, some of the standards are 20 or less. So as far as how we move containers, our skilled workforce actually is pretty efficient. So I think for cargo handling, where we gotta get away from is the manual process and trying to get things in the system so it doesn't require such a tedious paperwork trail, where we can actually rely on the system to generate information versus, like I said, manually, like going out there and physically looking at it. I think we gotta, obviously the workforce will be representing that work, but to physically go out there now to go look at something, I think we got to look at trying to simplify the business in the sense of using the technologies that's available. So we're not physically looking for it. That clerical person can actually search it through the system. And I think it'll be more seamless. And, maybe if we can get faster, if we can actually generate bookings for like our less than container loads, as an example, as a suggestion. And maybe we can actually reduce some of the wait times because customers can come in with an appointment and deliver cargo versus right now it's a, first come, first serve, and it's, walk up with your rocking chair to ship to Maui. And, you might get lucky and it might be a 15-minute wait or it might be a 3-hour wait, just depending. But we have no way to measure it right now because we allow these walk-ins. So I think we got to try and curb some of that. And like I said, move to an online platform that allows for it to be more managed on the system versus physically.
It sounds like that type of technology would be really helpful for customer service as well. That would benefit the whole range of stakeholders in this process. So is that the type of technology that you were considering, that you were mentioning potentially being in place in January of 2021, or is this a much longer term?
The one is the longer term. Okay. The other one that I mentioned earlier is a more simpler. It's more switches to test and run to process it. But the online platform and doing something that's more, like I said, using the system and the clerical person to process it, that's more long term. But our current system and our current software phase has enhancements within it. So we just have to work with our vendor and see. And we've had earlier this year, we've reached out to start that conversation. We just haven't, with everything happening with COVID and the rate case, we haven't been able to put too much energy to it. But we did meet with our vendor to see what enhancements are out there for us and start that conversation.
Sounds like a great opportunity. That's great. I'm happy to hear that. Great. I have a couple more questions for you. In regard to one of the things that I've been a little bit hung up on in reading the filings that Young Brother has submitted is that they've repeatedly articulated that their fixed costs for the company are around 63%. And when such high fixed costs, isn't it in the best interest of Young Brothers to accept more cargo? I mean, that's what we're talking about, more cargo. I realize there's a rate component associated with that, but volume is very important. That's what we've talked about in declining volumes. Now, in the sense that you have fixed cost, people that are working at the docks, you mentioned, that you can't really lay them off because you're still dealing with these barge days and you're running kind of a skeleton crew at that point, but those costs are fixed for that personnel. So when you're talking about cargo, certain types of cargo, and in this instance in particular, LCL load and LCL cargo, is it not, I still am not making sense of how you can be losing so much money on LCL, and this can be such a huge non-compensatory type of cargo when you have fixed costs that are so great. It doesn't seem to mesh for me. Can you please articulate what's going on there and why you would see such a discrepancy between those two?
So part of the struggle is that in order to get traceability of palletized cargo that travels without a booking, so basically traveling on a bill of lading, it requires extra documentation and extra work. And what we've enhanced is that we now document the process from start to finish, which adds to the labor component. So when we process that single pallet can now get traced throughout our terminal and in our system. So it's an enhancement at a cost. And so it's difficult because it's a manual process. So it takes energy and time, and it's longer. So as we start processing the LCL, they get staged as it's brought into the yard, multiple pallets staged so we can process it onto a cargo carrying device, into the system, onto the barge. So it's just those added layers to create that traceability for a customer, because previously, without these work rules, we had no idea where that pallet was. And I'm not saying we lose a lot of pallet, but when a customer dropped off their pallet, we would be like, yeah, it's here, but we'll tell you when it's on the neighbor islands, because we never tracked it in our yard. We never tracked it, in its once we received it. So that enhancement costs money, and that's why LCL is a little bit more expensive now, because it is a manual process and because of documentation required. But we have that traceability. So again, we got to move to that, whatever platform makes us successful, so we can create that seamless transaction of not having to handle that cargo more than necessary, so we can handle it like a container, very few times, and get it to that port of destination. I hope that answers the question.
In some degree, yes. I just want to follow up on that, though. So were the rates that are currently in effect today for LCL cargo, were those designed around the process that you just described without having these pallets being traceable? Is that the reason why these are no longer compensatory rates? It's because you've enhanced the process to provide better customer service for this type of cargo, and that
Correct.
You've never adjusted the rates to.
Correct.
Okay, thank you.
So,
that helps. So I have one more question, and I'm not entirely sure that you're the right person, but I'm going to ask anyway. So if you're not, just let me know. So I'm assuming that with the new barges that you have in place today, that they're more fuel efficient. Is that correct?
The tugs.
The tugs, yes. I'm sorry. What did I say? The vessels, the cars? Yes, the tugs. Are they more fuel efficient?
Yes.
Yes, great. And also the fuel costs have been decreasing, right, as a result of COVID?
Yes.
So have you seen substantial reductions in fuel costs as they relate to your operating expenses?
So I'm not the right person to answer your question, but we've seen some savings on the fuel costs with the Capena tugs.
Okay, great. All right. Chair, I have no further questions for this witness. Thank you.
Sorry, muted myself. Thank you, Commissioner. Thank you, Mr. Martin. I just have one question. And again, I want to make sure I get the context for this right, and I don't want to misquote you, but in responding to Mr. Knox, you said something, and I'm going to infer a little bit. So discussions with the union are based on how things play out here. Help me understand what that means, or let me maybe play out 2 points. If the commission were to approve the motion in full, what does that mean for how things play out? What does that mean for your discussions with the union?
So if I understand full, I'm
using your words.
Yeah, I'm gonna answer your question. So the discussions of how this thing plays out was specific to not getting the rates with the LW. And as we start to manage the cash flow, there's a possibility that we can't maintain the current service levels that we currently do today. I know we moved our sailing schedules to reduce, one sailing to Hilo and reduce one sailing to Maui. But if we started to have to manage the business minus any relief, we would have to look at certain levels and not being able to meet that level. And so basically we would pay off some of those employees that would be otherwise working in that area. We got if we got compensatory rate, I think we stay as is. Service community.
Okay, let me.
Right.
So let me ask a variation of this question, or I guess just to confirm. So if the commission were to say to rule the level of relief consistent with the consumer advocate's recommendation, you're saying you would then look at where you find savings on your labor force. If the commission were to rule and for the motion in full, you would not?
I don't, yeah, if we're, like I said earlier, if we are going and fulfilling our schedule, we currently have just the right amount of people right now to service all lines of business. We don't have a large bench of employees or people, a supplemental workforce or people on the bench. Everybody's working. And with COVID, what makes it even scarier is that we're dealing with, people potentially being out sick for long periods of time. And so we can't really afford to let people go if we get the rate to continue. So yes, I don't think we let anybody go with the rates, but if we don't get it, and we have to look at saving money, yeah, there's going to be some headcount reductions.
Okay, well, let me, because it's been such the basis of Young Brothers losses here, with the reference to fixed costs, the references to inflexible costs. What you're telling me is that there'll be no efforts to address these if the commission is to rule for the motion in full.
To address the fixed costs, you're saying? I
Well,
can't.
my understanding is that's largely based on your need to, under the current collective bargaining agreement, under your current schedule. I mean, that's the structure that sets that up.
Yeah, so I mean, we would engage the ILW if necessary. It's hard for me to like wrap my head on what I'm going to talk to the ILW without knowing what we're dealing with. I guess where I'm struggling, if we're not.
Can I offer, maybe since we came into this prior to the event, the company's losing money and this is viewed as the biggest structural factor in your costs, that maybe regardless of the outcome, it may be important to address this?
Yeah, understood. I mean,
that didn't occur to you?
It has, but again, we have a highly skilled workforce and we don't have a bench. So I don't know where we could reduce headcount. I mean, we can go to the ILW and look at some work rules, but some of these work rules were agreed upon to create a safer work environment. So yeah, they add to cost, but they've also made working here a lot safer. So it's a fine line that we're kind of trying to juggle here. We don't want to reduce the headcount to make it unsafe, and we don't want to take away work rules. So it has occurred to me. I understand what you're saying. But.
Okay, and just one final question, just to confirm, because I think Mr. Honest, that you're the point person for the company negotiating this?
Correct.
Okay, thank you.
Thank you.
That's all. Thanks, Mr. Martin. I think we will take let's call it a 13-minute break based on let's come back at 2:30. We'll finish up with the last two of Young Brothers witnesses, and then try to move quickly through consumer advocates witnesses. Is that clear, everyone?
Yep.
Okay.
Yes.
Thank you.
Thank you, Chair.
Hi, everyone. We're getting, oh, gonna roll soon. Mr. Starkey, can we check your audio?
Yes, can you hear me all right?
Yep.
Good.
Okay.
You can speak a little louder, Mike.
Okay, maybe I just need to hold this a little closer to me. Maybe does that help?
Yeah. Oh, yeah.
Okay, let me see if I can.
We got Commissioner Asuncion. We'll wait a second. Hi, Commissioner Potter. Okay. Okay, Dave, are we good to go? Okay, calling the hearing back to order. Let's pick up with Young Brothers witness number 5. Michael Starkey, please stand and identify himself.
My name is Michael Starkey.
Hi, do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed with the direct examination.
Thank you, Chair. Please state your name for the record.
My name is Michael Starkey.
And where are you currently employed?
I work for QSI Consulting, Inc.
And in what capacity? What's your position there?
I've been the president of QSI since 1999.
And could you just describe very quickly the nature of the work that QSI does?
Sure. We're an economics consultancy. We work a lot in regulated industries, primarily with network-related businesses. We have PhD economists and accountants, and we do an enormous amount of econometric modeling. We also do damages calculations at trial and a number of other things, but we primarily have a utility background.
And you were retained by Young Brothers for the 2020 test year general rate case?
Yes.
What was your assignment for the 2020 test year?
For the 2020 test year, it was to use the cost of service model that we had developed for Young Brothers to provide reasonable jurisdictional allocation percentages that would identify costs associated with the intrastate operation or the regulated operation versus the interstate or non-regulated operation.
Okay. What did you do to construct that cost of service model?
So we actually started working for Young Brothers in mid-2017. There was a prior cost model that the company had used since about 2001 to allocate jurisdictionally its costs. Our first job was to understand that model. That model had been around for a while, and a number of people who had been at YB that had managed that model had left. And so there was a bit of a need for someone to come in and really tear that model apart, understand it, and explain it in the last rate case. So we were hired to do that. Through that process and through that proceeding, it became pretty clear that that model had diverged pretty dramatically from the business processes and the cargo and the data available within YB that ran that model. So we were asked to rebuild a model that would better capture those operational differences and sort of the new environment or the sort of evolving environment at YB and more efficiently use existing data sources and try to really refine what that jurisdictional percentage of allocation should be. So with that in mind, we built the new model, which we refer to as YB BIP, which stands for Young Brothers Business Intelligence Platform.
When you refer to the old model, is that the Marsoff model that we've seen referenced in some of the papers?
Yes, a company named Marsoff originally built that model, yes.
Okay, so I'm going to refer to it as the Marsoff model. Did you take the old Marsoff model and use it as a platform for the new model?
I wouldn't describe it that way. We built YB BIP or the QSI model from the ground up. That's not to say that we didn't learn a lot in evaluating the Marsoff model and we didn't employ some of the same techniques that they did where they were still applicable. But we did not make revisions to Marsoff and end up with the current model. We started from the ground up.
And how did you go about building the allocation factors for each work activity at Young Brothers in order to arrive at an overall allocation for expenses and rate base between interstate and intrastate?
It took us about 2 years to build the current model, which I'll refer to as the QSI model. It flows a lot easier than YB-BIP maybe. It took us about 2 years, and we spent an enormous amount of time interviewing YB personnel. Mr. Martin spent a lot of time with us as an example in his team. We also spent a lot of time on the ground in Honolulu, reviewing the operations, not only on the shore side, but also on the tugs, understanding the barge operation. We evaluated the various processes from in-gating cargo to documenting cargo to staging cargo, consolidating it where necessary for less than container load, and then ultimately barge load and discharge. So we tried to take the YB operation in its current form, really from soup to nuts, and understand each piece of it, understand where employees fit within that process, various types of employees, and then also where various pieces of equipment, lifts or chassis or the various capital assets that YB uses to operate its business. We tried to understand with a lot of particularity how all of those were employed in the process.
Now, what types of employees did you interview in order to build the allocation factors?
Hopefully employees that did just about every part of the business. We interviewed folks who were on the ground and doing documentation and billing, folks who were freight clerks on a day-to-day basis, folks who drove the machines, the lifts, as you will, and really just try to talk to all of those people, and then also try with Chris and his team to get kind of an overview of how all those pieces fit together in the larger operation.
And what did you do with respect to observing the actual processes?
We spent a lot of time doing just that. We went to the mix.
We can't hear you, Mike.
Oh, I'm sorry. Can you hear me now?
Yep.
Sorry, I'll just hold this up even though it might look funny. We spent time, for example, in the mix lot. The mix lot is the part of the yard where if you bring in that chair that Chris was talking about earlier and you want to ship it to Maui, that's where your chair goes. It goes to the mix lot and it ultimately goes into a 20-foot container with everybody else's mixed cargo. That container is shut and then ultimately staged and put onto a barge. So we went to the mix lot, the refrigerated lot, the reefer lot, which they call the ice house. We spent time in the pallet yard. You know, we basically just tried to observe as much as we could how this process worked.
The consumer advocate sent Young Brothers several IRs that questioned specific allocations to the model in the underlying rate case. How did you address those IRs?
Well, we answered them as best we could. We understood that with a brand new model, and the model is an important piece of deriving the revenue requirement, we understood with a brand new model that there were going to be a lot of questions. So we answered as best we could, as completely as we could. We also had a number of technical sessions with the consumer advocate where sort of sat down face-to-face informally and walked them through the model. Tried to make every effort we could to get them to understand the model and the way in which we built it, so that if we had differences of opinion, they weren't about how the model how you might put input or something else. We wanted to make sure they were substantive issues where we might agree or disagree.
Okay. Was the same identical model used for the 2020 test year revenue requirement as was for the motion for temporary emergency rate relief?
The same model was used, however, through the process of interrogatories that we went through with the CA. So we got hundreds really of interrogatories, and there was an enormous amount of time that went in on both sides, I'm certain, to trying to get to the bottom of some of these inputs and assumptions. There are literally thousands and thousands of inputs and assumptions. The Young Brothers business is complex. With more than 100 different types of commodities that it ships on a daily basis, and different operations required for very many of those. So we spent time trying to get as much of that information in there as we could. So the model stays the same, but in the interrogatory process, the CA would identify areas or inputs or assumptions where they would have questions. And whenever we looked at those and we said, yes, you know what, I think you're right here, I think that assumption should be different, then we would accept that or we would change the model. So the model that was filed in the 2020 test year did not have any of those changes resulting from the CA interrogatories, obviously, because we hadn't received them yet. So when we filed the emergency petition, we incorporated, I think, 38 changes that resulted from the interrogatory process with the CA.
Okay, and there was one change that was not accepted by you. What was that, and why did you not accept it?
That's true. The CA had asked us, so on the cargo handling side, and Mr. Martin went through some of this, on the cargo handling side, we break it up into 3 parts in the model. Barge load and discharge, which you can kind of think of as taking something on the boat and taking it off the boat. This is kind of working backwards from there. A consolidation process where you might take like pallets, 3 or 4 different pallets, and then put them on a flat rack so that they can be stacked onto the boat. Just a little bit more efficient way to manage them and ship them. And then a documentation and billing process, which is kind of the paperwork or the in-gating and that kind of process. So the first 2 of those, when the documentation and billing process and then the consolidation process, there are a lot of shared facilities that go into that, like a 5-ton lift, a small lift that you might use to pick a pallet up off a truck that someone's brought in and place it in the yard. And then so later it can come back and consolidate those and then get them on the boat. We used, in order to allocate those costs, we used freight bills. So the number of freight bills, if a particular commodity had more freight bills, then it got more of the cost. And the consumer advocate had suggested that instead of freight bills, we should use piece count, just the total number of pieces. We did not accept that.
We've got 5 minutes, Mike. Young Brothers sent some IRs to the consumer advocate, and we recently got those responses back. There were additional modifications to the model that were recommended by consumer advocate consultant Michael Brosh. Is your silence here today on those additional allocations, modifications by the consumer advocate mean that you agree with them?
No. Sorry, I'm going to object to the characterization of the question in terms of recommendations.
We'll allow the question.
No, we just got them earlier this week. We're still looking at them. We have, there are a few of them that we think, just we wouldn't agree with for sure. There are a couple that we think have some merit that we maybe need to look through in more depth. But we're still looking at them.
And you've prepared an exhibit to help demonstrate where these various allocations fall as part of the that are all included in the record in the docket.
I did.
I think I know what's coming next, so I'm gonna object to the use of or the reference to what I believe is going to be the document that is in the header or title, Summary of Jurisdictional Costs of Service, COS, in parentheses, allocation data points in the record.
May I be heard, Chair?
Excuse me?
No, may I be heard?
Yeah, well, yes, please go ahead, Mr. Ono.
Yes, we provided this document to the consumer advocate yesterday, and we made it clear we are not going to attempt to introduce it into evidence. It's a visual aid. It's a demonstrative exhibit. It's no different than if Mike Starkey had a whiteboard behind him and I asked him to write these numbers on the whiteboard. I think it's appropriate. If Mr. Tsuchiyama believes that there are inaccuracy, then he can cross-examine the witness with those questions.
Just to confirm, the information's already, it's summarizing information that's already been submitted as evidence.
Yes.
Mr. Chair, if I could respond to that. I think the problem is a couple of things. First, it's not consistent with the Commission's procedural order. I think that is 37250 as modified by order number 37258, I believe, in terms of designating a hearing exhibit. So whether we designate it as a demonstrative exhibit or something else for introduction into the record officially, it's still to be used at the hearing. But beyond that, I think the concern of the consumer advocate in looking at the what is to be used here is that we didn't have an opportunity to review and understand, just the genesis and the nature and how this all came together and what is selected and not selected and the columns for presentation. So the concern is that we didn't have a chance to fully understand it, but based on some of the conversations that we had so far, we're not entirely sure whether it's an accurate or I want to say appropriate, but accurate presentation of the evidence in the record, even what it's drawing from.
So is your concern that you believe that the citations may be inaccurate, or you just haven't had a chance to verify?
Verification is one, but also that the way that the material is described, that's another thing, because in conducting these various rate cases, cost of service and the cost of service allocation models have always been a contentious and a controversial issue in which sometimes Young Brothers and the consumer advocate can't just agree onto even the inputs or the nature or some of the assumptions going into the model. So for it to say, for instance, consumer advocate suggestions or consumer advocate recommendations accepted, we're not sure that that's entirely accurate, and we don't want to paint a incomplete picture, but we haven't had the opportunity to completely review and know where these particular pieces and columns of information are presented. So we just want to make that objection noted for the record.
Okay, thank you. And for for a number of sakes, but partly in the interest of time, we're going to continue forward. The commission will take it under the understanding it's not going to be admitted as evidence. This is summarizing, or it's a summary document of information that has been already submitted. Commission will take it and give it the credibility, the weight of evidence that it deserves, as well as it goes to the credibility of the witness. So if you want to proceed, Mr. Ono, please continue.
Yes, I do. Thank you, Chair. Mr. Starkey, could you put up the exhibit?
Yes, I could. Might take me 1 second. Sorry. I didn't realize I was going to do that. 1 second. Can you see it?
Needs to be, yeah, there you go. Thank you.
Okay.
Can you just tell us real quickly what this chart represents?
Sure. I was concerned there are a number. So when you build a model like this, you build a model so that you can change the inputs, you can change the assumptions, you can run it a number of different ways and understand how different inputs and assumptions change the results. So not surprisingly, there are a number of different runs of the model that I understand to be in the record. So I just wanted to prepare this so that we had what I understand to be the primary runs of the model that are at issue in one place, so the commission could go to one place and see it without having to look at a bunch of different documents. So I highlighted number 4 in the middle as an example because that's Young Brothers' proposal in the emergency relief petition. It's the only reason it's highlighted.
Is this meant to be like a dartboard where the commission can pick one of those allocations and they're all reasonable? Is that your opinion, Mr. Starkey?
No, I hope not. The intention was just to put out there one place where the commission could see all of them. Number 4, so this model, like I said, we spent 2 years on it, and we've now spent a ton of time in the interrogatory process going back and forth. And like I said, 38 things got changed just because we thought the CA made a good point. So number 4 is what I think is the most reasonable run of the model, given what we know today.
And then can you compare, what are 5 and 6? What do those represent, those allocations?
These are my best efforts to put into this chart what the consumer advocate provided to us in discovery earlier this week. They had in their interrogatory response to us included 5 additional changes beyond what we had already incorporated. So line 5 is our run in number 4 with their 5 additional changes. And then in their interrogatory response, the consumer advocate described maybe perhaps quote unquote simplifying the process and just using revenues. And so line 6, and by that I mean just taking the interstate revenues and intrastate revenues and dividing costs accordingly. And number 6 is meant to capture that proposal.
Okay, and what are numbers 1, 2, and 3? What do those represent?
Number 1 is so in the last rate case, in the 2018 rate case settlement, we used the old model, and the parties, the consumer advocate and Young Brothers, settled, and the percentages in which they settled on the old model are on line 1. Line 2 is that old model run for the 2020 test year in the larger rate case, and line 3 is the QSI model run with the 2020 test year numbers in the larger rate case. And then number 4 again is the emergency petition.
And then looking at these different allocations, why do you feel number 4 is the most appropriate one to use, the QSI model?
It uses as its financial data the test year
Mr.
2020.
Arnold, the time's up. Can we please summarize?
Oh, I'm sorry. I couldn't see Dave Parsons.
You got two red cards.
Oh, I'm sorry. Starkey, can you please just summarize and finish up? And I do apologize.
Sure. I forgot the question. I do remember it. So I think 4 is the most reasonable because it uses the test year from the emergency rate petition. It includes the changes that we agreed to with the CA through the interrogatory process. And I think it's the most reasonable based on all that information.
Thank you, Mr. Starkey. I have nothing further at this time.
Okay, thank you. We will proceed with the cross-examination by the consumer advocate.
I think Lane's on mute.
Yeah, Mr. Suchi, I believe you're on mute.
Sorry.
It's okay.
So, Mr. Starkey, I'll be questioning you. So could you I just had a few questions on that exhibit we were discussing.
Okay, that was the question I was going to ask, if we want to keep it up on the screen share.
Sorry about that. Let me get back to there then. Sorry. For some reason, my WebEx now isn't giving me my controls. 1 second. It says that it's sharing it. My apologies. 1 second. All right, let me try and share it one more time.
Let me see if I have it.
All right, I'm sharing and then sharing.
There was also, I believe our staff has a copy.
You could try Alt-tabbing and it might jump to the correct screen.
Oh.
Is it? There we go. How about now?
No. Oh, there it is.
Okay.
Okay.
Okay. The question I have is, I know for lines 5 and 6, but especially 5, the designation is, or the identifier in the column says CA version of TY 2020 QSI model. The question I have is where did you get this, calling it the CA version of the model? Because to my understanding, we don't have a version of the QSI model.
What I'm referring to is your attachment 1 to the interrogatory responses that you provided us earlier in the week. There was an Excel file attached. In that Excel file, I believe it was Mr. Brosh had made a number of revisions, and those revisions in inputs and assumptions resulted in the ultimate output that I have on this table at report 15,000, which is the report output for the model. So I didn't mean to misstate it. This was the QSI model as opposed to the Marsoft model with Mr. Brosh's changes.
And so when you say the best attempt to run the C8 numbers, that was more of an attempt to just lift whatever you believed was the output of the, I guess, the attachment that was submitted with the IR response then.
No, I wouldn't phrase it that way. I'm looking at attachment 1 to your interrogatories from earlier in the week at report 15,000, and those are the numbers.
Okay, and then let me ask you this. I mean, just a general global question then. So could you identify or explain to the commission where all these numbers and where all this math comes from, or all these percentages, where they're drawn from? Because it doesn't seem to be apparent from this chart where these things are coming from.
Sure. So the QSI model, if you will, what we refer to as the YB Business Intelligent Platform for Cost of Service, is a cloud-based model. One of the limitations of the Marsoft model was that it was built in Excel. And there's an enormous amount of data that sits behind this model. We tried to capture as much of the operational data, the day-to-day data that's generated in YB's operation as we could in this model. So there's an enormous amount of data that you really can't run very effectively in Excel if you're going to do some of the calculations. So the model sits in the cloud. YB BIP sits in the cloud. But in order to allow cost analysts like Mr. Brosh and the consumer advocate and ourselves to some extent in the company to understand all the inputs and assumptions, the model spits out or will generate an Excel version where you can trace all the inputs and assumptions all the way from initial inputs all the way to the output. So what I'm looking at that was provided by the consumer advocate to Young Brothers earlier in the week is that Excel output that started in exactly the same way, as far as I can tell, as line 4 on this chart. And then Mr. Brosh made additional changes and then calculated the differences based on those changes.
I'm sorry if I wasn't that clear. The question was more simple than that. It was more what records in the document can you point to where the commission can identify and verify for itself that these are the percentages and or these are the representations coming out of the items that you described.
You want me to go line by line, or was there a specific line that you're interested in?
Line by line, if you could, but I guess what I can't tell from this is where the source documents are for this.
Well, as an example, let's take number 5, which we were just talking about. The source document is the consumer advocate's response to YB's interrogatories, attachment 1, YBCA IR1 attachment 1, which is a native Excel file. My understanding is that is in the record.
Okay, and then how about number 1 then? What's the source file for that?
Number 1 is the Marsoft model run, which served as the basis for the 2018 rate case. I believe that was provided in the original filing in the larger rate case. I'll refer to this as the emergency petition rate case, but the larger 2019 rate case that we filed in September of last year.
And then 2 is the same thing. 2019-0117 application.
2 and 3 would both be found there. Yes, those are attachments to my testimony.
And then 6 is where then?
6 is also taken from YBCAIR1 attachment 1. Well, not attachment 1, but it's YBCAIR1. Let me see if I can find it. It is on page. It is also attachment 1, page 1 of 1.
Okay. And then going back to your testimony, I believe you mentioned that your work for Young Brothers began in 2017, and that was to review the Marsoft model. And I guess that's how we're referring to it, right? The QSI model is the model that is utilized by or presented in this particular rate case, 2019-0117. And the previous version of whatever Young Brothers was using, we'll call the Marsoft model. So you reviewed that Marsoft model then?
Correct.
And did you, as part of the last rate case, have any kind of come to any kind of conclusion, or did you have any type of observations about that Marsoft model?
I did. I filed both direct and rebuttal testimony in that case. And the general opinion was that it was reasonable It was the best information we had at the time. It was a reasonable allocation of costs based on what we knew. But we highlighted certain deficiencies with the model, and I believe it was Mr. Brosh in his testimony had suggested that it be rebuilt from the ground up. So that's what we did in the QSI model, was rebuild Marsoft from the ground up.
Okay, and this, I believe this is from your testimony in docket number 2017-0363. And it was one of the bullet points, I believe, on page 18 at the bottom of the page. And it says something, the quote that I have here, it says, even though the cost of service, and I believe it was abbreviated COS process, is complicated, the logic and basic functions of the COS model are sound. The COS model's allocation algorithms are based upon reasonable cost drivers and the fundamental elements used by the COS model, e.g. commodity codes and CPE. And I believe that CPE there referred to the term container platform equivalent, are well suited to helping the COS model differentiate costs by cargo category. Results from the COS model in its current form can be reasonably relied upon for purposes of jurisdictionally separating costs amongst cargo categories and between regulated and non-regulated services. Does that capture or refresh your recollection of what you said in the 2017-0363 rate case?
It does, and I have page 18 in front of me. That's one of 3 observations or conclusions that we raised. The other 2 describe the fact that the model could be improved and that it had diverged from YB's operation and its data sources. So,
right, and then,
like I said, that was the best information that we had at the time, and I thought it did provide reasonable results at that time.
Right, and then there's also a bullet point, I believe that's after that, saying the existing COS process, including the COS model, can be improved primarily by simplifying the process.
Correct.
So you still agree with those conclusions you reached in 2017-0363?
Generally, I do. That was, I mean, I've had 2 years now looking through that model and building ours, and I'm further educated for sure. I do think, I mean, just frankly, the Marsoft model did a good job based on what it was at the time. It had converged from YB's processes, including its data sources and the process by which it handles cargo. And so it certainly could have been improved, and that's what we did with the QSI model.
Okay, and then I believe that in your discussion, in your exchanges with Mr. Ono, you had talked about there being a significant number of information requests exchanged and a number of technical conferences with yourself and Mr. Brosh and members of Utilitech, the consultants for the consumer advocate and others discussing the QSI model.
That's true.
So in your understanding of the state of the case right now, is the consumer advocate's position and formulation of its response to the QSI model, is that complete yet?
Well, objection, that just calls for speculation.
We'll allow the question. Please continue.
Yeah, I don't know. I doubt it. I mean, for the first time this week, we saw sort of them describe changes they wanted made to the model or their opinions and evidence supporting that. So I doubt it is complete. I don't know.
I guess the question is, is it your understanding that there are still disagreements as to how the model, the portions of the model, how it allocates, just general income. Sorry, I'm trying to find the word that I'm actually looking for, but is it your understanding that there are still disagreements? I guess that's the best term. Disagreements between the consumer advocate's position and Young Brothers' position as to this QSI model, its operations, and how it allocates costs between the jurisdictions.
That's fair, yes.
So if I understand reading some of the material that was included in YBT 9, and I believe it might have been in YB 901 where you described the cost of service model, QSI was retained by YB to develop and create a new simplified cost of service model that reflects YB's current operations. Is that correct?
I don't have it in front of me, but that sounds right.
And I believe it mentions jurisdictional allocations. When you say jurisdictional allocation requirements, what specifically are you talking about there?
So the purpose of the COS component of the YB BIP, of the business intelligence platform, is to identify, first of all, it's to identify costs associated with different kinds of commodities. What's it cost to in-gate a container versus that chair that we talked about, or a pallet? So the primary building blocks are, it develops costs by commodity, but it also does it by what is in the model referred to as contract types, whether it's a public tariff commodity or it is an interstate commodity, a contracted commodity. So what the model ultimately does, the ultimate result is how much of the total cost should go to the regulated commodities and how much should go to the unregulated commodities. That's the jurisdictional allocation.
And is this operationalizing any type of commission rule or guideline or procedure, or is this just Young Brothers, is QSI creating something that's not prescribed, expressly or explicitly by the commission's rules or rulings?
Objection, very ambiguous. I don't understand the question.
Yeah, can you rephrase?
Let me
Mr.
rephrase
Suchiyama?
the question then. Is this to respond to something that the commission said, to turn a commission rule into something that YB follows, or is this something that YB is creating on its own to allocate cost across jurisdictions?
I think the only way I can really answer that is, my understanding is that in order to develop a revenue requirement associated with regulated cargo, because regulated and an unregulated cargo share facilities like the barge, that some calculation must be made, or some attempt must be made, to allocate those costs between those two jurisdictional components. That's what this model is intended to do. Whether that's prescribed by a commission order or a rule, I just don't think I know the answer to that.
Okay, and then, in your opinion, has QSI been successful in simplifying the COS model from the previous Marsoft model for YB's use in its operations?
I know you'll find this hard to believe, but the answer to that question is yes. So two components to that. One, because the Marsoft model had become detached from the internal data sources at Young Brothers. For example, Marsoft was built when they used a completely different accounting system than they use now. So a number of machinations had to go into taking existing accounting data just to be able to input it into the Marsoft model and then run it. So the QSI model certainly simplifies that entire process because it matches directly with all of the operational systems that Young Brothers uses today, and a whole lot more of those systems. Our intent, the intent of the business intelligence platform, is not only to do cost of service, but to really let Young Brothers harness an enormous amount of the data that it generates in the course of its business and make strategic decisions. So yes, we totally simplified that process associated with gathering that data. Now, to be fair to your question, it's a complicated business. There are a lot of commodities. There are a lot of processes that go into gating and all of the things that get a piece of cargo from one port to another. So it's not for the weak at heart. If you want to dig into the spreadsheets and look at the algorithms and the assumptions, it's not simple. It's sophisticated, we hope. But the purpose of taking the cloud model and pushing it into an Excel format was that at least we all have a tool that we can look at together don't have to be a programmer, can look at together and trace inputs and assumptions. So it's not simple, but it's simpler, I think is fair.
Okay, so so you're saying that it is simpler than the Marsoft model that predated the QSI model.
I think that's fair, yes.
Even with, and the exhibit YB901, I think it has like, I think I counted 240 pages, and that's the user manual for the QSI business intelligence platform.
Correct. I don't remember how many pages, but that would not surprise me. We tried to give as much detail as we could on how it worked.
And then and I believe YB-902, that's a 144-page output report from the BIP or the QSI model.
That's, again, I don't have the pages in front of me, but that wouldn't surprise me. That's the entire output of everything. The model, if you just wanted to look at the primary outputs, runs on maybe 8 reports, with report 15,000 giving you everything you really need to know, unless you want to dig in and start getting to the bottom of every input and assumption. The only other thing I would add to that is that you keep in mind that the QSI model, if you will, or YB-BIP, provides an enormous amount more granularity in the cost process than did Marsoft. Prior to the QSI model, the Marsoft averaged all sailing costs together as an example. So you couldn't determine how much it cost to sail to Hilo versus how much it cost to sail to Kauai High, or to Lanai or Molokai. So the QSI model provides a lot more detail so that young brothers can make decisions based on costs differences, like the cost differences at the very small commodity contract level, and then also on various sailings, not only between ports, but whether the sailing on Monday is more profitable than the sailing on Thursday to Hilo. So it provides, it's not, like I said, it's not simple, it's sophisticated, but it provides you a lot more detail than the Marsoft model did.
Okay, and then just a few more questions then. So to your knowledge, at least, for the use of the QSI model that you were building for YB, are you aware that every dollar of expense that is ultimately allocated to YB's intrastate side of expenses, as opposed to their interstate side of expenses, would be includable in the company's revenue requirement for the rate case application purpose?
I apologize. Can I hear that one more time? I was going to make
Yes,
sure.
so to the extent that you know, for the QSI model that you were building for YB, are you aware that every dollar of expense that's ultimately allocated to the YB intrastate side of its operations or expenses, as opposed to the interstate side, would be includable in the company's revenue requirement for its rate case application purposes?
Okay. I assume there is some allocation of the cost or the investment associated with building YB-BIP and running it for the rate case. There's some allocation that goes to intrastate and interstate. I don't know what that is. And as Chris Edwards said earlier, I think some of that has been capitalized. So I don't know the details of that, but that would not surprise me.
And then that would apply to their rate base items as well, right? That the allocation between intrastate and interstate that's ultimately determined by the QSI model, that would be includable in YB's rate case application too on the intrastate side.
Yeah, some amount of the expense, I think the best way I can answer it is some amount of expense associated with developing YB-BIP would go into the rate case expense, which would be recoverable from the revenue requirement from intrastate rates. Yes.
Mr. Starkey, the consumer advocate has no more questions for this witness at this time.
Thank you, Mr. Tsuchiyama. Next is Commission Counsel Caroline Ishida.
I don't have any questions for this witness at this time. Thank you.
Thank you, Ms. Ishida. Next is Commissioner Sunsian. Leo, I think you need to unmute.
Sorry about that. I thought I hit the button. Mr. Starkey, if you could just clarify for me, right, in this particular discussion that you're having with the CA, and you had testified to in accordance with this table, mainly the focus is on, right, the QSI model, the cost of service model. And is it your understanding that that is still subject to some review by the commission because it's part of the bigger rate case, if you will?
Yes, that's my understanding, is that the commission is still reviewing the QSI model.
Okay.
Because it was filed in the larger rate case.
Yes. Okay. Thank you. I just wanted to make sure, clarify that I understood that, because it sounded like the testimony was going towards like, this is the model and this is what you guys use, right, to come up with these numbers, and then going forward too with, right, what are considered the changes proposed by the CA. But we don't have, right, a firm approval yet on the model itself.
That's true, Commissioner. And in my testimony, or with my testimony in the larger rate case, we ran both the QSI model and the MARSOFT model, so that you have both numbers. So
yes. Okay. Thank you very much. That's all I had, Chair.
Thank you, Commissioner. Commissioner Potter?
Thank you, Chair. I have no questions for this witness at this time.
Thank you. I have no questions either. Mr. Starkey, thank you for your time, and you may be excused.
thank you.
Okay. Next is, oh yeah, can we, I'm not sure, Mr. Starkey, can you stop the screen sharing? There we go. Okay. We'll go to Young Brothers' next and last witness, Paul Brubaker. Mr. Brubaker, can you please stand and identify yourself?
My name is Paul Brubaker.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Please proceed with the direct examination.
Thank you, Chair. I'll be handling the director, Dr. Paul Brubaker.
Can I question, David?
Yes.
We talked about my not showing any slides, but
Yes.
I would like to show slides from the report that I gave you on May 3rd. Can we do that?
It was filed in connection with the general rate case, but for purposes of this motion and to keep things going, I would just ask that you just speak to your testimony.
Well, no, in response to your questions, sure. Okay, one more question. If I updated them to today for May 3rd, is that legit? The chair had expressed a concern about this yesterday, that there's some problem with having new data.
Well, nobody has seen it. Consumer Advocate hasn't had a chance to see it. We won't have a chance to see it.
It's the exact same data that's in the report, only I've updated from May 3rd to today.
If Young Brothers would like to make a motion to introduce
Just like
it
the
so we can
whiteboard
rule on
analogy.
it, or we can move on. Mr. Nakashima?
So, Dr. Brubaker, if I can just understand, you would like to present some information purely for visual aid purposes. Is that what I'm hearing?
Yes,
or
correct.
Chair, would you permit that?
Sorry, can you be, is he presenting slides of his prior information or updated version?
Figure 1 updated.
I think we'd have to view that as new evidence. And so is this a motion to submit new evidence?
No, Chair, we don't need to go down there. So Dr. Brubaker, if you could just again state your name and occupation for the record.
Paul Brubaker, economist.
And could you briefly describe your professional background?
Graduate school at Wisconsin, where I taught for a few years before coming back to Hawaii, where I worked at Bank of Hawaii for 25 years as their economist, and then consulting for the last decade.
And could you just talk generally how the COVID-19 pandemic has affected our state economy and how it may affect Young Brothers going forward?
With the data since May 3rd or without?
Just you can include recent data, but just talk about
Okay.
it orally.
So as of today's data, the prevalence of COVID in Hawaii is 100 times worse than it was on May 3rd. So that gives you an idea of how much things have changed in terms, in this case, of daily confirmed COVID-19 new cases posted on the Department of Health website today at noon. Accordingly, almost everything we were saying around May 3rd at the time of my earlier report, which, by the way, was highly conjectural because we had no data. I mean, in April, at the end of April, we were barely getting March data, and we were still going to work in March. So, I mean, as a rule of thumb, whatever we said, whatever we conjectured, make it 100 times worse, and that's where we are today. In particular, the nature of the recession that we had been expecting at that time was already unfolding, but of course didn't have measures to confirm it, which was then validated by both conventional data sources as well as the new data sources we have that have literally been invented since I wrote my May 3rd report. All confirm not only was it for Hawaii the deepest downturn in, well, let me be specific. In the US, it was the deepest downturn since Great Depression and maybe the deepest ever. But I can tell you, based on my own estimates, that is as deep as the downturn that Hawaii experienced in the post-World War II demobilization era, which, by the way, lasted 4 or 5 years. It took 1946 to 1950 to sort of climb out of that hole. I don't think this one takes that long. But the problem with where we've arrived, having actually contained the coronavirus in the course of May, is that we let it run amok again. And now it's just exponentiating. And at the rate we're going right now, by sometime before Labor Day, but as soon as next week, I'm guessing, maybe the third week of August, once people are really in school, this will be like New York in March, or Arizona in early July, or Florida in mid-July. That's where we're headed right now. So the Nike swoosh trajectory that I think Chris Edwards was talking about is sort of a framing visualization of the path of the recovery, a severe initial downturn followed by a partial clawback and then a gradual improvement thereafter. The point where we're at after the initial bounce, where we're kind of inflect and then dig our way out of the hole in anticipation of a vaccine, that's about to get pushed down really hard right now. We do see inklings of it in data which didn't exist when I wrote the report, but I'm not allowed to share with you, so pretend we don't know that. It's coming, and it's going to hit pretty hard. And the final point I would make here is that because of the nature of it was interesting listening to this allocation discussion, because we literally modified our econometric modeling over the years in response to the recognition that it was really intrastate was kind of where the action was. And so we went from a generalized Hawaii-based macroeconomic modeling strategy to something that focused exclusively on the 2/3 to 3/4 of YB's costs or revenues that are sort of neighbor island driven. And those guys, in addition to the consumption contraction, which is now going to worsen, we just blasted 30% of their economy away simply by shutting down tourism.
Well, just one last question, Dr.
And on that note, I will conclude.
What would our state's economy look like without Young Brothers?
The zombie apocalypse. So it would look like the windward side without 6 tunnels and 12 lanes of multi-lane divided highway. Or think of Hawaii without 10 million visitors a year, and then double it. I mean, it's double the economic impact of that. It's, yeah. Self-sufficiency is the economic development strategy of North Korea. So good luck with that. That's right. That's what we're talking about.
Okay, no further questions, Chair. Thank you.
Thank you. We'll have the cross-examination now.
Dr. Brubaker, I believe in one of the Young Brothers filings, I think it was in their supplemental filing that filed their rate design piece, there was a discussion of the concept of price elasticity. Can you explain for us what that concept is, price elasticity?
Well, technically, it is the proportionate response of quantities demanded or quantities supplied to proportionate changes in prices. So if a price goes up by 10% and quantities decline by 5%, then the elasticity is 1/2, 5/10.
So in your expert opinion, then, are Young Brothers prices for the goods it transport, are they subject to price elasticity or not?
Well, all prices are subject to price elasticity, but as the sole regulated monopoly ocean surface carrier, there's an absence or a limited amount of substitutability, which makes demand relatively price inelastic.
So if the prices charged by Young Brothers became too high, whatever that number might be, what might happen at that point?
I'm sorry, say that again?
So if the price,
what? Sorry.
So if the prices charged by Young Brothers became too high, whatever that ultimate number in the terms of what is high, whatever that number might be, what might happen to Young Brothers?
Well, again, there's two sides of the market that are responding to the signals being sent by prices. So on the demand side of the market, prices going up mean that quantities of their services demanded, or in turn, the amount of freight volume being transported by barge inter-island would not diminish by that much, but people would have to pay a lot more. Of course, the whole point is YB hasn't made money since the Cretaceous era, so they need to make more. But on the supply side of the market, the problem is, of course, that there is no substitute. And that's a product of legislative design. I mean, the state of Hawaii designed this monopoly, not YB. And the question, we have learned answers to, or possible answers to, in other transportation situations, and now social media and technology are another big area where these kinds of questions are arising, is how much entry or exit, how free is entry or exit in response to these price signals of the potential substitutes. By definition, in regulated monopoly, entry is not available. An alternative would be non-collusive duopoly, where, for example, Hawaiian Airlines and Aloha Airlines facing a rivalrous entry from a third, but not particularly credible carrier, was unable at a time of rising petroleum and aviation fuel costs to sustain, in the case of Aloha Airlines, to sustain a profitable model given the rivalrous nature of unregulated airfares, both at that time and today. And so they exited. And what's instructive about that experience is that technically, I guess you could count Alaska Airlines entry into Trans-Pacific service in about 3 years later, 2 years later, maybe 2010, as a partial substitute. But even if Southwest Airlines were to ramp up its, or renew its much anticipated entry and abortive entry last year because of the coronavirus, even they would not present, as Aloha Airlines did for many, many decades, a straight up rival providing 40% of the inter-island capacity. So rigidity on the supply side of the market, or inelasticity, because there's an integer constraint, there shall be one carrier, it shall be regulated, combined with inelasticity on the demand side of the market, where people really don't have alternatives and will either have to pay or pay or stop, or call up FedEx, are characteristics of both sides of the markets in this instance.
So if the commission gets this wrong, in the sense that the prices charged by Young Brothers becomes too high, could the possible result be that Young Brothers sees a further erosion of its cargo volumes, such that it's going to be back here again for another rate increase or rate adjustment in the future?
Well, so the point is that you can think of in price and quantity space. Here's my whiteboard. Here's the y-axis, the price axis, and the quantity axis, the horizontal, the x-axis, right? And what we're saying is that the demand curve is relatively steep. So when you increase price, quantity doesn't go down by that much. You still got to use the barge. How are you going to get your car, to the next island? There's no super ferry. So in that situation, the challenge of the moment is that it's not really the slope of the demand curve. It's not price elasticity per se that's problematic. It's this compression in demand. So am I going from left to right for you guys? Is that right? I'm looking at it, it looks backwards to me. At any rate, demand, which remains inelastic, for which, ocean surface carriage remains, continues to offer, few substitutes. The demand is contracting from the 1/3 of the neighbor island value added that disappeared overnight because of the drop in tourism following the coronavirus, the arrival of the novel coronavirus, but is being compounded by the fact that households, which had initially reduced consumption back in March and April, and then sort of came out to play and went to too many parties, is now also going to retrench. So that the action's all on the demand side of the market, and as an earlier question alluded, I think it was Chris who was having these questions posed to him. Can't you shrink to fit the barges, right? Don't you have too much capacity? Well, again, there's an integer constraint, and if the demand for the service goes down, then you have more space on the barge. And the upside is you don't have to stack containers as high. But the point here is that what's really going on right now is this massive compression in demand, and we were hopeful, that it would build back. And there will be a moment when vaccination arrives in 6 months to a year, when it probably will return to something that's different, a new normal, but nonetheless is more viable in terms of sustainability of the enterprise, if not profitability of the enterprise. But that's down the road.
Okay,
we can accelerate. Yeah, sorry. Go ahead.
Sorry. So this is my last question. So so is it your testimony or your opinion that no matter what the charge of Young Brothers is, they will still not experience they will not experience a decrease in cargo volume no matter how high that rate goes?
No, it's going to be a smaller decrease in volume than if McDonald's raised the price of cheeseburgers, for which demand is more elastic. But the problem here is that we're not really focusing on the right thing, because what's happening it's the reason it's a regulated monopoly utility is that it enjoys economies of scale, and in order to ensure that the benefits of those scale economies are passed through to the consumer in large part, we recognize we try to use average cost pricing to spread the wealth, so to speak. So everybody on Molokai pays the same first class stamp prices people on Oahu do. And what happens when you have this contraction in demand, it descales the production of the utility, And as a result, average cost is going up. It's less, we heard a lot today about how it's just less efficient to operate as a consequence of the drop in demand. And the challenge, I mean, I've heard it called a threat, but the fact of the matter, it's, we're at this moment of this sort of binary decision. Do I operate or do I not operate, right? I hold the option to deploy my capital elsewhere. And at some point, it's just not worth keeping the assets in place doing what they're doing now. No matter how much your commitment to services, you can't just, I mean, it's not the job of the owners or shareholders of one company to subsidize, the lives of people in Hawaii. We try to act collectively to mobilize such a response through our federal government, and Congress stepped up and managed to get us all the way to August 1st, but now it's failed to extend that. So we face some real problems here. But that's, the one way we sort of try to organize these cross-subsidization responses is by design of the system, so that we use Ben Franklin's model, where Molokai pays the same rate as Oahu and the Big Island. And then we exploit the scale economies of having one big, really efficient operator, rather than a bunch of guys with small boats driving around. The odds that under these circumstances, should the service provider exit, that another service provider will, sweep into the void, swarm into the opportunity under the current economic circumstances is relatively low. And that's sort of the Aloha Airlines example. It's 10 years later, we're still waiting for Southwest, and those guys have unregulated entry, right? They can deploy their planes wherever they want. We regulate safety, but we don't regulate entry and passenger carriage, so air passenger carriage. So here we are, and sucks, but I don't know. The legislature went home, the Congress is going home. I mean, I don't know what's going on.
Okay, thank you, Dr. Brubaker. The consumer advocate has no further questions at this time.
Thank you, Mr. Tsuchiyama. Now turning to Commission Counsel.
I have no questions for this witness. Thank you.
Commissioner Asuncion.
I have no questions for Dr. Brubaker. Thank you.
Commissioner Potter.
Thank you, Chair. I have no questions for the witness at this time.
Thank you. Same for myself, no questions as well. Dr. Brubaker, thanks for your time and have a good afternoon and weekend.
Thanks, you guys. I'll send you my slides. They're scary and awesome. Oh.
Thanks, Paul.
Okay, we will continue rolling forward. We're gonna, Dean Nishina is our next witness representing the consumer advocate. Dean, can you please step forward, identify yourself?
Hi, is my audio and video working okay, or is there still some latency?
I can hear you okay.
Okay.
All right. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Please proceed with the direct examination.
Good afternoon, Mr. Nishina. Could you tell the commission your name, place of employment, and role in this proceeding?
Good afternoon, Chair Griffin, Commissioner Potter, and Commissioner Asuncion. My name is Dean Nishina, and I am the Executive Director of the Division of Consumer Advocacy in the Department of Commerce and Consumer Affairs. I am one of the sponsoring witnesses of the division's response to Young Brothers' motion for emergency or temporary rate relief.
And what is the division's position on Young Brothers' request for emergency or temporary relief in the motion?
To summarize, the division has offered that it is not clear that financial need has been supported and that YB has not proved probable entitlement to the requested $27 million increase. There are many questions and concerns related to the factors leading up to the emergency, the base case numbers upon which the motion is based, the jurisdictional allocation charges proposed by YB, as well as the adjustments used by the company to support its $27 million temporary rate increase request. That being said, rather than simply recommending that the Commission deny the requested temporary rate relief request, the Consumer Advocate has offered the Commission alternatives to address the current situation.
Do you think it is reasonable for the Commission to grant the requested or emergency rate increase as proposed by Young Brothers in the motion?
No, as set forth in the division's response, we have offered several reasons why the requested temporary rate increase of $27 million is not reasonable, not the least of which is the potential impact that this requested increase will have on customers and the state's economy. The current pandemic has affected the world, just as Dr. Brubaker was mentioning, and we should be expecting a lot worse. Many residents are unemployed, and there are many businesses that have already shut down, and more businesses are likely to shut down even without an increase in their expenses. However, if YB's requested increase is allowed, businesses and residents in Hawaii, especially those on the neighbor islands, will be adversely affected, and the state's economic ability to withstand and recover from the current pandemic will be significantly diminished.
Young Brothers contends in its motion and reply that it is entitled to receive the requested temporary rate increase of $27 million and that the Consumer Advocate's alternatives are unreasonable. Do you have a response to that?
Yes. First, I think Young Brothers' sense of entitlement is a significant part of the problem here. In filing its motion for a temporary rate increase, Young Brothers is not allowing the Commission and the Consumer Advocate a reasonable amount of time to review the request, since there are very limited intervals within which the Consumer Advocate can respond to motions. Young Brothers criticized the Consumer Advocate for not detailing each of the concerns and issues that were still being developed in the general rate case in the Consumer Advocate's response to its motion, and then argues that should persuade the Commission to find its temporary rate increase to be reasonable. To my knowledge, in all other temporary rate increase requests, it was either as a separate application or part of a general rate case application, which allowed both the Commission and the Consumer Advocate more time to address the request for a temporary rate increase. Furthermore, to my knowledge, the Commission's rulings in past requests for temporary rate increases were generally binary, where the Commission either granted the entire amount or denied the entire amount. In this situation, rather than seeking to moderate its requested temporary increase to acknowledge the symbiosis between its customers and YB asked the Commission to consider adjustments to its base case so that even without a rate of return, its temporary increase is even larger than the increase requested in the base case. Rather than an all or nothing situation, though, again, I repeat, we have offered a different path.
So if the Commission, I guess, finds that that Young Brothers has satisfied its burden to establish probable entitlement and financial need based upon the information provided in the docket, should the Commission grant Young Brothers' request in its entirety or something other than that?
Let me object. This calls for legal conclusions.
We'll allow the question.
So my response would be that rather than simply proposing to deny YB's requested relief of an over 46% revenue increase, or I don't know, maybe it's 34, with some tariffs proposed to see an actual increase of 100%, we have offered something that would allow for some relief, still subject to refund, to address the stated problem, but would also be more bearable by customers than what YB argues is its entitlement. Mr. Brosh will be explaining the derivation of the proposed 9.6% increase that we offered in our response on pages 43 to 47, or the $5.7 million increase calculated on an intrastate percentage of revenues basis in the response that was offered to YBCA IR3 Attachment 1.
Thank you, Mr. Nishina. The witness is available for cross-examination.
Thank you,
Okay,
Mayor
thank you.
Katsi.
Yeah, please go ahead.
Mr. Nishina, have you been to Young Brothers recently?
I have not been to many places recently.
Well, in fact, have you been to Young Brothers over the last 2 years?
I can't remember the last time I was at Young Brothers. I do not believe I was there within the last 2 years.
Have you ever gone to Young Brothers for the purpose of gathering evidence that would be relevant to the jurisdictional split between interstate and intrastate services?
Mr. Chair, I'm going to object to that question. That seems to be outside the scope and a rate case question.
Mr. Owen, can you explain the relevance?
This is relevant to the development of the cost of service model.
Whether Dean has actually been down there?
Right. For the purpose of developing and gathering evidence relevant to the jurisdictional split between interstate and intrastate services.
Can you please rephrase?
Let me repeat the question. Mr. Nishina, have you ever gone to Young Brothers for the purpose of gathering evidence that would be relevant to the jurisdictional split between interstate and intrastate services?
And Mr. Chair, I still raise the same objection. I believe this is an issue that's more properly decided in the general rate case application, not specifically to this motion for emergency or temporary rate relief.
Agreed, sustained. If Mr. Owen, you can either rephrase or continue.
Let me ask another question. Mr. Nishina, have you ever interviewed any Young Brothers freight clerk to determine the amount of time Young Brothers freight clerks provide services to Young Brothers interstate versus intrastate business?
Again, Mr. Chair, I think it goes to the same question of jurisdictional allocations, and that larger matter is still a rate case issue.
Yeah, except for this, the consumer advocate, the cost of service model in the opposition. I believe this is fair game to inquire.
Okay, we'll allow the question.
Mr. Ono, I believe your questions are more appropriately directed to Mr. Brosh, who has conducted various interviews with different employees of Young Brothers, to which, when I was available, I often called in to listen to those interviews.
So the answer to my question, no, you have not interviewed any Young Brother freight clerk to determine the amount of time Young Brothers freight clerks provide services to Young Brothers interstate versus intrastate business.
Again, I'm still going to lodge the same objection that this is still a rate case issue. And the witness
So yeah, we'll allow it. He's rephrasing the question. We'll allow it.
I think I responded to your question already, Mr. Ono. I mean, if you want specifically, no, I personally have not interviewed a freight clerk. However, again, your question is more appropriately directed towards Mr. Brosh, who is the sponsor of the cost of service and rate design discussion.
So let me ask it this way then, and we can cut to the chase. Have you done anything, Mr. Nishina, to gather evidence for purposes of developing or criticizing the allocations in the Young Brothers cost of service model?
Have I personally gathered information? I have in the past, but that was with the Marsoft model.
You haven't done it with respect to the QSI model?
No, that's what I'm paying Mr. Brosh to do.
Or have you ever assigned any consumer advocate staff other than outside consultants for the specific purpose of developing evidence with respect to the allocation of activities between interstate and intrastate services?
Mr. Chair, I'm still going to renew my objection that this is still outside the scope, a general rate case matter. And moreover, I think that Mr. Nishina has already directed Mr. Ono to speak to Mr. Brosh about these things.
Well, Council, are you withdrawing the opposition on the cost of service model? You're saying it's irrelevant. You brought it up. I mean, the consumer advocate opened the door.
We'll allow the question. We'll give it the weight that it deserves. Let's keep in mind the issue before us today.
I'm sorry, Mr. Ono, would you care to restate your question?
I was asking if you ever assigned any staff for that purpose to develop evidence.
Again, since the last time the consumer advocate looked at the cost of service model that was submitted, that was with the Marsoft model, but since we've hired outside consultants to look at it, I specifically, or the division, has not used any in-house staff to look at the cost of service model.
You requested and obtained Young Brothers bank records and financial data.
I'm sorry?
Did you request and obtain Young Brothers bank records and financial data?
Could you point me to a specific IR?
Sitting here today, do you don't remember asking for Young Brothers bank records?
Sitting here today, I do not remember a specific information request for bank records. I know recently we have been asking for cash flow information to address Young Brothers' stated concern with its cash emergency.
Based on that cash flow information that you reviewed, have you come to a conclusion as to when Young Brothers runs out of cash and is forced to cease operations?
If I remember what Young Brothers had provided, one of the exhibits that it had provided on a total company basis suggested that at the end of July, the numbers could be negative.
Have you made an independent assessment of whether Young Brothers can avoid filing for bankruptcy protection if it does not receive any temporary and emergency rate relief?
I'm sorry, could you repeat your question?
Have you made an independent assessment of whether Young Brothers can avoid filing for bankruptcy protection if it does not receive any temporary emergency rate relief?
I'm gonna have to. Well, I don't know if it's my situation to object here, because I think you're asking me to speculate about whether or not Young Brothers would choose to seek bankruptcy relief. But as stated earlier, when we were provided information by Young Brothers that it was facing a cash emergency, we tried to analyze the situation to determine what type of need might be how that need might be appropriately addressed by a potential approach such as the one we laid out in our response using EBITDA, or earnings before income taxes, depreciation, and amortization. We have not analyzed bankruptcy, and again, I would have to speculate whether or not YB has been pursuing such an analysis.
Have you made an independent assessment of whether Young Brothers will remain a going concern if it does not receive any temporary emergency rate relief?
No, we were trying to focus on providing a solution to address the cash emergency.
As the consumer advocate, have you engaged in any scenario planning to determine what would happen in the event that Young Brothers runs out of cash?
Actually, that was one of the questions we were trying to ask Young Brothers to provide, because they possess the information, and we were trying to determine what type of planning Young Brothers has done to address the potential situation if different forms of either cash infusion, loans, rate relief are not made available. And to date, I think the information that we received from Young Brothers hasn't really been able to, or hasn't provided us sufficient information as to what those alternatives might be.
So is the answer to my question that no, you did not do any scenario planning to determine what would happen to Young Brothers in the event that Young Brothers runs out of cash?
I'm going to object. I believe the witness answered that question already.
No, he did not.
We'll allow the question.
We have attempted to analyze what the scenarios might be by asking Young Brothers to provide us information as to what might happen if they were not able to get various forms of solutions. And the consumer advocate has engaged with other state agencies to determine what paths might be taken if Young Brothers were no longer able to provide the services that they are expected to provide.
If Young Brothers ceased operations, are there sufficient tugs, barges, and other water transport assets to completely replace Young Brothers service lines, both interstate and intrastate?
I believe the answer to that question, it would depend, because one of the scenarios we're looking at was whether or not it would be appropriate for the commission to appoint a receivership for all of the assets that Young Brothers currently has. And if that occurred, then the assets that are currently used to provide the services would then be used for those same services.
Have you done any analysis to determine whether the state has sufficient tugs, barges, and other forms of water transport assets, excluding any of the Young Brothers assets, to completely replace Young Brothers service lines for both interstate and intrastate services?
I have not analyzed whether or not, if we assumed YB's assets were not available, whether the state has sufficient tugs, barges, or other assets.
Have you determined what would be worse for the state of Hawaii and its consumers, a $26.9 million rate increase or Young Brothers ceasing operation?
Mr. Chair, I'm going to object to that. Calls for speculation.
We'll allow the question.
Thank you.
That is one of the analyses that we are trying to do. And actually, I anticipate that that particular consideration may be part of what has been discussed earlier with respect to the working group, because I think I will readily acknowledge that Young Brothers, in terms of the inter-island shipping service, is a vital service, especially to the neighbor islands. I'm also concerned, however, as I mentioned earlier, if there is a 46% increase, or again, as proposed by Young Brothers in its rate design supplement, certain customers are going to receive 100% increases in the cost to ship things, that there will be businesses that fail. So I'm not sure how to weigh whether it's better to see all these small businesses fail or Young Brothers getting, or I'm sorry, without a doubt, we don't want Young Brothers to fail. And that's why we offered the alternative solution.
Thank you, Mr. Nishina. I have no further questions.
Okay, thank you. Commission Counsel.
I have no questions for this witness. Thank you.
Commissioner Asuncion.
I have no questions. Thanks.
Commissioner Potter.
I have no questions. Thank you.
Okay, I just have one question, Mr. Nishina. In your reply motion, Consumer Advocate also recommended a management audit for Young Brothers. Is that accurate?
Yes, that is correct.
Can you further explain why you think that may be necessary in this case?
To elaborate, I think the commission is most likely aware in the decision and order that it granted in the 2017-0363 case, as well as earlier in this docket, the commission had asked for a cost reduction plan, which the company had requested a delay on submitting. And the Consumer Advocate has similar concerns that perhaps Young Brothers hasn't been looking for other ways of trying to address the situation as opposed to just looking for a rate increase. So my hope, I would point to the management audit that was recently done for the Hawaiian Electric companies in terms of identifying means by which it could operate more efficiently and look for ways to reduce its costs while still providing the same services, rather than just presuming that either rates have to go up or services have to be pulled back in order for the company to continue to be a going concern.
Just one follow-up. Based on the testimony you've seen today, has it changed your mind or perspective on this? On that recommendation?
I'm sorry. Yeah, I didn't mean to speak over, but based on what I've heard today, that would still be one of our recommendations to the commission in terms of trying to help Young Brothers determine whether there are ways that it might be able to operate on a more efficient basis.
Okay, thank you. No further questions from the commission. Mr. Nishina, you're excused. Okay, I'm going to look. We want to take. We're in the very final stretches here. We have one more witness closing arguments, or do we want to take a very short break and then proceed forward? Okay, let's reconvene at 4:10.
That's fine.
Okay.
Okay.
We're in recess. Sorry, I was muted. It's like we're getting people coming back. We got another couple minutes. Okay, we're gonna go in about a minute. They've started the live stream, but I said 4:10, so we'll stick to 4:10.
Okay.
Okay. All right, we have the consumer, bring the back to order. We have the consumer advocate's second and final witness, Mr. Brosh. Can you please stand and identify yourself?
I'm Michael Brosh.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please proceed with the direct examination.
Sure. Mr. Brosh, good evening.
Good evening.
Would you please state your full name again and your occupation for the record and explain your role in these proceedings?
Yes, my name is Michael L. Brosh. I'm the president of Utilitech. My firm has been involved in several previous Young Brothers rate cases, and I testified in each of YB's last 2 rate cases. Utilitech has contracted with the consumer advocate to analyze and help respond to YB's pending general rate case and its emergency rate relief motion. I have been actively involved in the consumer advocate's review of the rate case since it was filed, and then shifted attention toward YB's emergency claims starting in May of this year. I assisted the consumer advocate's review of YB's motion for emergency or temporary rates and helped in preparing the consumer advocate's response to that motion. I have also reviewed the company's filed reply to the consumer advocate's response, assisted in preparing the CA's discovery on that reply, and in responding to YB's information request to the consumer advocate. I am appearing today to respond to questions about the consumer advocate's filed positions in areas involving rate-making policies, cost allocations, and financial calculations in connection with YB's request for emergency rate relief.
Thank you. Did you hear Mr. Martin's testimony earlier regarding cost allocation based on freight bills versus piece counts?
Yes, I did.
Did you have any comment on that?
I would say only that I would refer my reply to that to the consumer advocate's response to YBCAIR1, where at pages 4 through 8, there was a discussion of that single cost allocation factor issue. And note that to my knowledge, YB has no time and motion studies or other documentation to quantify differences in processing time or handling complexity between intrastate and interstate cargo.
Okay, thank you. On page 5 of Young Brothers' reply to the consumer advocate's response, YB states that, quote, the consumer advocate does not and cannot refute the fundamental point that Young Brothers faces a financial crisis that necessitates emergency rate relief, end quote. How would you respond to that statement?
I would simply observe that the urgency behind the alleged financial crisis appears to be self-imposed by Saltchuk in allegedly cutting off new cash liquidity when most needed by YB in this period of serious public health concerns and economic pressure. If YB had secure access to sufficient liquidity to pay its cash expenses that cannot be reduced or avoided until its pending rate case was completed, there would be no emergency and the rate relief actually needed by YB would be forthcoming at that time. It's difficult to imagine a worse regulatory precedent to establish than allowing the parent company of a utility to simply withhold financing in order to quickly leverage a pending rate case into an emergency rate increase that exceeds the prices initially requested by the utility.
Thank you. Also on page 5, Young Brothers avers that the Consumer Advocate's proposed solution, a rate increase of $8.6 million, is woefully insufficient. Is the Consumer Advocate's proposal woefully insufficient?
On this point, I would say the amount proposed by the Consumer Advocate was carefully tailored to be responsive to the information filed by YB regarding its cash flow needs. It is important to recognize that any cash flow emergency is company-wide and not limited to only YB's intrastate jurisdiction, and therefore any remedy must also be viewed on a total company basis. The Consumer Advocate's calculus accepted all of YB's estimates in its motion on a total company basis, removed depreciation expense that requires no cash payments, subtracted YB's own estimates of its ability to reduce expenses during the crisis, and the net amount of $8.6 million was converted into a surcharge percentage to be applied to YB's tariff. This approach recognizes how YB can and does charge its interstate connecting carriers prices that are tied to the same tariff rates that are set by the Commission.
Thank you. In its original motion, Young Brothers asserts an intrastate loss of about $30.4 million, but a total company loss that is less than about $28.8 million, because by YB's math, its interstate business is still profitable in spite of the economic downturn. Does that seem reasonable to you?
No, that result is clearly incredible, and it occurs purely as a result of the very aggressive changes to jurisdictional cost allocation methods the company is proposing in its filed case. The Consumer Advocate described in its response the large shifts in cost responsibility into the intrastate jurisdiction that the company's new COS model proposes. YB has invested a lot of resources in the development of a highly complex new YB BIP allocation model that promises to be vigorously contested in the rate case. The Consumer Advocate's response to CAIR1 explains some of the problems with that model. The good news is that to derive a cash flow response to YB's company-wide cash flow emergency, the Commission need not resolve cost allocation issues now, but it can instead fashion a result that will, under YB's existing service pricing procedures, produce rate and cash flow increases for YB in both jurisdictions.
Thank you. Also on page 5 of YB's response to the Consumer Advocate, it says that the Consumer Advocate is trying to, quote, impute revenues from interstate services that the Commission does not regulate, which it cannot consider in setting rates, end quote. How do you respond to that characterization and assertion?
On that point, it's important to understand what the Consumer Advocate is actually recommending. If the Commission finds the company is probably entitled to an emergency rate increase to cover its claimed cash flow needs, then we're not asking the PUC to change pricing to interstate customers, and we're not asking that any revenue be imputed. Instead, the Consumer Advocate is simply observing what will probably happen in the normal course of business. YB will be able to automatically increase interstate prices at parity with its intrastate tariff pursuant to its contracts and arrangements with connecting carriers. If the company and the Commission agree that YB's cash flow problems affect the entire company, this is the only way to quantify a remedy without creating an unintended revenue windfall that exceeds YB's cash flow needs.
Thank you. Young Brothers is requesting intrastate temporary rate relief of about $27 million. Based upon the amount set forth in a notice to customers in this docket, how would approving the company's request impact its cash flow?
If a 27 million increase to the tariff rates were approved, YB would actually charge its interstate customers higher rates tied to the public tariff increases, and then collect a multiple of the approved rate increase amount in new cash flow. Of course, it would matter what rate design is approved, and on this point, the consumer advocate suggests an across-the-board percentage increase for several reasons. First, the larger increases YB is proposing for certain cargo types is based upon cost calculations derived from the company's new COS model, which are disputed by the CA and which have not been reviewed or accepted by the Commission. Second, an equal percentage increase approach is commonly applied by the Commission in granting interim increases in electric utility cases, so that more detailed rate design issues can be taken up in final rate orders. Finally, given the size of YB's proposed rate increases of up to 100%, it's important to moderate customer impacts by more gradually implementing rate changes, which a percentage surcharge helps to do.
With respect to the overall dollar amount, Young Brothers asserts that it is probably entitled to $27 million. Do you agree with that?
In the absence of a completed rate case proceeding, it's nearly impossible to accurately determine probable entitlement for purposes of setting rates according to standard rate case principles. But for the purpose of setting emergency and temporary rates, the company is probably entitled to just enough to meet an identified emergency. Clearly, the company does not need as much as is requested because of the observed flaws in its COS model and how the company proposes to completely ignore cost savings that are being achieved in reaction to the very emergency that's driving the request for emergency rates. The company also does not need to collect depreciation if it is only paying essential cash costs, because the company does not disperse any cash or write any check to pay depreciation. I will say that in response to YBCAIR3, the consumer advocate has developed an alternative calculation with simplified jurisdictional allocations that the Commission may find indicative of probable entitlement if it finds an emergency rate increase to be justified.
On page 30 of Young Brothers' reply, it expresses concern over what it calls further delay that may result from the Commission defining a path for completion of the general rate case. How would you respond to that concern?
I would observe that the company's injection of an emergency rate request, asserting a cash flow emergency this past May, was the impetus for redirection of consumer advocate resources away from the rate case and towards responding to the emergency. It is simply not possible to complete the general rate case unless and until we know what approach will be taken, as outlined in the consumer advocate's response to YB's motion. There are options to be considered. We can restart work, put on blinders, ignoring all of the operational and financial changes caused by COVID impacts, and then file testimony that may not reflect the reality of ongoing conditions or meet anyone's needs. Alternatively, we can have YB file new evidence with new adjustments and sales forecasts that it believes accurately reflect future conditions, providing a new window of discovery on those changes, and then establish modified dates to complete the 2020 rate case. As a third option, the Commission could dismiss the 2020 test year case and invite YB to file a new rate case when changes to sailing schedules, operational adjustments have been made, and more is known about future ongoing business conditions. In any event, some formal review is required to carefully consider the company's changing revenue requirements and to reconcile any emergency rates that may be awarded now.
Thank you, Mr. Brosh. Chair, the witness is available for cross-examination.
Thank you, Mr. Knox. We'll start with the cross-examination now.
If the Commission orders a return to the full sailing schedule pre-COVID, the $8.6 million amount that you're suggesting would be inadequate to meet operating expenses. Isn't that right?
if we hold all else constant, then the savings associated with the reduced sailing schedule would not be realizable. That's correct.
And you included in arriving at that $8.6 million figure, certain cost savings, including wharfage fees due to the state of Hawaii. Isn't that right?
That's right. I included all of the cost savings that the company had quantified and elected to not include in its request. Savings that were associated with cash flow deferrals, expense reductions, negotiated vendor discounts, and sailing schedule reductions, among others.
And that wharfage fee that's owed to the state, that can only be deferred. That amount is still due and owing. Isn't that right?
I'm not certain what the terms are associated with that.
Are there any other cost savings items that you have identified that are just deferrals and are not and are still due and owing?
Perhaps. Certainly, the company argues that all of its quantified cost savings are not sustainable in the long term. I would like to believe that the COVID situation is also a transitory concern that will pass with time. And the consumer advocate's perspective on this is, let's not just count the bad news, let's count the offsets as well and not burden customers with all of the lost margins and none of the cost savings.
Well, we all wish this COVID pandemic would be transitory and leave us quickly. But Mr. Brosh, you've been to Young Brothers on several occasions, isn't that right?
I have, yes.
About how many times have you been there?
I don't know, perhaps 8, 10 over several years.
Right, you've been on at least 2 tours conducted by Young Brothers for the PUC and the Consumer Advocate. Remember that?
I do. I think we looked at the new boat together.
That's right. And you've been to Young Brothers as part of the discovery process to conduct follow-up interviews of Young Brothers personnel as part of the discovery process. Isn't that right?
Yes, in this case and prior cases. And there have also been a series of telephonic interviews, and I imposed on Mr. Starkey at his home to talk about the COS model. So yes, there's been some discussion.
Have you ever interviewed a freight clerk to discuss the
objection, Chair? And this is a different objection.
My question, please.
Is it not the same question as last time?
Can I ask the question?
Let's let him finish the question, Mr. Knox.
Have you ever interviewed a freight clerk to discuss the nature of the work that freight clerks perform for interstate versus intrastate customers?
Objection, Chair, and for different reasons than before. This is more prejudicial than probative. The issue about the allocations is not irrelevant necessarily, but the way that council is getting at this gives a false impression of what Mr. Brosh could be doing or should be doing. Mr. Brosh extensively interviewed the witnesses provided by the company. If they wanted to make freight clerks available, they could have. It's disingenuous for them to now say that Mr. Brosh, or to imply that Mr. Brosh may have been doing an insufficient job in some way.
We'll allow the witness to answer.
Yeah, let me just say something, because this is very improper. Council should not be allowed to argue. You should make your objections and the grounds for the objection. Mr. Knox, you know better.
Mr. Ono, we're allowing the question. Please go, Mr. Brosh.
I discussed shoreside operations with Mr. Martin with the understanding that he supervised freight clerks and documentation personnel, as well as other shoreside employees. There were people involved in some of those interviews. I'm not certain if any of them were freight clerks, but I came to my understanding of the processes involved, from documents, procedural manuals, copies of documentation, and other materials provided in response to discovery after discussing processes with Mr. Martin.
You ever interviewed any Young Brothers employee who was responsible for customer billing?
Same objection.
I assume.
We'll allow the question.
I assume that the supervisory people who I spoke with have some level of responsibility for those functions. I don't know if I ever spoke directly to anyone doing the billing at YB.
Have you ever interviewed a customer service employee to determine the work activities of a customer service clerk for interstate versus intrastate customers?
I would have the same response. I requested job descriptions. I spoke with Mr. Martin. I spoke with Mr. Starkey. I asked for documents. There are flowcharts in the discovery of all the procedures. There were follow-up questions submitted asking what differences existed, if any, between interstate and intrastate. There's a lot of documentation here. I don't recall if any of the people I actually spoke with had the job functions that you are asking me about. I trusted the job descriptions were accurate and complete.
Have you ever interviewed a stevedore to determine the work the stevedores perform in consolidation activities for interstate versus intrastate customers?
That's on the record.
I have the same response.
Allow the question.
Excuse me. I have the same response. I spoke to supervisory people. I read the cost allocation manual. I conducted discovery. I looked at job descriptions. As to distinctions between jurisdictions, no, I don't recall asking that specific question of a stevedore.
And further, thank you.
Okay, thank you, Mr. Ono. Commission counsel.
I don't have any questions for this witness, Chair.
Thank you. Commissioner Asuncion.
Yes, Chair, and it's just clarification. Mr. Brosh, Mr. Ono just took you through a cross-examination, and more for me, can you give me the context? Right, certainly it looks like you went down to YB, talked with some people, supervisory, if you will, but like, what was the time period on that? Is it, and right, like, is it 5 years ago, a couple years ago?
My involvement was in the last two of the company's rate cases. And in connection with the first case, there was a Marsoft cost of service model involved, and there were on-site interviews of the sponsoring witness for that model and the company's supervisory people to explain how it worked and from the company's perspective, why it was reasonable for the allocation of costs between jurisdictions. In the most recent case we completed, the company had Mr. Starkey sponsor the results of the Marsoft model, claiming that it was representative and reasonable for use in that case, while also admitting that there was consideration with Young Brothers to create an improved model because of the deficiencies he spoke of earlier with you today. Since the last rate case was completed, the YB BIP model was near completion, and Young Brothers offered to share that model and its logic with the consumer advocate. And I participated in at least one, maybe two presentation discussions before the company filed its most recent rate case this past fall. And then the more serious examination of the model commenced when it was part of the record in the pending rate case.
Okay, and when you refer to the YB model, that's the OSI, the more recent model.
Yes, they call it YB BIP, BIP, I think. Okay. Yeah. And I heard Mr. Starkey refer to it as the QSI model, the name of QSI. Yes.
Yeah. Thank you, Mr. Brosh. That's all I have, Chair.
Thank you, Commissioner. Commissioner Potter.
Thank you, Chair. I have no questions for this witness.
All have no questions for the witness either. Thank you, Mr. Brosh. You're excused. Have a good evening and a good weekend.
Thank you.
That concludes all of the witnesses. We'll now move into closing arguments, starting with the consumer advocate. Just as a reminder, each will have 10 minutes, and we will give you the 5 and 1 minute warnings. Who will be providing closing arguments for the consumer advocate?
Mr. Chair, that would be me.
Okay. Proceed when you're ready.
Okay. Thank you, Mr. Chair. Mr. Chair, Commissioner Potter, Commissioner Asuncion, staff of the commission, also to the staff and counsel for Young Brothers LLC and those who watch this proceeding from afar today. Thank you for your time and patience as the consumer advocate made its presentation under the challenging circumstances that we find ourselves in right now. Let me say first off, there are many aspects of this proceeding that are highly irregular and perhaps in any other time would be the subject of further commission investigation and scrutiny. Were this a normal situation? It is not. This is not a normal situation. We as a community find ourselves in a circumstance where the world, including Hawaii, is struggling with the pandemic known as COVID-19 right now. For Hawaii and parts of the world and nation, the life force of the community has been shut down, and for some, those parts of the community may never reopen again. As observed by the consumer advocate in its filings submitted on July 23, 2020 in the docket, there are several aspects of the Young Brothers motion that deserve further attention by the commission at this time. These aspects include procedural deficiencies within Young Brothers filings that threaten the very process of notice for the general public and Young Brothers customers and ratepayers alike, and the commission and the consumer advocate's ability to review Young Brothers' application for a general rate increase in a manner that respects the commission and consumer advocate's limited staff and resources at this time and enables both the commission and consumer advocate to balance the competing interests of Young Brothers against its customers and ratepayers fairly and reasonably in an affordable, efficient, and effective manner. In its motion and reply, Young Brothers presents several points to try to demonstrate that the consumer advocate's response is erroneous and utilizes a set of processes and regulatory adjustments that are, in the words of Young Brothers, irregular and not permitted by the generally accepted regulatory and rate-making principles that Young Brothers believes should apply to the determination of its motion in the docket. YB contends that the approach of the consumer advocate denies Young Brothers the relief it is entitled to in the docket and prevents Young Brothers from receiving the opportunity to earn a just and reasonable rate of return on its investments in the proceeding. While the consumer advocate might be willing to agree that Young Brothers' motion demonstrates that it meets the elements of probable entitlement as that concept is described in the Commission's previous decision and orders, such as decision in order number 10850, filed in docket number 6399 on November 16, 1990, decision in order number 14151, filed in docket number 94-0365 on August 22, 1995, and order 21354, filed in docket number 03-0369 on September 17, 2004, as well as HRS sections 271G-17, subsection E, and 269-16, subsection C. The consumer advocate contends that Young Brothers still fails to demonstrate, indeed, to sustain its burden of proving the element of financial need in its motion because Young Brothers fails to present evidence that demonstrates an extraordinary circumstance exists in this situation, such that Young Brothers should have its motion granted by the Commission in its entirety in the docket. As the Commission has pointed out to parties that have filed for emergency or temporary rate relief in the past, the grant of emergency or temporary rate relief is an extraordinary remedy that requires the Commission to assess the elements of probable entitlement and financial need as those elements are presented for the Commission to review in a docket. As Young Brothers presents its case for the Commission's review and determination in this proceeding, Young Brothers has stated on the element of financial need in its review that, and I am paraphrasing here, the discussion of financial need does not depend on the financial ability of Saltchuk Resources Incorporated, Young Brothers' parent and owner since 1999 in this instance, because according to Young Brothers' perspective in this docket, it is the responsibility of the Commission, the Consumer Advocate, and Young Brothers customers and ratepayers to establish and present the conditions on which Saltchuk will be induced to invest additional capital in Young Brothers as those principles have been laid out and applied according to generally accepted regulatory and rate-making principles recognized and used by the Commission in the state. According to Young Brothers, Saltchuk asserts that it has provided sufficient financial resources to Young Brothers in the past, and this provision of financial resources enabled Young Brothers, for example, to finance the acquisition of 4 new tugs and continue with Young Brothers operations despite incurring financial losses in the recent past. Young Brothers appears to believe that this financial support gives Saltchuk the ability to unilaterally decide for themselves to restrict Young Brothers' support it receives from Saltchuk until such time that the conditions allow for Saltchuk to earn a sufficient return from Young Brothers in the future. The Consumer Advocate disagrees vehemently with Young Brothers on this point in the docket. The Consumer Advocate states that this interpretation of financial need misunderstands the concept of financial need as that concept has been described by the Commission in the past. The Consumer Advocate encourages the Commission to review such decision and orders referenced by the Consumer Advocate above and asks the Commission to require an owner of a public utility to continue to support its utility despite the situation that the utility may find itself in the future. Failure to do so would establish an undesirable precedent for the Commission to apply in the years ahead, and this may haunt the Commission for years to come as owners of the state's public utilities decide to restrict resources from public utilities they own in the future. Notwithstanding anything presented by the Consumer Advocate above, the Consumer Advocate does recognize that Young Brothers continues to provide a vital service that links many people from across the state, especially those who live on Kauai, Maui, Molokai, Lanai, and the Big Island at this time. If the Commission is so inclined, the Consumer Advocate offers that the Commission could adopt several of the solutions presented to the Commission for consideration found in the Consumer Advocate's response and the Consumer Advocate's responses to Young Brothers' information requests, for example. These proposals attempt to balance Young Brothers' need to continue to operate as a business that can pay its bills and provide service to its customers against acknowledging there are many remaining issues, questions, and concerns that still need to be addressed with respect to Young Brothers' general rate case application filed in this docket. The Consumer Advocate has offered alternatives in its response and responses to Young Brothers' information requests, and the Consumer Advocate believes that these offered alternatives could address some of the strain faced by Young Brothers at this time. The Consumer Advocate asked the Commission to consider the 3 options for rate case completion described on pages 41 and 42 of the Consumer Advocate's response filed in the docket, and requests that the Commission provide further guidance so that the parties can address Young Brothers' rate case application efficiently and effectively in the future. The Consumer Advocate looks forward to supporting the Commission in addressing Young Brothers' application for a general rate increase appropriately as time moves on, and the Consumer Advocate asks that the Commission review Young Brothers' motion with a skeptical eye because there are many aspects of Young Brothers' motion that touch upon rate case application matters that the Consumer Advocate has not had a chance to fully consider and develop its position on at this time. Thank you for the opportunity to provide the Consumer Advocate's perspective on this matter, and the Consumer Advocate looks forward to assisting the Commission on resolving this docket in the future. Thank you.
Thank you, Mr. Tsuchiyama. Now turning to Young Brothers. Mr. Ono, you'll be doing the closing argument. Please proceed when you're ready. Oh, Mr. Ono, you're on mute.
Got it.
Okay.
May it please this Honorable Commission. Chair Griffin, Commissioner Potter, Commissioner Asuncion. On behalf of Young Brothers, I want to thank the Commission for giving us this opportunity to be heard and to present further support for our motion for temporary and emergency rate relief. I have 10 minutes and much to cover. I can't cover it all, so if you don't hear an argument from me, it's not that we're giving up on it. It's because we rest on those arguments we raised in our motion and reply. So let's get to the issues. Probable entitlement and financial need. Well, I want to start with the second one first, financial need. The Kapalua Water and Lanai Water decisions are instructive in this regard. A utility seeking temporary rate relief must show an urgent financial need. There must be a showing of irreparable harm from a distinctive and sudden deficiency. That burden has been met. There is no dispute that the COVID-19 pandemic has and will erode Young Brothers' cargo volumes now and into the future. The consumer advocate hasn't questioned the revenue decrease forecast. The consumer advocate hasn't questioned the cause and effect of the pandemic on Young Brothers' sudden and steep decline in cargo volumes. As a general rule, these losses are not recoverable in rates. That's the irreparable harm suffered by Young Brothers. Instead, the consumer advocate claims there is no financial need, that Saltchuk, Young Brothers' parent, should be hailed before the Commission and forced to continue to fund Young Brothers' losses. Now let's consider the consumer advocate's claim for a moment. The pandemic hit the state of Washington and Saltchuk before it hit Hawaii. Now, as soon as Governor Ige shut our state down in the third week of March, Young Brothers' volumes immediately fell off a cliff. We've provided ample evidence of this in this docket and in the emergency investigative docket. It was at the end of May, after 2 months of one of the steepest declines in cargo volumes Young Brothers has ever faced over such a prolonged period of time, that Saltchuk ceased funding Young Brothers' losses. Is this an irresponsible owner that is not committed to the state of Hawaii? Let's not forget that Saltchuk just invested $80 million in Young Brothers for the 4 Kapena tugs that were just delivered in 2018 and 2019. Saltchuk has proven its commitment to Hawaii over the last 20 years since it purchased Young Brothers. In the dockets in which the Commission looked back at the parent and determined that the parent should provide emergency financial relief, for example, Lanai Water and the East Honolulu Community Services dockets, there was no worldwide pandemic that caused the loss in those dockets. There was no state economic crisis that caused the parent companies of Lanai Water and East Honolulu Community Service to cease funding those operating losses the way Saltchuk has been prior to saying it can't keep doing this. There is nothing in the law that says that a parent company must continue to fund these losses in this economic crisis. There is nothing in the law that gives the Commission jurisdiction over Saltchuk to hail Saltchuk before this Commission and force it to continue funding Young Brothers throughout this financial crisis that is predicted to plague us for years to come. Young Brothers has satisfied the burden of proving financial need. Let's move on to probable entitlement. What does that mean? We look again to Commission decisions to see how it's been decided. We look to Chapter 269. In the Lanai Water decision in 1995, the Commission stated the following: the standard in showing probable entitlement for a temporary rate increase under HRS 269-16C is less strict than the standard in showing probable entitlement for an interim rate increase under 269-16D. Interim relief under 269 requires the completion of discovery and the completion of the contested case hearing, but temporary relief does not. The Commission was clear in those prior dockets. We don't need to try every issue as you would need to for interim relief under Chapter 269 or final relief under 271G. That's the key, because the CA is here saying he has issues with our underlying general rate case, so you need to deny Young Brothers' motion so that the issues in the underlying general rate case can be fully litigated. Well, that's ridiculous. If that were the case, then there would never be temporary rate relief, and it would always be at the whim of the consumer advocate, because the consumer advocate can always claim to have issues with a utility's underlying rate case. The Commission should not deny this motion on the basis that the CA the consumer advocate claims that the underlying rate case needs to be fully litigated. That's not how probable entitlement is defined. In Lanai Water, probable entitlement was satisfied by a showing that the utility had suffered 2 straight years of net operating losses and was forecasting another year of net losses. In Young Brothers' case, we have demonstrated 2 years of net losses, and we are forecasting a 2020 test year with even deeper losses caused by the pandemic. The filing of the general rate case, including all of the discovery, coupled with the proof of Young Brothers' losses, satisfies the probable entitlement standard. We have proven with credible evidence of the steep decline in cargo volumes, with very little ability to reduce labor costs, which are largely fixed. We have shown in Exhibit A to this motion the erosion of Young Brothers' financial stability and proof of the need for the $27 million increase. The evidence supports probable entitlement. Now, having satisfied the probable entitlement and financial need standard, the question is, how much? What amount of an increase is just and reasonable? Once again, the consumer advocate seeks to fully litigate an issue. In this instance, it's the cost of service model. How does the commission determine a rate increase when the cost of service model is not fully resolved? Again, a request for temporary rate relief does not require resolution of all issues in the underlying general rate case. So how does the commission deal with the cost of service model that the consumer advocate is objecting to? The law dictates that once Young Brothers fulfills its obligation to prove probable entitlement and financial need in setting the needed rate increase, the commission should then adopt the utility's position without litigating the consumer advocate's adjustments, with the idea that the rate increase is temporary in nature and the issues surrounding the cost of service model will be fully litigated as part of the underlying general rate case. That's the appropriate time to make adjustments to the model. Another way you might be looking at this is by asking whether Young Brothers has proven that it is probably entitled to use the QSI model. Now, I don't believe this is the correct way to view it, but if you are, consider the evidence that's already before the commission on the QSI model. No, we did not fully address each of the consumer advocates' adjustments to the model, not because we agree, because if we did that, then we get sucked into the trap of having to fully litigate all issues in this request for temporary rate relief. You heard from us on only one of those adjustments, the biggest one, the $4.4 million cost shift from intrastate to interstate that the consumer advocate is arguing for. Now, in considering the evidence, the commission has to look at the credibility of Mike Starkey and Mike Brosh. Now, I'm not saying to consider who is more qualified or whether one Mike sounds more believable than the other Mike. I'm saying consider the work put in by QSI to develop that model, the hours of interviews with YB personnel, the hours spent observing and noting the work activities of various employees. Compare that to the handful of hours Mr. Brosh spent interviewing a handful of supervisors. If that isn't enough, you had a chance to consider Chris Martin's testimony. Who is in a better position to determine what is the best proxy for allocating expenses for shoreside labor of consolidation, documentation, billing, and customer service? It's Chris Martin, and he explained to you why it's freight bills, not piece counts. By taking this one adjustment and proving that QSI's proxy is far more appropriate than the one raised by the consumer advocate, I was hoping to convey to you that there is strength in this model. We refuse to accept the consumer advocate's adjustments to the model, not because of the amount of expenses it shifts away from intrastate, but because the consumer advocate's adjustment is not based in fact and reality. By refuting the consumer advocate's $4.4 million adjustment, we have produced credible evidence that the consumer advocate's adjustment does not have merit. The law says that we cannot be litigating the entire validity of the cost of service model. Therefore, the evidence that we provided to you on the $4.4 million adjustment is enough to tip the scales of justice in favor of adopting the QSI model for purposes of this motion. Chair Griffin, Commissioner Potter, Commissioner Asuncion. Young Brothers has been everywhere looking for financial help. We've been to the banks.
Please summarize your time. Your time is up.
I'm almost done. We've been to the legislature, the governor, Department of Transportation, county mayors. There is no money out there for Young Brothers. This is the last place we want to come to for assistance because we know what this means to our customers. There is no profit, no rate of return in our request to help mitigate the impact of customers.
Mr. Ono, that's over 10 minutes.
I'm done. I just ask that you grant the motion. Thank you.
Okay. We appreciate everyone's time today. Thank you for your efforts. We appreciate your participation. Commission is going to take all of this under consideration, and we'll be issuing our decision shortly. Thank you. Everyone have a good weekend.
Thank you.
Thank you.
Thank you, Chair.